Morning. Today's date is April 15, 2013. This is our motor vehicle legal report. We have present Commissioner John Clayton, Commissioner Donnie Hatchett, and Commissioner Don Parr. And also we have present Director Stribling, our attorney, Anthony Glendorf, our staff, Leslie Holt. We do have Bob Weaver in the audience, and staff member Jason Gilliam. We're prepared to get started with our legal report. So with that said and done, we're going to turn over to the attorney.
Morning.
Morning.
Before I begin, does anybody have any questions that they would like to ask me before we start? If not, we'll just take them up as we go then. This is the April 15, 2013 Motor Vehicle Commission legal report submitted to you all from the legal division. I'll start out. We should all have the same numbering on the side. I'll generally call out the number on the left-hand side, number 1, and then I'll indicate the case number, and then I'll read through the case. The first one, case number 2012023291. Here, the complainant consumer alleged that a respondent dealer engaged in unethical practices in the process of repossessing a motor vehicle. Respondent denied such, indicating that the vehicle payments were in default. The complainant purchased the vehicle and traveled out of state for several months without first obtaining an emissions test for the registration of the vehicle. The complainant stated that she agreed to the repossession of the vehicle in lieu of foregoing any further payments. As such, recommend this to close this complaint with no violation. Number 2 is case number 2012023551. Here, the complainant consumer alleged misrepresentation and deceptive acts during the purchase of a vehicle from a respondent dealer. The complainant alleged that after purchase, the vehicle had mechanical difficulties that were not corrected by the respondent. The vehicle was purchased as is with no warranties implied. The complainant further alleged that the vehicle was financed by providing false information to the financing company regarding a cash down payment. The bill of sale signed by both parties indicates a cash payment contradicting the complainant's claim, which could not be substantiated at that point. Therefore, I recommend close this with no violation, being found the vehicle was purchased as is. Number 3, case number 2012025751. Here, the respondent dealer was issued an agreed citation for failure to post the city and county business licenses as required. Respondent also failed to respond or to pay the agreed citation that was sent to him. Our recommendation would be an authorization for a civil penalty in the amount of $500, which would be generally $250 per non-license posted, to be settled by the consent order or a formal hearing. Number 4, case number 2011030821. Here, the complainant consumer alleged respondent dealer failed to provide title to a vehicle sold and had the respondent dealer arrested for fraudulent transfer of title. This case was dismissed after the respondent complied with the district attorney's office in transferring the title. I recommend to close this with a letter of warning. There was no any other information, documentation regarding the inability to obtain title other than the dates indicated that when he made the complaint to the district attorney's office, 60 days had not yet passed, and it appears that he did get the title. The next one is next to your left-hand side on the case number. Do you just have what appears to be a pound sign? Okay, I'll make that notation there to correct that then. That would be case number 2012013061. Here, the respondent is an out-of-state dealer, purchased a vehicle at an auto auction and sold it to an individual in Tennessee by endorsing the back of the title as a dealer. The consumer attempted to title the vehicle without rebuilt documentation when he was informed by the county clerk's office that the dealer was not licensed in the state. The respondent appears to have engaged in unlicensed activity by doing so. Recommendation would be the authorization for a civil penalty amount of $500 to be settled by consent order or formal hearing. Next is case number 5, 2012025151. Here, the complaint consumer alleged that the respondent dealer failed to deliver title and provided 4 temporary tags after the sale of the vehicle. An investigation was conducted and found the respondent failed to respond to the Commission's request for response on the complaint. The respondent provided 4 temporary tags to the complainant, and after failure to obtain title, the respondent bought back the vehicle and put the complainant in another vehicle to his satisfaction. Here, I'd recommend an authorization for a civil penalty in an amount of $1,250 that being $1,000 for the issuance of two more temporary tags than allowed by law, and $250 for his failure to respond, to be settled by consent order and formal hearing. Number 6, case number 20120200851. Here, the respondent consumer alleged that the complainant alleged that the responding dealer failed to indicate that a vehicle to be purchased had a rebuilt branded title. Investigation was conducted. The complainant was uncooperative during the investigation. However, the investigator did find that the respondent's temporary tag log did not accurately reflect the issuance of temp tags. Therefore, I recommend authorization for a civil penalty in an amount of $1,000 for the respondent's failure to properly maintain its temporary tag log, to be settled by a consent order or formal hearing. Number 7, case number 20100031151. Here, an internal complaint was opened against the respondent dealer for criminal allegations that the owner was indicted for bribing a public official. I believe this was in Shelby County. The employees of the county clerk's office were the ones allegedly being bribed to process titles. We took this case and we put it on a monitoring status, and it was in a monitoring status for 2 years, trying to determine what the allegations came to. As of I believe 2 months ago, there's no record of the criminal judgment. The individual indicated here doesn't hold a motor vehicle dealer salesperson's license. So, after actually going through the process for 2 years, the entire criminal docket has been does not have any record of this person having been found guilty of anything. And that will happen from time to time. I could tell you other reasons why, but I'm not sure. It doesn't indicate exactly what did happen, other than the fact that there was no finding of guilt on this person. So I would recommend that we close this with no violation. There was no judgment after the indictment to be found. All right, case number 20120226661. Here, the complaint consumer alleged that the respondent dealer sold her a vehicle that was previously salvaged without disclosing such, that he provided her with more than 2 temporary tags. The complainant also indicated that she paid $1,000 cash, which was not reflected on the bill of sale. The complainant eventually returned the vehicle to the respondent. Investigation was conducted. The investigator found that 4 temporary tags were issued to the complainant. The investigator also found that the vehicle sold to the complainant had a salvage title, and the respondent had not yet applied for a rebuilt title. The respondent indicated that he knew he could not obtain a title at the time of sale to the complainant. The respondent allowed the complainant also to drive the vehicle off of his lot on the road with a temporary tag, though the vehicle, since it had a salvage title, could not illegally obtain registration for road usage until it had been rebuilt. This respondent actually indicated he admitted that he actually sold him a salvage vehicle and did not think that there was anything wrong with doing so. The fact that she didn't actually know that the vehicle currently had a salvage title was a very difficult issue for her, given the fact that she could not obtain a rebuilt vehicle title since she was not the person who actually rebuilt the vehicle. The Department of Revenue wouldn't allow that. So the dealer had to go back and do what he originally should have done, which was to obtain that rebuilt title prior to the sale. As such, I recommend an authorization for a civil penalty in the amount of $3,000, $2,000 for the deceptive act of selling a salvage vehicle without being rebuilt, and allowing the complainant to drive the vehicle off the lot on the road with temporary tags, and further for a $1,000 civil penalty for the complainant having issued more temporary tags than you would have been allowed by law for any vehicle, to be settled by a consent order or a formal hearing. Number 9, case number 20120219141. Here, the complainant consumer alleged that he purchased an Infiniti motor vehicle from the respondent dealer, which was to be repaired by the dealer, and the dealer put them in a temporary vehicle, put them in temporarily until the vehicle was repaired. The complainant indicated that he signed a bill of sale, but did not realize that the bill of sale was for a different vehicle, an Aurora, and he believes that it should have been for the Infiniti. The complainant states that the respondent deceived him into purchasing the Aurora, which is what the bill of sale indicated. There was an investigation that was conducted. The respondent indicated that he sold the complainant that, Yes. Say again?
I was just repeating.
Oh, excuse me. The respondent indicated that he had told the complainant that the Infiniti could be had if they purchased the Aurora and made 6 months payments on time to the respondent, financing the vehicle by its own lot and the complainant's lack of credit. So here the complainant believed that they were putting in one vehicle, that they were buying a certain vehicle, and the bill of sale was for a different vehicle. The bill of sale was on the vehicle that they actually had driven, that they actually drove off the lot. The complainant said it was their belief that that was a temporary vehicle that they were going to be put into while the actual vehicle they wanted to purchase was being fixed to be sold to them. And the dealer indicated, no, I indicated to you that this is the vehicle you're buying. If you make 6 months payments on this vehicle on time, since I'm financing through my lot, I will, if you make your payments on time, I'll let you trade in this vehicle and take further financing for this Infiniti that you really want. So regardless, the bill of sale indicated that the vehicle she drove off the lot with is the vehicle that was purchased. Therefore, I recommend to close this complaint with insufficient evidence of any violation. The bill of sale signed by the complainant indicated that the vehicle sold was the Aurora. Number 10, case number 20120260021. Here the complainant consumer alleged that the respondent dealer failed to provide title to a vehicle purchased. Respondent replied indicating that it was attempting to obtain a title from a dealership in California. The respondent provided proof of doing so. The surety bond information was already sent to the complainant. I recommend that we close this. Respondent is attempting to provide the title to the complainant. Surety bond was sent. Information was sent. Should not be an issue with this. Number 11, case number 20120222701. Here the complainant dealer alleged that the respondent, who is a non-dealer and is a tire shop, was conducting unlicensed activity. Investigation was conducted. No evidence of unlicensed activity at the respondent's location was found by the investigator. I recommend that we close this with insufficient evidence of unlicensed activity. Number 12, case number 20130000471. Here the complainant consumer alleged that respondent dealer sold her a motor vehicle which subsequent to the purchase had mechanical failures. Prior to the purchase, the complainant had test drove the vehicle with a personal mechanic. Vehicle was sold as is. I recommend we close this complaint with no violation being found. Vehicle was sold as is and the complainant test drove the vehicle. Number 13, case number 20110300961. Here an internal complaint was opened against the respondent salesperson for allegedly lying on a salesperson application that he had not been convicted of a felony. The respondent was convicted of multiple counts of theft of property over $10,000, which were Class C felonies. Upon investigation, the motor vehicle dealer employer actually terminated the respondent. As such, the respondent no longer holds a license as a motor vehicle salesperson. Also, the respondent is planning not to renew their salesperson license. I recommend that we close and flag the respondent has terminated the salesperson and he's not in the industry anymore. Number 14, case number 20130016111. Here the complainant consumer alleged that after purchase of a vehicle from the respondent dealer, the vehicle had mechanical difficulties and would not pass emissions. At the time of purchase, the vehicle was 13 years old with 256,000 miles. Sold as is. I recommend we close this complaint. No violation being found. The vehicle was purchased as is. 15, case number 20120232221. Here the complainant consumer alleged that the respondent dealer failed to provide a duplicate title for a vehicle purchased. The vehicle respondent stated that the complainant was given a duplicate title, and later the complainant indicated that he had accidentally destroyed the duplicate title and requested another through the dealer. When our investigator went out there, the respondent said, here is the duplicate title that I have obtained for the complainant. I indicated to him that if he wants it, he is going to have to pay for my costs of obtaining it before he would send it to him. So I recommend we close this with no violation being found. The respondent is waiting the complainant to pay for the second duplicate title. Number 16, case number 201300161. Here the complainant consumer alleged that the respondent dealer failed to provide title registration. The vehicle was purchased in September of 2012. The respondent indicated there was confusion in processing the title. They overnighted a power of attorney to the complainant, which the respondent has received in order to obtain title for the complainant. I recommend that we close this complaint with no violation being found. The complainant forwarded the power of attorney to the respondent for processing registration. Number 17, case number 20130011131. Here the complainant consumer alleged that the respondent dealer advertised a motor vehicle as new without disclosing that the vehicle had 5,800 miles upon it and had been used for demonstration purposes. The complainant alleges that he found the vehicle had 5,800 miles on it when viewing it at the dealership. The complainant did not purchase the vehicle. The respondent stated that the advertising the vehicle as new was a mistake on their part, and they corrected such. I recommend that we close this with a letter of warning indicating that demo vehicles cannot be advertised as new or sold. Number 18, Case number 201202638. Here, the complainant consumer alleged that the respondent dealer sold him a vehicle representing 94,000 miles on it after knowingly purchasing the vehicle at auction announced as true miles out unknown without disclosing such to the complainant. Those were the allegations. 5 months after the purchase of the vehicle, the complainant ran a vehicle history which indicated that the vehicle was previously reported with over 240,000 miles. An investigation was conducted, and what they found was that the respondent, who was the dealer, he purchased the vehicle at auction with approximately 94,000 miles, and at the auction it was announced as true mileage unknown. The documentation from the deal file indicated that the odometer disclosure to the complainant indicated that 94,000 miles was checked with also a discrepancy of mileage. Similarly, the vehicle title that we received from Indiana indicated the mileage discrepancy, and the title itself was branded as an odometer discrepancy, the actual title. The respondent indicated that he informed the complainant of such. The complainant states that he was not. The only evidence of such communication is the odometer disclosure form, which indicated the discrepancy, which was signed by the complainant. And from our understanding and research, we found that this vehicle was, whatever its discrepancy with its mileage, with its odometer, came out of the state of Indiana. It was not done by this actual dealer. Could not have been, since he bought it with 94,000 miles on it. Number 19, case number 20120265531. Here, the complainant consumer alleged that the respondent dealer sold her a vehicle but failed to deliver title, and that the respondent sold her a 90-day warranty without that he would not honor the warranty. An investigation was conducted, which found that the vehicle in question was repossessed after the complainant claimed bankruptcy. Further, the respondent provided complainant a rental loaner vehicle, but a sale was never conducted. The complainant later returned that vehicle. A 90-day warranty could not be determined by any of the documentations gathered in the deal file. However, during the investigation, the investigator found that the respondent had provided 3 temporary tags to a previous customer of the same vehicle in question. Therefore, I recommend an authorization for a civil penalty in an amount of $500 to be settled by consent order or formal hearing. Number 20 has 2 respondents, case number 201201935 and 201201935. Here, the Memphis City Police Department submitted a complaint regarding improper use of a temporary tag that was on a motor vehicle that they actually pulled over. The temporary tag on the vehicle appeared to be issued to a different vehicle from the respondent dealer than the vehicle that they found it on. An investigation was conducted. The respondent's temporary tag log indicated that they issued that tag to a consumer, which was not the person who was driving the vehicle, in April of 2012. However, the actual tag had physical holes punched into it, indicating that the date of issuance was July 2012. As such, it's very sufficient to say that the respondent failed to maintain the accountability of the issuance of that temp tag. I would recommend an authorization for a civil penalty in the amount of $500 for failure to properly maintain its temporary tag log, to be settled by consent order or formal hearing. Number 21, case number 201300181. Here, the complainant is a Kentucky resident and consumer who alleged that the respondent dealer sold him a motor vehicle that had a rebuilt branded title without disclosing such to him prior to the sale. The complainant was contacted and forwarded this office a copy of his sales documents. The complainant provided this office with a document labeled as is where is form that indicated specifically that the vehicle purchase was previously salvaged and that the title to be received would be branded as rebuilt. The complainant signed this disclosure. I recommend to close this case with no violation being found. The complainant was signed as is whereas form disclosing the branding of the title. Number 22, case number 20130022751. Here, the complainant consumer alleged that the respondent dealer sold her a motor vehicle which she believed had previous flood or water damage. The respondent replied indicating the vehicle was sold with non-branded title, that he had no knowledge of the vehicle having any flood, water, or damage. The respondent further indicated the complainant had been behind on payments and the vehicle has now been repossessed. The vehicle history report was obtained from our office through the Department of Revenue, which provided the vehicle's title history. The history indicated the vehicle had previously been titled in the state of Michigan. There no brand, that was the only state it ever been titled in. There was no branding of title either by water or flood as indicated on the vehicle's history provided. I recommend that we close this with no violation being found. The vehicle titled was not branded as a flood vehicle. Vehicle title history does not indicate the vehicle ever being branded as flooded. Number 23, case number 2013003651. Here the complainant consumer alleged that after purchasing a vehicle from respondent dealer, the vehicle had mechanical malfunction with the transmission. The respondent indicated that the complainant driver, in their understanding, recklessly drove, revving the engine and popping the clutch. The vehicle was sold as is without warranty. I recommend that we close this with no violation being found. The vehicle was purchased as is. Number 24, case number 20122022-671. Here the complainant consumer alleged inaccuracies of the amount of money indicated as the balance due on a bill of sale purchased by the respondent dealer. The bill of sale was on the dealer's letterhead. However, the dealer's license expired in 2010. It appears from the bill of sale that the vehicle was sold in 2011 or 2012. It's a little unclear. An investigation was conducted. An investigation at the location indicated investigation was conducted at the location the complainant indicated they purchased the vehicle. The respondent was not found there. The investigator attempted to serve a cease and desist letter that I provided him upon the respondent, but could not find him. It's safe to say we understand that there was unlicensed activity being conducted here, but we do have issues right now finding him. I recommend that authorization for a civil penalty in the amount of $500 to be settled by consent order or formal hearing. Number 25, case number 2012023571. Here the complainant dealer alleged unlicensed activity as a motor vehicle dealer on part of a respondent who is a repair garage. Investigation was conducted. The investigator determined that the respondent recently opened a motorcycle repair garage where he also sold dirt bikes and ATVs on consignment. The respondent also repaired motorcycles. No information documentation was obtained evidencing the sale of motorcycles or that a motor vehicle dealer license was required to be obtained prior to the sale. I recommend to close this with a letter of instruction, since he just recently opened his shop, regarding motor vehicle dealer license requirements prior to the sale of motorcycles on consignments. It seems that he's doing dirt bikes and ATVs. He's repairing motorcycles, street-driven motorcycles. Letter of instruction indicating that if he attempts to consign actual street-driven motorcycles, he would need a dealer's license. Would probably be beneficial to him. Number 26, case number 2012026651. Here the complainant alleged that its neighbor was conducting unlicensed activity as an automotive dismantler and recycler by selling motor vehicle parts. An investigation was conducted. The investigation found that there were numerous pieces of equipment, metals, trailers on this residential piece of property. It really kind of looked not exactly like Sanford and Son, but it just kind of had, he had everything kind of lined up out here, and it did not appear that there were any vehicle parts for sale, no signs being issued, nothing written on them. He had two truck beds that were sitting on a trailer, but he had tractors and bush hog parts and everything sitting out there. And it appeared that the neighbor was really upset that it was making the property look bad. As such, this matter is more suitable to the an ordinance zoning issue. I recommend that we close this with no evidence of unlicensed activity being found. Number 27, case number 2012023021. Here the complainant consumer alleged that the respondent dealer sold him a vehicle that was advertised and listed as new, but was actually used for demonstration purposes. Investigation was conducted and found that the vehicle was advertised as new with a dealer discount off the MSRP. No reference was made in the advertisement that the vehicle was a demonstration vehicle. Further, the bill of sale was marked as new and not demonstrator, which box was available to be marked. An affidavit from the respondent indicated the vehicle was used for demonstration purposes. Respondent stated that the vehicle odometer disclosure statement signed by the complainant indicated the vehicle had 4,400 miles driven on it. The respondent also had failed to respond to the Commission's original request for an answer to the complaint. As such, I recommend an authorization for a civil penalty in the amount of $600, $500 for the one of actually selling the vehicle as new when it was a demonstration vehicle, and $100 civil penalty for failing to respond to the Commission's written request for response to the complaint, to be settled by consent order or formal hearing. Number 28, case number 2011030741. Here the complainant consumer alleged that the respondent, who is an auctioneer, conducted unlicensed activity by selling a motor vehicle to him as a bank repossession. Further, after purchase of the vehicle, the complainant alleged that the title pass was a rebuilt vehicle title, which was not disclosed at the time of sale. An investigation was conducted. The respondent is an auction, and this auction does not hold a motor vehicle dealer license or a public automobile auction license. The vehicle was sold to the complainant, who received a rebuilt title that cannot be shown to have been disclosed prior to the sale. The respondent auctioneer attempted to indicate that they have no duty whatsoever to inform anyone of any branded title for any motor vehicle that they sell. I disagree that they would require a motor vehicle dealer's license. I recommend authorization for a civil penalty in the amount of $1,000 for unlicensed activity, along with an order to cease and desist, to be settled by consent order or formal hearing. And I would also recommend to forward this complaint to the Auctioneer Commission for further allegations of acting as a public automobile auction without a license. 29, case number 20120088971. An internal complaint was opened against respondent, who's an expired dealer stemming from a biannual inspection on the respondent's dealership location. The respondent did not renew his license, and it has expired. The license was issued to a sole proprietorship at the time of inspection. The expired location had 4 motor vehicles posted for sale. The titles were placed into the individual name of the owner, so it was not in the dealership's name. A follow-up investigation was conducted and did not find any further vehicles for sale or sold. As such, I cannot substantiate that there were more than 5 vehicles that were sold to constitute unlicensed activity. However, since he had 4 out there, always would like to send a letter of instruction to this dealer whose license expired, indicating, reminding him that he cannot sell more than 5 a year individually without obtaining a dealer's license. Number 30, case number 20130022731. Here an internal complaint was generated upon information from an investigator from the Tennessee Department of Revenue concerning the respondent who allegedly altered a temporary tag. An investigation was conducted. The respondent's employee admitted to altering the temporary tag. Further, it was found that the employee was not licensed as a salesperson. After the inspection, it was found that the respondent did not have any licensed persons. The respondent has now applied for a licensed salesperson. I recommend an authorization for a civil penalty in the amount of, I have $3,000, and then I have $2,000 in parentheses. I believe that the reason why I do that to make sure that I double check myself, and I believe that should be $2,000. Excuse me, I'll make that mark there. $1,000 for the false act of altering a temporary tag, and $1,000 for 1 count of unlicensed salespersons, to be settled by consent order or a formal hearing. Number 31, case number 201202591. Here the complainant consumer alleged that the respondent dealer provided more than 2 temporary tags for a vehicle purchase and failed to provide title registration. An investigation was conducted and did not find an issuance of more than 2 temporary tags for the vehicle, and further the respondent's records showed title being transferred into the name of the complainant. As such, I recommend to close this with no violation being found. Case number 32, case number 20130045591. Here the complainant consumer alleged that the respondent dealer failed to disclose the condition of a vehicle at the time of purchase. The complainant alleged the vehicle was disclosed at an auto auction as being frame damaged or having unibody damage. The complainant alleges the value of the vehicle was misrepresented. A view of the auto check provided by the complainant indicates that the vehicle was announced as frame unibody damage, not at the auto auction where the vehicle was purchased by this dealer, but at an auto auction 1 year prior to the purchase by this dealer. As such, this dealer, when he purchased the vehicle at the auto auction, had no knowledge of any such announcement because announcement was not made. I recommend that we close this with insufficient evidence of a violation. Number 33, case number 20130046661. Here an internal complaint was opened for a dealer for failing to renew its city and county business license. I recommend an authorization for a civil penalty in the amount of $250 to be settled by consent order or formal hearing. Number 34, case number 20130046671. Here an internal complaint was opened upon the respondent dealer after a biannual inspection, wherein the investigator found that the respondent failed to properly maintain its temporary tag log. I recommend an authorization for a civil penalty in the amount of $1,000 to be settled by consent order or formal hearing. Number 35, case number 20130046681. Here, an internal complaint was opened upon the respondent dealer after a biannual inspection, wherein the investigator found the respondent failed to properly maintain its temporary tag log. The issuance of tags, I recommend an authorization for a civil penalty in the amount of $1,000 to be settled by consent order or formal hearing. Number 36, case number 20130033311. Here the complainant consumer alleged that after the purchase of a used motor vehicle that it began to have mechanical difficulties. The respondent indicated that it showed that the vehicle was sold as is without warranty and that he has actually repossessed the vehicle due to default. I recommend that we close this with no violation being found. Vehicle was sold as is. Number 37, case number 20130044731. In this case, the complainant alleged that there were deceptive acts by the respondent dealer in connection with the purchase of the vehicle and the limited warranty that was provided with the vehicle at the time of purchase. The complaint actually states that when he actually purchased the vehicle, when test driving it, he noticed that there were issues and or slips with the transmission. The complainant alleges that he did not receive a buyer's guide in the window of the vehicle. The respondent provided a signed document from the complainant acknowledging that the vehicle was sold as is. However, the vehicle came with a limited 4-month, 4,000-mile limited warranty on the transmission. The complainant alleged that he was told by the salesperson that the warranty would cover such issue. After purchase of the vehicle, the complainant made application for a new transmission to the warranty company. The claim was denied because the clause in the contract indicated that there was a failure that was existing at the time of purchase by the complainant. By the terms of the limited warranty, had it actually been covered, it would have only been covered in $1,500, which the repair damage estimate amount was over $3,000. The respondent offered to purchase the vehicle back. However, the terms of rescission could not be agreed to by both parties. This just seemed like a very difficult case because the complainant actually, in my mind, it appeared that he had purchased the vehicle with the transmission slipping, and it was his intent to actually file a claim on the limited warranty after purchase to have it repaired, which I don't see how the complainant could assert that that the dealer actually deceived him in any way for that. I recommend the authorization for a letter of warning for the respondent instructing to ensure that each vehicle contains a buyer guide with that information and against limited warranties. The investigation did not ask or go into the buyer's guide actually being present, so I cannot make a determination whether or not one was present on the vehicle at the time of the sale. Number 38, case number 2013004861. Here the complainant is a consumer who alleged that the respondent dealer sold her a manufacturer buyback vehicle in 2007 without disclosing such prior to the sale. The respondent replied indicating that the vehicle was taken as a trade-in from a customer back in 2007 and that they resold it to the complainant in 2007. The vehicle in question is a 2003 Ford. The respondent indicates they did not purchase the vehicle as a buyback from the manufacturer, that they generally do not do that. The transaction is over 6 years old at this time. I recommend that we close this with no violation being found. Number 39, case number 2013005441. Here the complainant consumer alleged that after the purchase of a vehicle from the respondent dealer, the vehicle began to have mechanical difficulties. The complainant indicates that the vehicle was purchased with over 118,000 miles on it. The respondent replied providing multiple documents signed by the complainant indicating that the vehicle was sold as is. I recommend to close this with no violation being found. The vehicle was purchased as is. Similarly, case number 40, case number 2013005841, and number 41, case number 2013006301. Both are similar, where the complainant alleged that they purchased a vehicle from the respondent dealer and the vehicle began to have mechanical difficulties after purchase. The respondent replied in both cases indicating the vehicle was purchased used as is without implied warranties, and as such I recommend that both cases be closed with no violation found. Vehicles were purchased as is. Number 42, case number 2013006461. Here the complainant is a consumer who alleged that the respondent dealer failed to provide a service agreement upon the service agreed upon and conditioned upon the purchase of a used motor vehicle. The complainant alleged that certain services were not performed on the vehicle. Respondent replied indicating that they would pay the complainant the exact amount requested by the complainant, but stated that they did not feel obligated to do these as they were not these obligations were not noted on their standard "we owe" form in the deal file. It appears the respondent has provided the complainant with all the items requested. As such, I recommend to close this complaint with no violation being found. The respondent agreed to comply with complainant's requests. Number 43, case number 2013001411. Here the complainant is an out-of-state consumer which alleged that the respondent dealer sold him a vehicle in 2011, after which the complainant moved to Kentucky and never received title to the vehicle. The respondent provided a copy of the title extension form, which was on a Virginia title, along with an affidavit of sale to be taken out of state, which he keeps for his records to the Department of Revenue, and indicated the title was sent to the complainant, who likely lost the title. The complainant didn't respond to us for any further information after we sent him the response from the respondent. As such, I recommend that we close this. The respondent provided a copy of the title and there was a surety bond information that was sent to the complainant. Number 44, case number 2012-026361. Here the complainant is a consumer who alleged that the respondent dealer sold him a motor vehicle without disclosing the vehicle being sold was from a dealer and that the transaction occurred in the parking lot of a Starbucks, not the licensed location. An investigation was conducted. The respondent indicated that the vehicle was sold at the licensed location. However, the complainant provided copies of text messages from the respondent indicating the location to be met at was Starbucks. This constitutes an off-site sales violation. I apologize for laughing, but it was actually the first time that we'd actually had copies of text messages from a dealer showing that they had actually lied at the location that they sold the vehicle. So it was pretty good for us to be able to get that from the complainant. As such, I recommend authorization for a civil penalty in the amount of $500 to be settled by consent order or formal hearing. Number 45, case number 2012-021641, and a second case was 2012-021642. Here there are two respondents. Here the complainant consumer alleged that the respondent dealer sold her a vehicle but failed to provide title or registration. An investigation was conducted. The respondent's location was found to be completely abandoned and the respondent could not be found. The investigator found that the respondent purchased the vehicle from an individual who was not the owner of the vehicle. The vehicle was owned by another person, which was a dealership, which had that dealership, the vehicle was owned by another consumer, which had a different dealership as a lien holder. Apparently, after default by the owner, an unknown person obtained possession of the vehicle and sold it to this respondent dealer. The respondent, without having title, turned around and sold the vehicle to the complainant and could not provide the title. The vehicle was subsequently repossessed by the true lien holder and sold at auction with an announcement that the vehicle had been previously stolen. However, our investigation did not obtain any police report indicating that the vehicle was actually reported as stolen. It appears the respondent dealership and salesperson purchased this vehicle that did not belong to the seller and sold the vehicle to the complainant, did not provide them with title for approximately 4 to 5 months. And as such, I recommend authorization of the revocation of the motor vehicle dealer's license and the motor vehicle salesperson's license who sold the vehicle to the complainant. Number 46, case number 2012-020451. Here the complainant dealer alleged the respondent auto auction allowed an unauthorized person to purchase a vehicle on behalf of the complainant. The complainant alleged that her licensed salesperson, who is also her brother, obtained an auction access ID and forged her authorization to purchase vehicles on her behalf. An investigation was conducted and found that the respondent auction had what appeared to be signed authorization forms for the salesperson to purchase vehicles on behalf of the complainant. They obtained affidavits from persons present at the auction indicating that the respondent's salesperson was present that day and did purchase the vehicles. The salesperson has since been terminated by the complainant. The salesperson could not be found. It appears this matter between the complainant and dealer is a matter between a brother-sister salesperson, and there's no evidence of any violation on part of the respondent auction. I recommend we close this with no violation being found on part of the auto auction. Respondent provided documentations for the authorization of salespersons to purchase on behalf of the complainant. Number 47, case number 2012-022951 and 2012-022691. Here the complainant consumers allege that the respondent dealer failed to provide titles or registration and provided more temporary tags than allowed by law. An investigation was conducted. The respondent had provided title to one complainant. It could not be determined how many temporary tags were provided to her as the respondent failed to keep a complete log of temporary tags. The respondent provided a sworn statement that the complainant was only given 2 tags. The respondent admitted to giving the second complainant 3 temporary tags. Further, the investigation found that the respondent was in possession of temporary tags that had been issued to customers and which actually had been altered. So he had issued them out, they were altered, but somehow they came back in his possession. The Tennessee Department of Revenue was contacted, who conducted their own inspection. The respondent was provided educational training by the Department of Revenue and our investigator. A follow-up inspection was conducted by the Department of Revenue a month or 2 later, and they reported back to us that the respondent was in compliance and had hired a new title clerk. I would recommend authorization for a civil penalty in the amount of $3,000, $500 for providing the complainant one more temporary tag over the legal limit of tags to be issued, $1,000 civil penalty for failing to properly maintain his temporary tag log, and $1,500 civil penalty for possession of 3 altered temporary tags to be settled by consent order or formal hearing. Number 48, case number 20120238891. Here, the complainant is a consumer who alleged that the respondent dealer sold her a motor vehicle with salvage title without disclosing such. An investigation was conducted. The complainant and husband purchased the vehicle in 2011. The documents from the deal file do not state that the vehicle currently had a salvage title. The vehicle was sold to complainant on a salvage title. The respondent issued 2 temporary tags to the complainants. The complainant soon after moved to another part of the state, I believe from Clarksville to Sevierville. The respondent had not applied for a rebuilt title and blamed the inability to obtain title on part of the complainant for not having the vehicle available for an inspection, which is an inspection from the Tennessee Department of Revenue for the anti-theft inspection when you rebuild a salvage to a rebuilt vehicle. The complainant stated that they were not informed that the vehicle at the time of purchase had a salvage title and that they would need to have the vehicle available for inspection. The complainants contacted the Tennessee Department of Revenue to assist in obtaining title. At that time, that's when the complainant found that the vehicle was rejected by the Department of Revenue for a rebuilt title based on 2 things. One is the complainant applicant was not the person who rebuilt the vehicle. The dealer rebuilt the vehicle. And second, that the vehicle, after being rebuilt, the airbag light was on, and that is one reason why the Department of Revenue will not issue a rebuilt title when that light indicator is on. From the document obtained, it appears that the respondent sold the vehicle on a salvage title, issued 2 temporary tags for operation of that vehicle, and further ultimately failed to obtain a good certificate of title for the complainant. I recommend authorization for a civil penalty in amount of $5,000, $4,000 for the deceptive act of selling a vehicle on a salvage title without disclosure, $1,000 for the issuance of 2 temporary tags on a salvaged vehicle. Number 49, case number 20120222791. Here, the complainant is a finance company that alleged the respondent dealer failed to deliver title to the vehicle financed by the company. An investigation was conducted and found that the finance company remitted funds to the respondent to pay off the lien holder. The lien holder accepted the funds. However, they could not provide the title until months later, so the lien holder actually had lost this title for a significant period of time. The respondent dealer had to turn around and reimburse the finance company and now holds the title and was working with the purchaser to obtain the vehicle back in return of his complete down payment. I would recommend that we close this with no violation being found. The complainant was reimbursed payment. The lien holder could not provide certificate of title. It appears this dealer has done all that he can to rescind the deal. Number 50, case number 201201862 and 201201862. Here, the complainant is an individual that alleged that the respondents were conducting unlicensed activity by placing motor vehicles for sale on Craigslist. The complainant provided 2 names and an address of the activity an investigation was conducted. The complainant did not provide information detailing how the named individuals were connected with the sale of the vehicles. The property listed did not have vehicles located on it for sale. The telephone numbers listed that were not connected to any found person. As such, the investigator did not conclude any specific vehicle sold by any identified person. Also, here the complainant did not fully cooperate with the investigator to attempt to get them any more specific information as to how they knew these persons. As such, I recommend to close this case with insufficient evidence of unlicensed activity. Number 51, case number 2012025-131 and 2012025-132. Here, the complainant consumer alleged that the respondent dealer sold her a motor vehicle in 2010 without disclosing prior known unibody damage that was announced when the respondent purchased the vehicle. The respondent had purchased the vehicle at an auto auction where it was announced as having unibody damage. The respondent at the time of sale to the complainant printed out a Carfax and handed the Carfax to the complainant, which didn't indicate that there had ever been any unibody damage reported on it. The respondent did not correct the mistake prior to the sale of indicating to them this is the Carfax. However, it doesn't indicate that there was unibody damage when I bought it. When selling the vehicle, the complainant found that the Carfax later did indicate unibody damage. It generally takes a couple months for those things to show up on a Carfax or auto check report. Respondent provided the original 2010 Carfax to my office and a recent Carfax indicating the depreciation in value. Further vehicle was shown to the complainant at the location that is not part of the respondent's dealership but a private residence. So on top of all of that, it appears that the salesperson of the respondent actually sold this vehicle to somebody at their own private residence, not on their licensed location, which would be off-site sales also. As such, I recommend an authorization for a civil penalty in the amount of $1,000, $500 for the deceptive act of failing to disclose a unibody damage after providing an incorrect Carfax report to the consumer, and $500 for off-site sales to be settled by consent order or formal hearing. Number 52, case number 20120256111. Here, the consumer complainant alleged that the respondent dealer required them to enter into a contract to purchase gap insurance in order to purchase a vehicle. An investigation was conducted. The complainant appeared to not fully cooperate with the investigator, providing documentation and statements. The respondent replied denying any such activity, and as a gesture of goodwill, refunded the gap insurance payment to the complainant. I recommend that we close this with no violation being found. The gap insurance was refunded. Number 53, case number 2012024641, 2012026491, and 2012026501, which are all against the same respondent. The Commission received multiple complaints from the Montgomery County Clerk's Office and consumers indicating that respondents, which is an Alabama dealer, were selling motor vehicles in Tennessee without a license. An investigation was conducted with the assistance of the Montgomery County Sheriff's Department. An investigation found evidence of 11 motor vehicles being sold by an Alabama dealer on its bills of sale letterhead. The dealer actually had purchased these vehicles at Tennessee auto auctions. The individuals selling the vehicles appeared to be Tennessee citizens with Tennessee driver's licenses. A location was found storing vehicles for sale in Clarksville. Those vehicles were moved overnight after our investigator went out there to observe them. The sheriff's office did not make any arrests in this matter. The company appears to have a dissolved charter and has abandoned its business location in Alabama. It is likely that this corporation will be difficult to find, along with the individual salespersons. However, at this time I would recommend an authorization for a civil penalty in the amount of $11,000 to be settled by consent order or a formal hearing. Number 54, case number 201000124771. Here there was an internal complaint that was opened regarding information that a dismantler and recycler was purchasing inoperable motor vehicles and failed to retain proper documentation from whom the vehicles were purchased. Documentation from the police department was obtained where Metro went out and did an inspection on the location. An individual owner was cited for a Class C misdemeanor and pled guilty and received a $50 fine. As such, I would recommend an authorization for a civil penalty in the amount of $1,000 for the false act of failing to obtain the required documentation on the purchase of the vehicle to be settled by a consent order or a formal hearing. Number 55, case number 201300553. Here, a complainant consumer alleged that the respondent dealer did not make adequate repairs to a vehicle brought in for service. The complainant alleged that after picking up a vehicle for service the next day, the vehicle overheated. The cost of repairs was $1,500. The complainant alleges the services charged for repairs should have been covered under a manufacturer recall. The respondent disagrees and, as a goodwill gesture, provided the complainant a 50% discount for the repair. The complainant's allegations were not substantiated. I recommend to close this with no violation being found. The next area is the representations that we provide to you. Number 56, case number 2012024071. The Commission previously authorized a civil penalty at its January 2013 meeting against the respondent dealer for misrepresentation that a motor vehicle was purchased as it was advertised as a track model, a certain type of model vehicle or accessory, when it was not such model. After the authorization, the complainant consumer communicated his want with the Commission to withdraw his complaint. He is actually settled with the respondent. As such, the violation would not be able to be proven without the complainant's cooperation. It seems the complainant is satisfied in this matter. I recommend that we close this. The complainant has withdrawn the complaint. Number 57, case number 20120026461. Here, the Commission authorized a $500 civil penalty at its January 2013 meeting against respondent dealer for not meeting its reasonable business hours. An anonymous complaint indicated that respondent was only open one day a week. After the January 2013 meeting, this office, my paralegal, called the respondent's number, which indicated that their office was actually open 12 hours a week. As the complaint was anonymous, there is insufficient evidence to actually show a violation because we don't have anybody's testimony that the previous recording was actually only open 1 day a week. As such, I recommend that we close this with a letter of warning. Number 58, case number 2012008331. Here, the Commission previously authorized a civil penalty in the amount of $124,500 at its July 2012 meeting for alleged 242 days of unlicensed activity of an automotive dismantler recycler whose license expired. The dealer is currently now licensed. The investigation report does not provide any proof that the respondent was operating each of those 242 days. The investigation only indicates that unlicensed activity was observed by one of our investigators on one day. As such, there's not sufficient evidence to show the 242 counts of violations. The respondent has offered to settle this matter in an amount of $10,000, which I would recommend accepting. I would recommend to amend the previous civil penalty authorization to $10,000 to be settled by consent order or formal hearing. Number 59, case number 2012008731. Here, the Commission previously authorized a civil penalty in an amount of $5,000 for unlicensed activity against the respondent unlicensed person. Upon review of the investigation report and documentation obtained, there is not sufficient proof to prove that previously thought 10 counts of unlicensed activity, but only 1 count. As such, the authorization can be reduced. And in here, the investigation report showed vehicles that were actually listed for sale with a telephone number. The telephone number was not traced back to this actual respondent, and the vehicles are sitting on a piece of property that was not owned by the respondent that we had, but by somebody else, and they were actually just being parked there against the owner's knowledge. As such, I recommend that we amend this previous authorization for a civil penalty in an amount of $500 to be settled by consent order or a formal hearing. Number 60, case number 2012012231. The Commission previously authorized civil penalty in an amount of $6,000 against the respondent at its October 2012 meeting for unlicensed activity in Memphis. The respondent was selling as an individual and cannot be found to serve a consent order upon him. This respondent actually has gone out of the state of Tennessee, and I cannot find him to actually give him the consent order. I recommend that we close and flag this case and close and flag this individual's name. Number 61, case number 2012019022 and 2012019021. Here, the Commission previously authorized 2 civil penalties. There was $10,000 against a salesperson for unlicensed activity of advertising a false entity in association with motor vehicles being sold through a dealer, and another $1,000 civil penalty against a motor vehicle dealer for unlicensed activity of having a vehicle solicited for sale at an unlicensed location, and further for advertising violation acts of failing to provide the dealer's name or dealer number on advertising created by the salespersons, and further for deceptive advertising. After receiving the consent order, this office, met with the respondent dealer who was open and forthcoming with his failure to supervise his salespersons and allowing them to advertise, but he admitted to failing to check their advertisements. This office does not have sufficient proof, as previously presented to the Commission, that the dealer had knowledge of the type of advertising that was being conducted by the salesperson. As such, this office cannot show that the dealer was actually conducting any deceptive acts of advertising, and that deceptive act allegation was only one of several allegations, and I would recommend that we amend this previous authorization only against the dealer from the $11,000 to $8,500 to be settled by consent order, and if not consented to, a formal hearing for the original authorization. Number 62, case number 2012015001. Here, the Commission previously authorized a civil penalty against the respondent dealer, which is a public automobile auction for deceptive acts, where they sold a truck that had 2 VIN numbers associated, one for the frame and one for the cab. After receipt of the consent order, the respondent, which is the auto auction, offered to purchase the vehicle back from the complainant for the full purchase price plus interest. I personally called the complainant and asked him if he would actually accept this offer. The complainant said he was thinking about it. He called me back the next day and said, "No, I'm not going to take their offer, and I've actually sold it to another person." So as such, because of that, I recommend that we amend the previous authorization to close with a letter of warning due to the respondent's attempt to rescind the transaction and compensate the complainant who has refused to do so. Number 63, case number 2011024021, 2011027531, 2011029041. Here, this complaint was generated as a result of two separate complaints filed with this office, as well as a request by an investigator to perform an audit on the business premises of the respondent. Both of the complaints filed were centered around title issues and the issuance of excessive temporary tags. Both complainants allege that the respondent had failed to provide titles to the vehicles purchased. An investigation was initiated in which respondent owner was interviewed. The respondent owner stated that he had been having financial problems and he was out of trust with his floor plan company and therefore unable to obtain the titles to remit to the customers. The respondent did state, however, that to date all customers had received their titles with the exception of one individual, the complainant. The respondent admitted to selling complainant a salvage vehicle in 2011, but respondent failed to submit the proper paperwork to achieve salvage certificate on the vehicle. The paperwork was not even submitted until after the first week of November, which was approximately 6 months after the sale. Thus, complainant had been driving on a salvage title for those 6 months. To this date, the respondent has not been able to provide proper title. The respondent also admitted to issuing numerous temporary tags to the complainant since May, and the complainant is currently driving on one of the respondent's used dealer plates that had given her until the titles arrived. During the same investigation, while reviewing the temporary tag log, the investigator discovered the tags were being logged in individuals' names while reviewing the temporary tag log, the investigator discovered the tags were being were not purchased from the respondent in order for it to appear that excessive tags were not being issued. The respondent stated that it knew during its biannual inspection was coming, and due to that knew that the temporary tag log would be checked, so it had tried to make a new log. And he destroyed his old log. The Department of Revenue had informed our investigator, the respondent has yet to send proper documentation. We previously had an authorization for a civil penalty in an amount of $89,000. When we actually went out we sent our investigator out several times to find this business, to find the business owner. This business has been completely closed down. There is a for sale sign in the window. We cannot find this person. We cannot get an address on him. We tried to send out a consent order. I can't even send him a consent order out so that he knows that he needs to pay the original $89,000. We do not have a function of being able to get the attention of this dealer. This dealer's license is going to expire in, I believe, 1 month. I recommend that we actually close this complaint and flag the actual individual dealer owner and the dealership. Number 64, case number 201102, 1271 and 2013002591. Here there's two cases. The first one is 2011021271. What I'm going to tell you is that based on there was a previous authorization for an amount of $2,500 due to issuing out excessive temporary tags to a complainant. The complainant actually, and she indicates that she could not receive title. We've had issues with actually this complainant about being able to actually prove the allegations with this complainant here. She indicates that she had an issue obtaining a title. We have no documentation of that. Department of Revenue has no documentation that this vehicle was ever registered in Tennessee. So what we would like to do is we would like to actually close this complaint, 2011021271, and we actually set up a second complaint just on the temporary tag violations, because that's the easier violation and the better violation to go after because it's more substantial. So I'd recommend that we would close 2011021271 due to the insufficient evidence of the violation for the inability to obtain a title. And we have opened 2013002591, and when we opened that complaint, we had the investigator go out and obtain a copy of their temporary tag log, the full temporary tag log, where we found that 33 temporary tags had been illegally issued to consumers, and I would recommend that on that case, that authorization of a civil penalty in an amount of $16,500 to be settled by consent order or formal hearing. Number 65. Number 65 have cases, and I'll read them here for you. 2011027181, 2012000481, 2011024291, 2011028971, 2011022501, 2011019851, 2011027561, 2011031001, 2012000641, 2011018641, 2011022331, 2012004091, and 2012018841. I've put all of these complaints together because all of these complaints have been previously authorized civil penalties by the Commission. In preparation for a formal hearing, it's determined that we have insufficient evidence to support the allegations against these. Some of them we have issues with. The complainant cannot be located, they cannot be identified, and they were the only persons who can actually assist us in proving these allegations that we previously had. We have a lack of investigator testimony, wherein we have had an investigator who is retired after so many years of service, and their investigation report we cannot use because we do not have them as actually a testimony witness. And the respondents in some of these cases have actually gone out of business and cannot be found. So these respondents, when we try to attempt to serve them with further consent orders second and third time, they haven't responded, and the investigator has gone out there and found that it's completely closed out location. Those I would recommend that we close for insufficient evidence of a violation. We're not going to be able to move these cases forward any further than where they have gotten right now. Number 66, cases numbers 20120262, 2012057661, 2013000501, 2012023901, 2012025991, 2012017951, 2011025151, 2013000334, that will be a 1, and 2013000357, and that will be a 1. All of these complaints are where the dealer had failed to provide titles or registrations for vehicles, or dealers who had been issued a citation which had not been paid. The dealer has abandoned their business and is no longer operating. The surety bond information has been sent out to the complainant so that they can recover against that. I recommend that we close and flags. These respondents are out of business. Number 67, 201, I'll read the case numbers. 20120235531, 20120235991, case number 20120264551, 20120233601, 20130029661, 201300271, 20130027001, 20130022511, 201300448, which will be a 1, and 20130055541. All of the above complaints were submitted stating that respondent dealer had failed to provide their title registration for vehicles, and after receiving the complaint by the Commission, we found that the registration or title was provided to the complainant from these dealers. I recommend close these complaints. Title registration was received. Number 68, case number 201202402, and that should be a 1. 2013004511, 2012026521. All of these complaints are where the complaints have been settled between the parties after filing the complaint, and they communicated that to my office. I would recommend to close these complaints. They have been settled between the parties. And number 69, cases 201300761, 20130011601, 20130011101, 20130025531, 2013561, 20120265541, and 201300481. All of the above complaints were withdrawn by the complainant after they submitted them to the Commission, and I would recommend to close them. They have been withdrawn. And lastly, number 70, case is 20130028111 and 201300491. The above complaints were opened due to the first advertising violation by a dealer within 1 year period. The first advertising violations are recommended to be given a letter of warning. I recommend to close these with a letter of warning. That does conclude the legal report from the the Motor Vehicle Commission legal report. Do you have any questions? Thank you very much.
9:35 a.m. Legal report meeting has been closed.
Thank you, Chairman Jackson. Director Stribling, are we going to need some lessons on this technology before we begin the meeting? Let's get the commissioners to take their places, see if there are any questions about the equipment. Is there anything that we have to do to make this operate? Is it operational right now?
So it'll pick up automatically.
What does the speak button mean? Okay.
Whoever's speaking, it's going to show their microphone on the screen.
I like our new digs. All right. Do we need a 5-minute break before we begin the meeting? We do. We'll start the meeting in 5 minutes. That sounds like it. Okay, Monday, April 15th, 2013, we convened the regular scheduled meeting of the Tennessee Motor Vehicle Commission at 9:45. We'll start with roll call.
Commissioner Stan McNabb. Commissioner George Bass. Commissioner Wade Hinton. Commissioner Clayton. Commissioner Kevin Cullum.
Here.
Commissioner Ronnie Fox.
Here.
Commissioner Donnie Hatcher.
Here.
Commissioner Nate Jackson.
Here.
Commissioner John Murray. Commissioner Reed Trickett. Commissioner Mark Purtle.
Here.
Commissioner Don Parr.
Here.
Sarah Vaughn.
Here.
Commissioner Lynn Webb.
Here.
Commissioner Billy Keck. Mr. Chairman, you have a quorum.
If you'll review the minutes of the last meeting, and ready, we'll vote to approve or revise those minutes.
So moved. Second.
Clayton moves and Commissioner Hatcher seconds. All those in favor of approving the minutes, say aye.
Aye.
Anyone opposed? None heard. Look over the agenda for this meeting. We'll need to adopt that agenda.
Move to approve the agenda as submitted.
Second.
Earl, and who seconded?
Joe. Second.
Commissioner Clayton. All those in favor of adopting the agenda for this meeting, say aye.
Aye.
All those opposed, say no. That passes. The meeting was posted on the MVC website March 29, 2013. We're ready to move to the salespersons, applicants, and appeals. The first appeal is Scott A. Tyler, Rainey Ford, Lincoln, Johnson City, Tennessee. Mr. Tyler, come forward, sir. Do you have somebody with you from the dealership? If you come forward too, sir. Director Stribling, where would they, okay. Throw Mr. Tyler around. Legal counsel would tell us the reason that the applicant was denied.
Multiple offenses that had to be traced and looked at. The offenses that we had: breaking and entering, acquiring goods or money by false pretenses. There's forgery of public record also noted in the file, and from the records that we indicated did not have an end date for the sentence or probation that we had in there. However, from the documents that we had, I'm confident that he has not passed the time limits where the discretion of the commission to actually deny this license.
Tyler, you understand why your application was denied?
I do, sir, yes.
Okay. You fall into not having had 5 years pass since your sentence was completed. If you'd address the commission as to why you think that you should be granted a license.
Yes, sir. First and foremost, a lot of those things are from just a battle with drug addiction. I have been clean for over 4 years. My career has been in automobile business. I was born into the business. My family had a Ford dealership in Oak Hill, West Virginia, so it's all I've known, and it is my career. I did get married here in September. Did buy a house in Bristol, Tennessee. And I was just hoping, for the board to have mercy and consider, look at me today as what I was 4 years ago. You guys don't know me, and I understand that. I've came a long ways. Do have a wonderful wife and children that are living in Bristol, Tennessee. I do have the support of the Ramey Automotive Group to transfer from Beckley, West Virginia down to Johnson City, Tennessee to go to work and sell cars down here. I've been ultra successful in this business, and I just look for an opportunity to further my career in Tennessee.
Commission members have questions for Mr. Tyler, or any observations by commission members? Take a moment then to look over the record and questions or motions. Okay, while we're doing that, would your sponsor like to address the commission? Identify yourself, sir. Lean in just a little into that microphone, sir.
My name is Keith Tyler. I'm a general manager there at the store of Beckley. I have spoken to Mr. Ramey about this transfer, for this young man here to transfer to Johnson City, and he's very much in favor of it there if it so be with you folks.
Related to the applicant?
I'm his father.
How long have you been at this particular dealership?
Been at this particular dealership since 1995.
As general manager most of the time?
No, sir. I started out as a new car sales manager, then worked my way up. I've been a general manager at this store since probably 2001,
How many salespeople do you supervise, sir?
F23 right at the present, yes, sir.
Are you a resident of Bristol or that area?
No, sir, I'm not.
Where do you live, sir?
I live in Beckley, West Virginia.
How far is that from Bristol?
Buyers,
About 2 hours to work every day?
No, sir. I work in Beckley. I'm the general manager there for the Ramey Automotive Group there in Beckley. We're all one big store. We have, Mr. Ramey has 14 different stores.
So you are licensed in West Virginia,
Yes, sir. Yes, sir.
and you're the general manager in West Virginia.
Yes, sir.
Okay.
Yes, sir, I am.
Now, who would be his supervisor in Bristol, Tennessee?
Gentleman's name is Ed. Brad Cox is the other gentleman there.
Ed Cox,
Brad.
Brad Cox.
Yes.
Your son worked for you before in West Virginia?
Yes, sir, he has.
How long had he worked for you?
Scott has worked for me from time to time. Oh, goodness gracious, probably 6-8 years.
Does he have an active salesman's license in West Virginia?
Yes, ma'am, he does.
The move to Bristol if you have a license in West Virginia.
A lot of it is, I would like to come to Bristol. A lot of getting a recovering drug addict, different way.
So that I understand the the term, 2 10-year terms, so this is 20 years from 3/25/11. Am I understanding that?
Those terms were, I believe those terms were sentenced together. He had multiple terms that were sentenced. They were done at the same time. From the paperwork that we have, that his probation, though ending either now or several months from now, the commission has the ability to deny the license application 5 years after that date. That's why you'll see on your form approximately 2017 is a year that the commission can deny all the way up to that year, just so you know. End of the later of the sentence ending probation release plus 5 years is the statutory discretion to deny the license.
Where are you working now? Where is he working? I understand where you are. Where is he? Where is your son working?
Works in Beckley, West Virginia for me.
How long has he been there?
Scott has been with me
I came back in, be right at 2 years come this July.
When were you released from prison? Yeah. You've been 3 years. And you've worked that 3 years there in Beckley?
First job when I came back out was I went into produce sales. Now that's a challenge. Produce sales, and and I earned the respect back of Mr. Ray. Ultra successful, and you can look at my record. All my stuff rolls back to drug addiction, credit card fraud.
What was the charge of forgery of a public record?
That was a speeding ticket.
Charge was theft of less than $1,000.
Let me add for the record that Commissioners Trickett and Murray have joined us, and I'll ask them to recuse themselves from voting or comments on this particular applicant since they weren't here to hear the full testimony. Further questions or motions? State that again, please, sir.
Motion that we grant him a license.
Second.
That was Commissioner Webb made a motion to grant, and Commissioner Fox, Commissioner Parr. Okay. Well, Commissioner Parr seconded that. Is there any discussion of the motion? All right. Hearing no discussion, I'll call for a vote. Roll call vote. Director Stribling?
Commissioner Hinton? Commissioner Hatcher?
Yes.
Webb? Hahn?
Yes.
Commissioner Parr?
Yes.
Commissioner Pirtle?
Yes.
Commissioner Trickett?
Abstain.
Commissioner Jackson?
Yes.
Commissioner Fox?
Yes.
Commissioner Cullum?
Yes.
Commissioner Clayton?
Yes.
Commissioner Roberts? Chairman, we have 9 yes, 2 abstentions, and 1 no.
Tyler, you'll be granted a license to sell automobiles in the state of Tennessee. Good luck. All right, let me get back to my agenda. Oh, yes. All right. Clarence E. Branch. Mr. Tyler? Mr. Branch, approach the podium there, please, sir. The staff would comment on the reason for denial of this application.
Having a felony his offense was a convicted felon in possession of a firearm. And looking at this, I would urge the commission to take into consideration that the ability to deny a license, to not issue one, is for one of those where someone has been convicted of a crime of moral turpitude, which is generally has a very rough definition. That's a very old definition, which indicates that it's inherently immoral or dishonest, or conduct which is contrary to justice, honesty, modesty, good morals, things of that nature. And I'm seeing this on my research. I have not seen where the Tennessee courts had previously indicated that a felon in possession of a firearm is convicted. It has been convicted of a crime involving moral turpitude. So I cannot say with much enthusiasm or knowledge that the crime that he's committed is actually a crime of moral turpitude.
Branch, would you like to comment on the circumstances of your comment further on the circumstances of your felony?
Yes, sir. The firearms that I had, I was in possession of. It was a conspiracy. Someone else called me about them, and I called someone else about it. That's how I got conspiracy of firearm. I'm not a dangerous guy. What I'm trying to do right now is just restart my life over. That's all I want to do, is just sell some cars and restart. And I got a home I have to pay for. I got 2 kids in college. Without a license, I can't support them. I want to just get out there and sell some cars, and take care of those.
Did your sponsor come with you?
Yes, sir.
Sir, would you like to address the commission?
Yes, thank you, Commission and Director. My name is David Smith. I'm with Jackson Auto Center in Jackson, Tennessee. 2 of us are partners. We own Jackson Auto Center. And we were familiar with Clarence prior to his conviction. And he contacted us in October of last year that he was coming to a halfway house in Memphis, Tennessee. And he needed employment to get to Jackson, Tennessee, so he could spend a night with his family every night. He still had to go to Memphis once a week. So we did give him employment as a car detailer. Then in December we applied for his salesman's license, and that got denied. And so we appealed that decision, and I have a lot of high regard for Clarence, and good people make bad judgments sometimes, but we fully support him.
Mr. Robert?
Yes.
I would have to abstain, but Clarence used to work for me about 10 years ago, and like he said, he'll never bother nobody. He has never. He was perfect. He was a salesman for me, and he has had previous salesman license, but it's been 10, 15 years ago. This is way before all this. But
You're going to abstain from
I will abstain from him, but he is. He's telling everything is the truth.
Record, Commissioner Hatcher abstains after comments. Any further questions for Mr. Branch? Motion then.
Mr. Chairman.
If there are no questions, entertain a motion.
So moved. Move to approve his license.
Second.
Myrtle moves to grant the license, and Commissioner Vaughn seconds. Any questions or discussion? Any discussion of the motion? Hearing none, we'll call for a roll call vote. Director Stribling?
Yes vote will be to grant the license. Commissioner Clayton,
Yes.
Commissioner Cullum,
Yes.
Commissioner Fox,
Yes.
Commissioner Jackson,
Yes.
Commissioner Jackson,
Yes.
Commissioner Murray,
Yes.
Commissioner Trickett,
Yes.
Commissioner Pirtle,
Yes.
Commissioner Parr,
Yes.
Commissioner Vaughn,
Yes.
Commissioner Webb,
Yes.
Baines, Commissioner Roberts,
Yes. Mr. Branch, you'll be granted a license to sell motor vehicles in the state of Tennessee.
Thank you all for a second chance.
Congratulations.
Y'all have a great day.
Mr. Quarles, Kenneth Quarles. Quarles. Note that Mr. Quarles doesn't seem to be here. Is there a motion?
Commissioner Jackson, motion to uphold the staff recommendation.
Commissioner Jackson and Commissioner Trickett motion to uphold the staff denial. So a vote for yes would be to uphold the denial, and the license would not be granted. Director Stribling, roll call.
yes vote will be to uphold the denial and not grant the license. Okay.
That will not grant the license.
Clayton,
Yes.
Commissioner Cullum, Fox,
Yes.
Commissioner Jackson,
Yes.
Commissioner Murray,
Yes.
Commissioner Trickett,
Yes.
Commissioner Pirtle,
Yes.
Commissioner Parr,
Yes.
Commissioner Vaughn,
Yes.
Commissioner Webb,
Yes.
Commissioner Hatcher,
Yes.
Commissioner Roberts,
Yes. Staff denial is upheld. George O. Devine. Morning, sir. Legal?
Mine was denied a motor vehicle salesperson license for conviction of a delivery for delivering a controlled substance. During the last meeting, this type of situation also arose, and I indicated that I have not found under Tennessee law, where the Tennessee courts have determined that someone who is selling a controlled substance is committing a crime involving moral turpitude. However, I've found that in other states and under the federal system, that they have determined in instances that they found that it was a crime involving moral turpitude due to the fact that selling controlled substances was a corruption of other persons or citizens, which was a crime against the morality of one duty that one person owes to another and to society in general. So with that, I believe the Commission could have the discretion, based on its own opinion, that this is a crime of moral.
Had a comment to that, and this is not a legal interpretation on my part, of course. In terms of some federal findings that selling controlled substances could lead to the corruption of another individual, I think also a factor would be the age of the person it was sold to. For instance, if you sold it to a child or a minor, something like that, if I might add that comment.
Yes, that was the case that happened at the last meeting that we were at, that the person was actually, not this person, so just for clarification, that person had been found to have sold a controlled substance, I believe within 1,000 yards, a certain distance of a school, which was an aggravating factor to that charge. However, we don't have that in this instance, so that would not play a factor, I guess, involved with him.
Mr. Devine, would you like to address the Commission about the circumstances of your...
Excuse me, I'm a little nervous.
I did sell some pills, 4 pills, to a neighbor who we were on the same prescription. I know that it was wrong. I've had to go to court and be on probation for it. I've been in the car business since 1985. I moved here in '04, selling cars since '04. Even though I didn't do this to, this wasn't like a big monetary gain type thing. It was wrong, and it was an undercover situation involved in it, and it's cost me a lot. And I never dreamed that I couldn't get a sales license back to sell cars, because it's all I've ever done. So I never dreamed that this would go this far here. Because this is the way I pay my bills. I own a home in Sparta, Tennessee. I work in Smithville. I work for Mr. Flores, who owns a dealership, and I've been there a few times and back and forth, and realized that once this thing happened to me, I needed to do something about this. So I joined this program, and I've been there for almost 9 months now, and I went to treatment prior to that, and I realized I had a problem, and I just been getting help for it and trying to stay. I've been clean, and I've been coming to work and doing the best I can, and I just want an opportunity to provide for my family.
You were previously licensed, and when you applied for another license to transfer to a dealership, it was denied. How did your denial come about?
Well, I disclosed the conviction on there, and they said that in the last couple of years, I believe that they passed a law that if you committed a felony of moral turpitude or something to that effect, that it was going to be 5 years when you got off probation. 5 years after that, you couldn't get your license till then. But
looking back over the last 2 years, your employment record on your application, Cumberland Kia, 2010 to 2010. That sounds like that didn't last very long there. Florence and White Ford, 4/2011 to 6/2011. That's 2 months. And then it looks like you came back to Florence and White Ford on 9/2011, and that lasted about 3 months into January 2012. And then you came back to Florence and White Ford April 2012, and that lasted 2 months into 6 and 12. Why all these short
well, in the meantime, there's been treatment. I got arrested, and I had to go to jail, and I had to, treatment, and then I realized I had a drug problem, and I had to do something about this drug problem. I've battled addiction my whole life, in one form or another, and this time I decided to do something about it for real. So I went to treatment, and one of the times I left there, I went to treatment, but I wasn't the best employee when I was using drugs. I wasn't, and I would like a chance to make up for that.
Were you fired at these places as you were addicted and didn't show for work? Or?
I got fired from Kia. And it was for not showing up on a Saturday. And then Mr. Flores fired me too one time. Most of the time, I just quit. These
dealerships have drug testing programs. Yours does. Okay. Would your sponsoring dealer like to? Are you from the sponsoring dealership, sir?
Yes, I am.
Would you like to?
I am Jim Florence, the dealer of Florence and White Ford.
Okay, sir.
And yes, George has been with us, sometimes somebody might say too many times, but we do give people opportunities. We like to give them second chances, and I was the one that fired George the last time. Now that we're hoping he's redeemed himself. He's spent the last 9 months getting himself back where he needs to be, and George is an employee we would like to have with us. We've had him in the past. We've always thought he was somebody worthy of coming to our dealership. But unfortunately, he has had problems that we don't acknowledge that it's acceptable at our dealership. So when it does get to that level, we fire him. It's just that simple. wouldn't matter if it was George or anybody else that worked for us. So in George's case, it's another chance of trying to give him another chance and see if he can get where he needs to be.
Question for, you're Mr. Florence?
Yes.
Any questions for Mr. Florence from the commission?
Yes, Commissioner Jackson, in reference to him being with your employer a couple of times, the time that you terminated, what was that about?
It was about drugs. No question. He couldn't perform his job.
Do you feel comfortable now? I mean, you fired him once before for the drugs addiction. Do you feel comfortable now?
You know, I do at this time. And I will tell you, the last time George came back, I wasn't. But he did pass a drug test. He did feel like he was, and we know George pretty well. We go back to 2011 or almost 2010 with George, so we know him pretty well. But the most recent time is the last time when we talked to him prior to bringing him back and trying to get a license for him was the most comfortable I've ever felt in speaking to George, because I have 4 kids at home. I've been lucky, you know, but on the other hand, not a lot of people do. So I look real hard. And in George's case, I've looked a couple times and wasn't happy. But in this time, I feel more better than I ever have.
And we verify that the sale of controlled substances were to adults, or is that in the record?
That's not listed in there whatsoever. It does not indicate it would have been to a minor. It does not indicate that it would have been close to a school. It's just this is just delivery.
Lawrence, can you verify any of the circumstances of the sale of controlled substances? Do you know anything about that?
The only I can verify is, you know, unfortunately, and we have dealers here that have car dealerships that probably understand this. They seem to run, when you have one, you may have another, and they seem to run together. And in the past, we've had a couple of them where, you know, where George is maybe work with somebody else, and they live in the same area, and they had problems. You know, so I know it's, from what I know of him, I know it's adult issues. I know it's him and his wife. His wife, he left it out of it, but his wife just got through rehab, and she's back to where hopefully she's going the right direction as a couple. So he left that out of it, but both of them are in the right direction, and they've lived in Sparta for some years. You know, we're all pulling for George, put it that way.
Any questions for?
Explain your drug testing procedures.
Well, prior to hiring, we send in local town, in our town of Smithville, is a company that does it for us, that we send them down for a drug test, and, you know, we look for the same thing, I think, that most places.
What about afterwards?
No, not at that time. What we're hoping for is we're keeping an eye on our people. We don't have a lot of employees. We're about 25 employees, so, and myself and my partner, we're at the dealership 6 days a week, so we feel that we keep a pretty good eye on them, but there's no guarantee.
Would you commit to 18 months of every month testing?
Oh, absolutely, surely.
At random
Yes.
periods?
Absolutely.
On this individual?
Yes,
You would commit to that?
I would.
You report that to this commission?
And yes.
Is that also a function of his probation? Does he go back for drug? Mr. Devine, do you go back for drug testing periodically during your probation? Is that random, or is that a regular schedule? Okay, so you'll be doing that through probation. Okay. Further questions for Mr. Devine or Mr. Florence? Here, motions either way to uphold the denial or to not uphold the denial.
I'll make a motion we grant Mr. Devine his license.
Motion? We have a motion to grant the license by Commissioner Trickett and Who seconded, please? Parr. Mr. Parr, Commissioner Parr. All right, any discussion of the motion? And the motion is to grant. Hearing no discussion of the motion, well, I'll call for a roll call vote.
Yes vote is to grant the license. Commissioner Hatcher,
Yes.
Webb,
Yes.
Commissioner Vaughn,
Yes.
Commissioner Parr,
Yes.
Commissioner Pirtle,
Yes.
Commissioner Trickett,
Yes.
Commissioner Murray,
Yes.
Commissioner Jackson,
Yes.
Commissioner Fox,
Yes.
Commissioner Cullum,
Yes.
Commissioner Clayton,
Yes.
Commissioner Clayton,
Yes.
Commissioner Bass, Commissioner Roberts,
Yes?
yes.
Yes. Fine. The Motor Vehicle Commission has granted you a salesperson's license. You're welcome. Good luck. Q.L. Hollow. Q.L. Hollow. Hollow. No response from Mr. Hollow. Will
Same as before, is convicted of a distribution of a controlled substance.
Commissioner Jackson, I motion that we uphold the recommendation of the staff.
motion, Commissioner Jackson, to uphold the denial of the staff.
Second.
Second by Commissioner Vaughn. Discussion? To clarify the motion is to uphold the denial, so a yes vote is to not grant the license. Any questions on the motion? Commissioner Stribling. I'm sorry, Director Stribling.
Hatcher,
Yes.
Commissioner Webb,
Yes.
Vaughn,
Yes.
Commissioner Parr,
Yes.
Commissioner Pirtle,
Yes.
Commissioner Trickett,
Yes.
Commissioner Murray,
Yes.
Commissioner Jackson,
Yes.
Commissioner Fox,
Yes.
Commissioner Cullum,
Yes.
Commissioner Clayton,
Yes.
Commissioner Roberts.
Yes. Denial is upheld. Ronnie B. Miles. Mr. Miles. Sure. All right. I'd like to hear from legal.
Yes, Mr. Miles, on his salesperson application, he was shown to have been convicted of the possession of a drugs of a Schedule II drug with the intent to sell or deliver.
Schedule II drug is,
Doesn't specifically say as to what type it was. It's just it goes to the culpability of the type of distribution that was actually done. So this one is indicated as a Class B felony that he was convicted of.
end of sentence is 11/18/19.
That's what the record had indicated, that it was to what would have been to November of 2019. But Mr. Miles, being here, could probably go on to explain as to those instances. Oh yeah, at some point in time, probation.
Yes.
Okay. Or you're currently.
Let's go straight to that question, and before your comments, sir, is that probationary?
It's probationary, yes, sir.
Okay, so you're on probation until 11/18/19. Add 5 years to that, and through our statute, he would be eligible 11/18/24.
Correct.
Okay, Mr. Miles, you'd like to tell us the circumstances, and frankly, what did you sell? All right, what did you possess? I'm sorry, possession with an intent to sell. So what did you possess and have the intent
Well,
to
at
sell?
that time, it was possession of cocaine. Now, would you like?
Yes, sir. Lean in just a little bit to the mic, if you would. Okay.
In 2009, and I'm not making this, trying to make up an excuse, because what I did was wrong. So I'm admitting to that. But, of a long story, but I was asked to do a friend a favor. And that favor was to pick up a package from one person and bring it to him, which I did. And here again, I know that that was wrong, but at the time, I guess I looked at it a little bit differently. And upon doing so, I found out that my friend was actually a confidential informant, and that's how I came about being in the position that I'm in now. But I'd also like to add that I've been in the car business for 30 years, and I've never had anything on my record anywhere close to this or any blemishes at all as far as my sales record is concerned. But I am admitting to the fact that I made a mistake.
Ask you about your application. It says dealer's name 5800 Crossings Boulevard. Is that the address or is that the name of the dealership?
Oh, that's the address. The dealership was Matthews Chrysler.
All print right above it.
Right above it, Chairman Roberts.
Got it now. Yeah. Thank you. So, and you have someone with you here from Gary Matthews, Chrysler Dodge Jeep of Nashville.
Yes, sir.
Okay. All right. Before that, any questions for Mr. Miles in regarding the circumstances of?
I was just going to ask you, you said you transported the drugs, but you didn't use any of the drugs?
No, sir.
You're not a user?
No, sir. No, sir. Never.
Okay.
Never. I would like to add, though, that due to my probation, I am required to do drug screens at their request. I guess that's part of it. But no, I was not and never have used drugs.
Were you having a good career selling automobiles?
Found what I thought was a great place to work. And I don't know that I'd be standing here now if I hadn't changed from one location to another. Because I've been working for the Matthews Group in Clarksville. And when I transferred to Nashville because of a better position, working for the same people, that's when all this came about.
This is a question that I have for you, sir, but also as applicants come through with similar circumstances, convicted of selling controlled substances. I hear from, I had a good career selling automobiles, I was making good money, then I start selling drugs. Is there that much more money selling drugs than selling cars?
That was not my situation at all. That was not my circumstances. I was, I mean, if you got time, I'll give you the story. I was, had gone through a pretty bad divorce, so I was living in a extended stay hotel. And I guess when you live around that element, you meet a lot of different people. Well, this so-called friend of mine had come to visit several times, and he knew some of the people that lived there. And I guess after 2 or 3 weeks or a month or so after me being there, he recognized somebody that he knew, and he simply called me and asked me if I would, that John Doe had a package for him, if I would bring it to him. And I agreed to do that twice. That's why I'm here. It wasn't for monetary gain because I never saw the money.
You didn't collect the money at all, or?
Well, yes, I did do that, but it was just from one exchange back from him to the other. And if you have any of my court records, it'll show where they actually had me on, where he was actually wired, I guess. The station will actually prove, to a certain degree, that the money was not for me. Documented, it's been gone over 1,000 times, which is, I guess, why my sentence was not as severe as it could have been, and the fact that I'd never been convicted of a felony.
Other questions?
Were you paid for your services?
No, sir. It was strictly here again. I guess you call it currying favor from at that time I thought was a friend. You know, if you bring this over for me, I'll give you a toaster, send you a customer. And that's basically what it was, because he actually worked in the car business as well. But he worked at a different dealership at that time. This was back in 2009. But no, I wasn't.
But you were aware it was drugs you were carrying?
I'll have to admit that, yes, I was. How much it was, and if you ask me if I ever physically saw it, no, I didn't. It was in a package. I went from one end to another. Start. Well, it was $150. The people that I picked it up from actually were staying where I was staying. My so-called friend at that time lived in Williamson County that didn't have train. How that was done. I picked it up from him and I delivered the money back to the people that I got it from.
Miles, you have a long time before you're eligible to get a license.
From what I've been hearing here today, I'm aware of that now.
Have a plan B?
Not really. I mean, it's just something that I've done consistently for the past 30 years, so I really don't know anything else to do.
Have you ever had a complaint filed against you with the Motor Vehicle Commission?
No. Well, not, no.
Brought somebody with you from...
Okay.
Yeah. I was going to ask any further questions for Mr. Miles at this moment. Okay, thank you, sir. Sir, would you identify yourself, and you're from Matthews?
Darren Matthews, Chrysler, that's correct.
Okay.
Good morning.
All right,
My
good
name
morning.
is Darren Simon. I'm a sales manager there. My history with Mr. Miles goes back about 10, 15 years. At a different troubles, and now he comes to us wanting employment. Part of that employment is a pre-screening drug employment. Happy to have him. I don't know the extent of all the... Doesn't have a license coming from one of our locations to the other. Caught us off guard in the transition. Merely down here to see if that was... I would love to have him on board. We would love to have him on our sales team. He's never presented a problem legally or with customers. Excellent salesperson.
In just a little bit, sir.
Sorry about that.
Maybe the last sentence. If you'd repeat
I'm
that.
happy to have him if we can clear him. We do everything the right way, and that's all I'm asking.
You're not from this store. This might be a question for Mr. Miles. But when you were convicted of this felony for controlled substances, did your dealership where you were working not fire you? Did they allow you to continue working there?
I wasn't convicted until November.
Or if your dealership has an employee who is convicted of a felony of selling controlled substances, you continue to employ that person?
Us, me personally?
The store you're in, you can't speak for the other store, but
Exactly. No,
I
sir.
find
We
that
would not
unusual.
At our location and our store, that is not the policy. No, sir.
What would be an offense for firing at your dealership? Would you if you're convicted of a felony, your job is not in jeopardy, and you continue to employ.
Absolutely. Absolutely. If you're convicted of a felony, your job is in jeopardy. Yes, sir.
Not at the other location.
My idea about the other location
That's
was
unfair for you to
transpired.
ask. Yes, sir. I understand.
Sorry about that.
That was inappropriate for me to ask you that question. Yes, sir. Mr. Miles. Aren't working. Where were you working when you were convicted? Apologies then to the Matthews organization. Where were you working? I got kind of, step up a little bit if you would, sir. Let me ask, where were you working when you were convicted of this felony?
Southeast Automotive in Nashville.
Okay, is that owned by the Matthews organization?
No, sir.
Okay, my apologies to the Matthews organization then.
Hence why I'm here, sir. He was employed with Matthews after this, under license from what I understand, transferred from the Clarksville location to my location here in Nashville. And I was thrilled to have him on board, only to apply for the license and be denied. That's why I'm here, sir.
My apologies too.
Oh, sure, absolutely.
To the Matthews organization.
Did he have a license from where he was transferred to your store while selling in Clarksville?
Yes, he came to us with a license from the other location in Clarksville, turned that in, and reapplied for the Gary Matthews on Crossings Boulevard with me. And then he was denied.
Mr.
Hatcher.
Supposedly now in the state of Tennessee, if you work for one dealer, you can work at any of his dealerships without transferring them. Is that true? Okay. And see, that's Gary Matthews and Gary Matthews.
Well, he came from, okay.
Came from Gary Matthews Clarksville to Gary Matthews in Nashville.
Let's hear from the legal staff.
See, I'm not for sure of our legal point. You know what I'm saying there?
The rule is that if they are licensed under the name of a dealership, whatever dealership they are licensed under, whatever that dealership's name on their license, whatever other dealerships that entity owns, they can work for. So many times you have, you could have, this is just an example, you could have Gary Matthews 1 LLC, Gary Matthews 2 LLC, Gary Matthews 3 LLC at 3 different dealerships. They could be all owned solely by Mr. Matthews. However, those 3 dealerships do not come under our rule for being able to sell at each of those dealerships because they're not connected legally in any way. The rule for salesperson's licenses are where all the dealerships are legally connected under one entity. So, just for clarification.
Did we verify that he got a legitimate license for Clarksville? That he had one when he reapplied here?
I don't have any of that documentation. I'm not sure if Mr. Stribling does.
Have a number. Sir, would you speak up?
Let me let you move forward, and let's make sure we heard comments by Mr. Miles.
Yeah, when I did my employee packet in Nashville, I actually turned in my license, and the office manager actually sent it in with my application to you all, or to the licensing board commission. And 7-8 days later, I was told that my license had been denied.
Further questions?
And yes, you left it blank on your application. Have you been convicted of a felony? You left that blank.
I wasn't aware of that, sir.
You answered all of them below that and above it.
Right, but here again, I wasn't aware of that.
More questions?
Commissioner Jackson.
Yes, sir. Commissioner Jackson.
I motion that we grant Mr. miles his license.
Motion by Commissioner Jackson to grant the license. Is there a second?
Second.
Second by Commissioner Hatcher. Any discussion of the motion? Have an extension. It'd be Commissioner Vaughn abstains. Call for a roll call vote, please.
Yes vote will be to grant the license. Commissioner Webb,
Yes.
Commissioner McNabb, Hatcher,
Yes.
Commissioner Vaughn, Parr,
Yes.
Commissioner Trickett,
Yes. Yes.
Jackson,
Yes.
Commissioner Fox,
Yes.
Commissioner Cullum,
Yes.
Yes. Sorry, Commissioner Cullum. I messed that up a little bit. Would you call Commissioner Cullum's name again and let him vote again?
Cullum,
Yes.
no.
I said yes.
Okay.
Is my
I won't
mic
ask him
working?
again.
Are we good now?
Commissioner Clayton,
Abstain.
Roberts,
Yes.
Mr. Stribling, you did not call my name.
Hurdle,
Yes.
yeses and 2 abstains.
Miles, you'll be granted a license to sell vehicles for the Matthews Company.
Thank you, gentlemen.
Thank you. Thank you.
Mr. Carlos Gonzalez. Carlos Gonzalez. Hearing no response.
Commissioner Jackson, motion to uphold the staff recommendation of denial.
Second that.
Have a motion by Commissioner Jackson to uphold the denial, seconded by Commissioner Vaughn. A yes vote will be to uphold the denial. Discussion. Director Stribling, roll call, please.
Commissioner Hatcher,
Yes.
Yes.
Webb,
Yes.
Commissioner Vaughn,
Yes.
Commissioner Parr,
Yes.
Commissioner Purtle,
Yes.
Commissioner Trickett,
Yes.
Commissioner Trickett,
Yes.
Commissioner Murray,
Yes.
Commissioner Jackson,
Yes.
Commissioner Fox,
Yes.
Commissioner Cullum,
Yes.
Commissioner Clayton,
Yes.
Commissioner Roberts.
Yes.
Yes.
Denial is upheld. I see no more appeals on the agenda. We'll move to the director's report. Director Stribling.
Find the 2 pages of the disciplinary action report. These are funds back to us, and the expressions are normally for about the same thing: temp tag logs, deceptive acts, advertising violation, unlicensed activity. And you'll find on the February of 2013, the department has had us start listing any kind of disciplinary action taken against the licensee, and you'll find 2 suspensions of license back there, both of them for default of student loans. That's getting to be a common occurrence. If a professional license holder is behind on a student loan or alimony payments of that nature, that's grounds for extension of the license, and we're advised of that from another department. System for the public to see. Also find the status about the dealers. We've been quite active in the last 3 months. Our records show we had 116 new dealerships or relocations, and the great preponderance of them are new dealerships. And we're 3927 on total dealers. Been little or no change in the other licensees except the salespeople, and the salespeople number continues to grow steadily. Remind the commissioners that our next meeting date is July the 15th and 16th, and that next month, or in July when you come, the Motor Vehicle Commission offices will be located in this building. The first week of May is the date for our moving. We'll be on the 5th floor, along with most everybody else that's in the Andrew Johnson Tower now is getting transferred out. Another thing happening, the Motor Vehicle Commission, along with other state departments, at the encouragement of our Deputy Commissioner and Assistant Commissioner, we're going paperless, and our staff has been since August scanning all new paperwork coming into the office. Originals are no longer kept. Been working frantically to scan the thousands of files that have been stored through the years, and Barry Whit, Jason, and the others of our staff are to be commended for that, because we're not going to have to haul many boxes, and we're not going to have to pay Richards and Richards to store them for the state. I'd like to thank the legal staff for the active part they're playing in the resolution of problems that the Motor Vehicle Commission has. Seems like it's a simple matter to open the mail and find a complaint and to send it up to legal. But as you folks on the Legal Review Committee see, a lot of effort, investigative effort, time to get things presented to you. Having the patience to go through an hour and a half of decision making every morning. And everyone that this afternoon the two committees are meeting, the Rules Committee at 1:30 in this office, same building, same office, and the Audit Committee at 1:30, room, 3rd floor conference room in the Andrew Johnson building, right down the street. Now the Audit Committee, Lynn Webb is chair, Mark Pirtle, Ronnie Fox, Wade Hinton, and Don Parr. So at 1:30, that's where we'll all be. Rules Committee, Chairman Roberts has asked that Ms. Farrah Vaughn serve as chairperson. This time, Stan McNabb is the named chairperson, but he's not here. Reed Trickett, Kevin Cullum, and John Murray, along with Commissioner Bass, are members of that committee. So you'll reappear over in this room.
Questions or comments for the director?
Jackson, I was told that I was on the audit committee, but I didn't hear my name called when I think I talked to Leslie one day this weekend.
Audit committees: Lynn Webb, Mark Pirtle, Ronnie Fox, George Bass, Wade Hinton, and Don Parr.
Further questions? Looking for more work? Commissioner Jackson? Real quick. All right. Hearing no questions, we'll entertain a motion to approve the director's report. Commissioner Purtle so moves.
Mr. Jackson,
Commissioner Jackson seconds. All right. All those in favor of approving the director's report, say aye.
Aye.
All those that oppose, say no. The director's report is approved. Legal report, and I don't see it in writing here, but normally the legal report contains legal review.
It would be part of it. The legal report was presented this
We'll
morning.
accept that as normal.
Yes,
procedure.
it was done this morning. That
Yeah.
should be part of the agenda.
You want to do that first?
Yes.
Okay. Proceed. Or does Commissioner Jackson want to proceed? How do you want to?
No.
Just so long as we know we have there was one change that I noted.
That's it.
Okay.
Okay. Go ahead and make that one change, and we
It
can
was
motion to it.
on page number 9,
Right.
number 31, case number 20130027731 for the recommendation to authorization of the civil penalty. Total amount should be read $2,000, not $3,000.
How many cases did you review this morning? Did the committee review?
70.
70.
70.
There was 70 line items, probably makes up originally, I think it was between 100 and 115 actual individual cases.
Motion, Director.
Motion.
Commissioner Jackson, a motion that we accept the legal review
Second.
report.
Action is seconded by Commissioner Hatcher. All those in favor of approving the legal review committee report, say aye.
Aye.
All those opposed, say no. That's approved. Okay.
I'm up.
Ms. Ryan is up.
Yes.
Ms. Ryan.
First of all, you should know, and you probably already do, that Tony does a very good job of getting the legal reports done. He is inundated with complaints because people like to complain about dealers, as you well know. But he does a really great job. The case that we have today to present to you is a case that you all gathered for a formal hearing for me, and it was continued. We had Judge Wilson there, and that was the matter of Pars Auto Sales. At that time, the owner did appear. It would have been a default, but he did appear, and after discussion, it was recommended and strongly discussed that it should have been continued. That hearing date would have been tomorrow, except Mr. Pars did hire an attorney, not Mr. Pars. The owner did hire an attorney, and we didn't negotiate the terms of the civil penalty because the original penalty that was proposed was $7,500, I believe. And we had enough proof to support that $7,500. But we did agree to allow him to pay it in installments so that he could have until June 30 of this year to pay it off, and that's the terms of the agreement. He will pay a $7,500 civil penalty. He will pay the current court costs, which are just $200 at the moment, and he will pay that as follows. $3,700 is due before April 30th. $2,000 is due on or before May 31st, and $2,000 is due on or before June 30th. There is a provision in this document that if these terms are not met, the license would be automatically revoked with no further hearing, no further appeal. This is what was agreed to. It has been signed off by the attorney, Bob Travis, for the company, and the respondent was signed for by Rashid Narazi, and that's the gentleman who was here before us last month. If this commission approves, I do have a space for you, Chairman Roberts, to sign. It will then be filed with the clerk's office, that is the APD's clerk's office, and will be go into effect. Does anybody have any questions?
The original amount
Was
of the fine
$7,500.
was agreed to?
Yes. This was as you don't know me yet, but I don't like taking things before any group where I can't prove it all. The burden is on us to prove it. In this particular issue, I could have proved it. Having said all that, there have been changes and moderations he has attempted and continued to attempt to make sure things are correct. That was what was proposed. There was probably a understanding of English translation issue that could have been there. In any event, it was agreed to be paid what was proposed, plus the court costs, and that what we did agree to is just give them an opportunity to pay for it over time, which is not unreasonable considering the dynamics of our whole society.
Questions about the agreed settlement for Mrs. Ryan? My job myself. That's good. I like when we can prove the facts.
I do too. I don't really like. I'll be honest with you. You haven't seen me yet, but I'm a very aggressive trial attorney. But I really like to have the facts behind me. And having said that, I also think it's appropriate if we can get it resolved without having a full hearing. It's better on everybody involved. That means that the business will go on, which is a good thing for our society as well, as long as the actions and problems are attended to, and they were. And if this commission agrees, I will then have Mr. Roberts sign this. I have the fax copy of it. Well, we're going to sign the fax copy of it. It was faxed to me by the attorney, and we'll sign the fax copy of it, knowing that I may or may not get the original later, but it will be sufficient.
We'll need to make a motion to
Make a motion. We accept.
that we approve. What we're making the motion about is to approve the agreed order. Am I
That's
right,
correct.
Ms. Ryan? Okay, and so that's what Commissioner Hatcher moves.
That's what I'm
and-
making the motion, that we approve the direct
and
order.
Someone seconded. Seconded by Commissioner Clayton. Any discussion of the motion? Hearing none, I call for a roll call vote. Yes.
Yes. Yes.
Yes.
Yes.
Yes. Yes.
Yes.
Yes.
Yes.
Can I approach to have you sign it while you're sitting there? Thank you.
Great, that'll save everyone some time. All right, so the agreed order has been approved by the commission. Nice work by the staff. I'll get a special pen for this, or?
Money.
Okay, next item under legal report, discussion of motion of declaratory order.
Thank you. Just to start out, the commission has the authority under the UAPA, Uniform Administrative Procedures Act, to hear what is considered to be a declaratory order, which is generally to hear the applicability of any of your statutes. From time to time, we have petitioner persons that are licensed by us out there that approaches the commission and files a motion, asks the commission, we would like you to hear a matter we would like you to hear a matter between parties and make a decision regarding that matter. Generally, the mechanism that they do in order to have that heard is that they would send a petition for the declaratory order to the Motor Vehicle Commission. It goes to my office, and then I see that. And attached along with that is a motion for that petition to be heard. So generally, what you have today is you have someone requesting that the Motor Vehicle Commission in the future make a decision on the applicability of the statute. And they have come today in order to have the commission to make that determination of whether or not that should be heard in the future. The commission has a discretion to not hear a declaratory order. You can pass and say no thank you, and that would give the petitioner the ability to go to the Chancery Court here in Davidson County to have that matter heard, should they choose. So what you have today is you have two parties that are here today. You have the petitioner, who is Gary Matthews Kia, who is being represented by Mr. Jim Cameron, who's sitting here. And then you also have representation from the manufacturer, who is Kia Motors America, Inc., who's represented by Mr. John Ross. There he is. Also behind me, and Mr. I believe what should transpire is that Mr. Cameron would come and make his motion to the commission on behalf of Gary Matthews Kia, and the commission can hear him as to his motion and what he would like the commission to do, and then Mr. Ross would have a chance to respond to his motion. And then if the commission has questions regarding any of this, you can ask me at any point in time, and I would really just like to give you advice basically on what legal authority the commission would have to do in the future. But I can say confidently before we begin that at the end of the day, the commission has the ability to grant or deny Mr. Cameron and Gary Matthew Kia's motion to hear a declaratory order in the future. The restrictions of exactly what that order, what that authorization would be, may become contentious here in a few minutes, but you do have that authority, and I will coach you along the best I can. With that being said, I would like Mr. Cameron to come up, if he could, Mr. Chairman, to make his motion before you. If you have any questions prior to that happening.
One, will the commission be allowed to ask questions of counsel as we
Yes.
go, or only through our own counsel?
No, yes, you can ask either Mr. Cameron or Mr. Ross to explain what their motion is, or exactly what they're asking the commission to do or not to do. That's very straightforward. The only thing where I would interject, whereas if they're trying to indicate to you what they believe the law is, since I am your legal counsel, I can let you know what my opinion as to what the law is or would allow.
Will the manufacturer in this case is here to oppose the petition for declaratory order?
I do not know his intentions.
We'll find that out. Okay.
But you would find out.
Okay. All right. All right. Mr. Cameron.
Ross is asked to be able to set a court reporter up so he can record this. If we could wait just a couple of minutes and let that.
That'll be fine, sir. Yes, sir. While we're setting up, this is a good chance for a 5-minute break for the commission members. Thank you. Good suggestion, Mr. Jackson. That'll work. You kind of saved the day there, Commissioner.
The wedding was last week. So all is done.
When I see you hauling around boxes, I don't think you've gone completely paperless.
it doesn't come to me, no.
A lot of paperwork on this deal we're talking about here.
Have you changed your last name?
I have. I got married about a month ago.
Well, good for you.
And
You could be going to a lot of Ole Miss games this year.
oh, yeah. We'll be tailgating in the Grove, and I went to state.
Oh, my goodness.
But I've had to switch teams.
That's,
So I told everybody, I was like,
I'm not go to Roca.
we don't do that. Crazy stuff. It's just
well, everything looks like it's going to be a good year for Ole Miss this year.
Yeah, I think so. And
So-
I really like the coach that's there.
Yeah.
His wife was my teacher in high school, and
Really?
she is first class.
Really?
I'm 10 years older than him, but whatever. So it's a small little world.
It is.
On Baughan. Yep. Works for Federated Insurance. Yep. It's kind of, I know, isn't that crazy? I got a text message from the Zurich rep said, I hear you're marrying the Federated guy. And I was like, where'd you hear that? Haha.
I think you better get his price right.
That's what I told him. I was like, this could be awkward. Renewal's coming up next week.
John Murray.
Exactly.
What you said.
Oh, yeah, and you know what's bad? Is I know I'm getting an increase.
Oh, no.
Yeah. It is. It's very nice.
No, sir.
Are they national?
Yeah, they're based out of Owatonna, Minnesota. I was actually with them before he started working for them.
Written my insurance several times. They're a
Yep,
good
same
company.
here.
Good
Yeah.
company.
I've had him this last year. I don't know about next year because renewal's next week. That'll be fun.
Federated, you said?
Everyone in place? Director, you think we have everyone? Best I can tell. Cameron, proceed, sir.
May it please the commission, my name is Jim Cameron. Along with Patrick Merkel, we represent Gary Matthews, who is seated here today. Mr. Glandorf and I will agree about many things. We may disagree about some things. As he said a minute ago, you do have the power to convene a contested case hearing in this matter. I agree with him about that. What I think this case is about is whether or not this commission has the power to become involved in a dealer termination before the dealer is terminated. And I believe that for two reasons. First reason is because of the history of case law in this state that goes back to Pace versus Ford Motor Company, and then was followed in the Capital Chevrolet case, a case that Mr. Ross was involved in back 30 more years ago. In that case, the Tennessee Supreme Court said the following: From their inception, the Tennessee statutes have given the Commission jurisdiction to revoke licenses of manufacturers who dealt unfairly with dealers, including failing to make timely delivery of vehicles, inducing dealers to enter into improper agreements by threats to cancel franchises, forcing unneeded or unwanted merchandise upon dealers as a condition to renewing franchises, improperly terminating franchises, forcing dealers to accept deliveries by specific means of transportation, and entering into franchise agreements with dealers not equipped to provide consumers with services warranted by the manufacturers. Mr. Justice Harbison went on to say, admittedly, there are some differences between terminating existing franchises and the creation of additional ones, but both may involve serious manufacturer-dealer disputes. As stated earlier, the previous statutes, which were sustained in case, gave the Commission authority to resolve disputes concerning the termination of franchises. That's the Tennessee Supreme Court speaking. It doesn't get any better than that when you're a lawyer practicing in this field. But we also have your own rule that dates back to 1974. This rule is 0960-01-.06. This rule is entitled Notice of Termination, Cancellation, or Non-Renewal. It's got two big sections. First section says that if a manufacturer is going to terminate a dealer, they must give at least 60 days notice to the dealer and to the Commission. The second part of this rule says failure of a manufacturer to keep the franchise in full force and effect pending a final determination by the Commission or to abide by the Commission's final order may result in the Commission's refusal to issue a motor vehicle dealer's license to another dealership selling the same trade name and like make of motor vehicles as the affected dealer or doing business in the same relevant market area as the affected dealer. This remedy is in addition to any other remedy provided in TCA 55-17-101 et sec. Now, there's only one way that you can read that rule, that the Commission has the power to hear a dispute over a dealer termination before the dealer is terminated. Otherwise, the rule makes no sense. You should also be aware that when this was promulgated in 1974, it was approved by the Commission, by the legislature, and by the Attorney General's office, and it's been here since 1974. I do not believe that anyone can make an argument that you are powerless to act in the face of a dealer termination until you wait until Kia terminates Gary Matthews and then decide whether the termination is wrongful or not. I think this is where Mr. Glandorf and I may have some difference of opinion, because when he talks about we're asking you to do something in the future, well, anytime you set a hearing, it's going to happen sometime in the future. But what we're asking you to do is to convene a contested case, listen to the facts, and then decide if, based upon those facts, you apply the law that gives you the power, whether or not this is a wrongful termination and would therefore violate the law or not. We're not petitioning you to do anything to Kia. We're simply asking you to convene a contested case and give a fair and impartial decision in this matter. The procedure that we're trying to follow here is the same that's been followed in recent cases that have been filed with the Commission. We did two things. First, after speaking with counsel for the Commission, we understood that they would prefer to see this kind of matter come as a declaratory order matter. So we prepared a declaratory order petition and filed it. But at the same time, just in case somebody changed their mind about the procedure, we also filed a complaint and a protest. And what we're asking you to do is to convene a hearing and listen to the facts of this particular case. A declaratory order is in the nature of a declaratory judgment. The Tennessee Supreme Court has recently noted that the purpose of declaratory judgments is to settle important questions of law before the controversy has reached a more critical stage. We're asking you to convene a case and listen to the facts. I want Kia to explain to you why they believe it's justified to terminate this dealer when in 15 of the 18 months prior to them sending him the notification letter, they paid him extra bonus money for meeting or exceeding his sales plan, his quota. There are a lot of facts that would be involved in a case like this. In our petition, we also asked the Commission to request of Kia if they would voluntarily postpone the termination until a hearing could be held. We didn't tell the Commission that you should instruct Kia about anything. We said request. And I agree that the Commission does not have the power to enjoin Kia. But if Kia decided to move forward with the termination after you had decided to convene a contested case, in that case we would be left with a choice of going to Chancery Court in Montgomery County to try and stop them. Now, your own rule says you can apply for a injunction and you don't even have to post a bond. But the Commission, to my knowledge, has never even done that. But think about it. Why would your rules say that you could apply for an injunction if you didn't have the power to hear the matter before the termination occurred? It just makes sense. The Uniform Administrative Procedures Act applies to these types of hearings. And it says in the rules of the Secretary of State, it says that you can convene a contested case by requesting one, and it says that the Commission shall issue a notice and shall set a hearing. It doesn't say maybe. Now, you could decide, I agree with Ms. Glandorf, you could decide that you don't want to hear this. And if you made that decision, what you would be saying to all other dealers is that this Commission and this law cannot help you in a dealer termination case. And so the next time that a dealer called me and said, I've been getting these threats, what can I do? I would have to say, you're on your own. Sorry. But we need you to give us a date for a hearing. The Administrative Procedures Act says that if you accept a case, you must set it for hearing within 60 days of when you get the petition for the declaratory order. Not that you have to hear it within 60 days, just set a hearing date. I suggest that we set this for a hearing in January of 2014. That gives all of the sides plenty of time to do whatever you have to do to get a case like this ready. I don't think anything shorter than that is really feasible. Certainly not at the next meeting of this Commission in July. There's a lot of work that goes into these cases. And what we're asking is not putting a burden on your counsel. Your counsel works very hard and deals with a lot of different things. But the litigants here are Gary Matthews Kia and Kia Motors America. And their counsel are the ones that do everything. Your counsel doesn't have to take a single deposition, file a single motion, or do anything except observe the proceedings. An administrative law judge would be appointed who would sit with you during any kind of hearing and would assist with questions of law and other procedures. The Attorney General's office, in a very recent case, wrote on your behalf Administrative agencies are authorized to consider the validity or applicability of statutes within their primary jurisdiction. And they cite 45223, authorizing administrative agencies to convene contested case hearings when petitioned for a declaratory order as to the validity or applicability of a statute, rule, or order within the primary jurisdiction of the agency. An administrative agency should be permitted to consider and rule on fundamental issues that deal with its own statutes that bear on the agency's authority to hear a particular dispute. You are empowered by the legislature and the rules to be the fact finder, to apply the law to the facts in a case like this. You need to observe the demeanor of the witnesses. You need to figure out who's telling the truth and who's not. You need to listen to cross-examination. You need to determine how much credibility the person who signed the termination letter has when he's never even been to the dealership. I'm reminded in a recent case before this commission that involved Kyle International Trucks. This commission voted 3 times to take jurisdiction and convene a contested case. But somehow, it never got convened. I don't know how, I don't know why, but it was a mess. Let's please don't let that happen again. This is a matter of the highest importance to all dealers in this state. If you have any reservations about whether you have the authority to hear this, then you can always schedule a hearing in July just to determine whether or not jurisdiction is proper, and let any and all parties weigh in, because there will be others that will want to join this fray. But I believe that you do have the authority given to you by the law, given to you by the case law and the statutes. And I don't believe that you're powerless. I believe you can entertain a declaratory petition for declaratory order and or the complaint that we filed. And I believe that you can do that. And I suspect that Kia Motors would probably agree to postpone the termination until this happens. I would certainly hope so. That's normally what happens. But you have the power to do it. Just because the termination has not happened yet does not mean that you can't get involved and adjudicate the rights and the privileges of the parties. Imagine if you wait and the termination occurs. That toothpaste is out of the tube and you aren't ever going to shove it back in. That dealer is dead. He has suffered irreparable harm. His people are out of work. And does that really do Kia Motors any good either? I suspect not. But what we're asking today is to give us a date, January of 2014, to hear this case. And all we're asking for is a fair shot. We're asking you to make a fair and impartial decision after you know all of the facts. Gary Matthews, who was the first Kia dealer in Middle Tennessee, deserves nothing else. Thank you.
Members of the Commission, my name is John Ross. I'm with the law firm of Neal and Harwell here in Nashville, and I'm here today on behalf of Kia Motors America Incorporated. What started this current controversy was a letter attached to Mr. Cameron's pleadings filed herein, the petition for declaratory order and the petition for a contested case hearing. That was a notice that went out on February 15, 2013, a 90-day notice that after 7 years of trying to have Mr. Matthews Kia franchise improve its sales performance and other items which were a breach of his dealer agreement, that they gave notice that in 90 days, which from the receipt of the letter, which would be May 20th of 2013. The fact is that we're dealing with two particular provisions of the Tennessee Motor Vehicle Commission statute, and they involve and deal with termination of a dealer. Let me talk to you first about the provision of Tennessee Code Annotated 55-17-114-C21. And this particular statute empowers the commission to take action to revoke the license or suspend the license of a manufacturer if certain things are done by that manufacturer, and it also applies to distributors. C21 says prohibits the commission of any other act prejudicial to the dealer by threatening to cancel the franchise agreement existing between the dealer and the manufacturer or distributor. There is manifestly been no violation of this provision, because it goes on to say that written notice in good faith to any dealer of the dealer's violation of any terms or provisions of the franchise agreement shall not constitute a violation of 55-17-114 subsection C. Now, the letter that was sent was a good faith statement of how Mr. Matthews' dealership there in Clarksville has violated his dealer agreement. So there is no violation of subsection C21. We, Kia Motors America, Inc., had the absolute right to notify this dealer after long suffering with him, trying to get him to improve his sales performance, that he'd violated his dealer agreement. And so C21 has not been violated. And nor has subsection C3 been violated. That also is a licensing provision that empowers the commission to revoke or suspend the license of the manufacturer or the distributor who has done that which is prohibited in subsection C3, and that is that they have unfairly or without due regard to the equities or without just provocation canceled the franchise agreement of a motor vehicle dealer. I'm sorry. There has been no violation of this provision. What has been done is to give the required 90-day notice under the dealership agreement, notifying them of the intent to do so. It has not occurred. It won't occur at the earliest on May 20th, 2013. Now, the fact is that the cited provisions that Mr. Cameron has cited they deal only with licensing, and licensing specifically of the manufacturer or the distributor. Now, the fact is that subsection C3 and C21 authorized, all that it authorizes the commission to do is to deny an application for a license or revoke or suspend the license of a manufacturer or distributor under certain circumstances. We've already established that C-21 has not been violated because the statute specifically says it doesn't apply to a notice to the dealer in good faith. And you notice that Mr. Cameron has not said in his pleadings that Kia has failed to act in good faith. He hasn't said that. There is no violation of C-21, and there has been no violation of subsection C-3. For the reasons I've stated, there has been no termination of the dealership. Now, the plain fact of the matter is Mr. Cameron is relying upon this rule that he cited in his pleadings, and that rule, members of the commission, goes beyond TMVC Rule 0960-01-.06, parens 2, close parens, goes far beyond what is authorized by the statute. What the statute, all the commission is authorized to do under the statute, if there is a violation, is to revoke or suspend the license of the distributor or manufacturer. And of course that is a very, very powerful provision. And it's a powerful provision because if the commission acts under that, which that's the only remedy that is afforded to the commission under that particular statutory provision. If the commission does that, it has the power to do it if there is indeed a violation of subsection C-3 under the statute. What it does, the effect of that, and every member of the commission is fully aware of it, what that will do is to put every Kia dealer in Tennessee out of business if they're prohibited from acting as a distributor or manufacturer under the statute. It's a very, very strong penalty. But there is no action to take now because there has been no violation of that provision. You say, well, they've given notice of their intent to do so. Does that authorize the commission to act? The answer is no, not in the way that Mr. Cameron would have the commission act. The fact is that Mr. Cameron's client, Gary Matthews Kia, there in Clarksville, does not have a private right of action under the Tennessee Motor Vehicle Commission statute. If the commission believes that there is a serious danger of an abuse under this statute, the commission's remedy is to proceed under 55-17-117 subsection B, and that's also cited in Mr. Cameron's papers. And what this is, that would involve the commission requesting the Attorney General of the state of Tennessee to file suit in court against Kia Motors of America and seek injunctive relief to stop Kia from terminating the dealership owned by Mr. Matthews. Now this, what I'm saying to you is the proper form for Mr. Cameron to be proceeding in is in court, not before the commission on this, in this dealer termination case. You heard him talk about the Capital Chevrolet case that was decided 30 years ago in 1983, and Mr. Cameron told you accurately that I was involved in that case from the start to the finish. That was a dealer addition case. It involves a different section of the statute that specifically does give to a dealer in that circumstance a private right of action to proceed in front of the commission. That is TCA 55-17-114 C-20. They are not proceeding under C-20, and the statutory language is markedly different in the two statutes. And so that, when I first got out of law school, when I first got there, I had to go and get a Black's Law Dictionary to carry it around so I could figure out all this terminology. And I also had to have a regular dictionary. And lawyers talk about what is holding in a case, that is what the law is, and what is dicta in the case. Anything they said about terminations in that case was what's called dicta and is not binding. Dictum means that it was unnecessary for the decision in the case. And what they held in that case was they upheld the decision of this commission when the commission, after a long hearing, decided that Chevrolet, with Division of General Motors, was not authorized to put a fifth Chevrolet store dealership in Nashville. That's what that case was about. It had nothing to do with dealer termination. Had everything to do with the dealer addition case, and it proceeded under subsection C20 of the statute that enables this commission to act. This commission is empowered to act in accordance with the statute which created it, and that's what both Mr. Cameron and I have been talking about, that particular statute. The rule that he referenced, quite frankly, goes beyond the authority given to the commission under TCA 55-17-114, C3 and C21. This rule is not authorized by the statute because it exceeds by quite a bit what is authorized by the statute. All that the commission can do in this case is decide whether or not Kia Motors of America's license should be suspended or revoked in the event some action is taken that the commission finds is improper under the statute. And I've already established that C21 doesn't apply. It applies in this sense. It doesn't apply in the sense that what they did, what Kia did when they sent their notice to Mr. Cameron's client, telling him that he was in breach of contract. If you look carefully at the statute, what it says is that it specifically authorizes what was done by Kia. It says written notice in good faith of to any dealer of the dealer's violations of any terms or provisions of the franchise or contractual agreement shall not constitute a violation of subsection C. And they're referring to 55-17-114 subsection C. That is the section they're referring to. Now, having said these things, we believe that Mr. Cameron's remedy, if he believes that there is that his client's contractual rights have been violated, is to bring suit in court to redress it. And there the court can address, or usually it's done by agreement, the court can address whether or not the termination may proceed or if it's to wait until the matter is adjudicated by the court. And quite frankly, we would be willing to talk to Mr. Cameron about what ought to be done. We think the proper forum here is not in front of this commission. The commission's power in this is limited to as far as giving a private cause of action to a private individual. And the private individual here involved is Gary Matthews Kia in Clarksville. But the commission's hands are not tied if the commission believes that Kia Motors of America is about to violate the statute. You are free to confer with the Attorney General of the state of Tennessee about bringing suit, not on behalf of Mr. Cameron's client, but as the commission itself would bring suit against Kia Motors to stop the termination. That is the mechanism that has been provided in the statute. And Mr. Cameron, being the thorough lawyer that he is, also cited that in his papers that he has filed with this commission. Now, having said these things, I would like to say once more, there has been no violation. There's nothing for the commission at the present time to adjudicate. C-21 I've explained, and in C-3 the termination is not to take place until May the 20th. And if Mr. Cameron would get in the right forum, then we would be willing to discuss with him whether or not the dealership franchise would stay in effect pending the adjudication by the court in a proper form. But after the court adjudicates it, if the court found that Mr. Matthews' dealership had not violated the franchise agreement, and therefore that they were not, it was not permissible for Kia to terminate them under the contract, the commission could then convene a hearing to determine whether or not there was a violation of the provisions of the statute that would require Kia Motors of America to lose its license or have his license suspended in the state of Tennessee. And these are legal arguments, but I hope that I've made them as plain as I can, because I don't think that it is proper for the commission to convene a contested case hearing in regard to a statute that doesn't give Mr. Cameron's client a private right of action. And that's been the law. The law on this matter has been settled, as he said, a long time, since 1980. There was a case involving white trucks that was adjudicated in the United States Bankruptcy Court for the Middle District of Tennessee. And what the court said in that case, I think, is telling. If I may find it here. This was a dealer termination case, and this is what the United States bankruptcy judge said. This is what the court said. TCA 55-17-114 allows the Tennessee Motor Vehicle Commission to revoke the license of a manufacturer who unfairly terminates or fails to renew the franchise of a motor vehicle dealer. All right, and that's the statute I've been talking about. But he also goes on to say it does not create a private cause of action or prohibit termination. And that's what the court found in that case. And that's what I've been trying to communicate to the members of this commission today. I will be happy to answer any question that you gentlemen and ladies may have, but I have concluded my argument, and I very much appreciate your having allowed me the opportunity to appear before you to make this argument today. Thank you very much. Counsel, do you want to, our counsel, do you want to comment at this time, or do we want to hear, do we go into rebuttal form? Or
Yes to the latter. I think if the commission members have questions, they can ask them. Either party, Mr. Cameron or Mr. Ross, if they could clarify some issues or exactly what they're asking you of, or whatever other questions that you may have.
I'll be happy to answer. Any questions for either of counsel by commission members? Mr. Parr, Commissioner Parr, for which counsel?
Why Can you ask why they're trying to cancel a franchise? Is that... Why does Kia want to cancel the franchise?
I'm sorry, I don't hear as well as I used to, and I apologize.
Why does Kia wish to cancel the franchise?
Because they have borne with these people for 7 years, all set forth in the letter. They've required them to get in their dealer improvement program. They've been in it. They've executed, if I can find it here, as an example, during that 7 years, they put them in that in December 1, 2005. It's now 7 years later. We're in 2013. So they've been bearing with this dealer for 7 years, trying to get his sales up. And it says, during the 7 years, it has been on Dealer Improvement Initiative, which is one of their programs to cause the dealer to improve its sales performance. The dealer, in the 12-month period ended November 30th, 2012, the dealer's DSI, which is Dealer Sales Index, was 54% below regional average and 56% below the state average, and in each case worse than the corresponding numbers in the previous year, 2011. And further, the dealership ranked last in sales effectiveness among all Kia dealers in Tennessee during both periods. That's one example of the reason why. They're set forth in Exhibit B to Mr. Cameron's pleadings. This letter is set forth. And they go on. In July 2012, they gave them an additional cure period. And based on the same goal of achieving 75% of regional average, and they set an updated monthly sales target for the dealership. In the last 6 months, the dealership hit the monthly target only once and averaged 26 sales per month, and they were supposed to be selling 45. In addition, it says the most recent 3-month period for which data was available at the time the letter was written, the dealership's DSI was 50% below the regional average and 52% below the Tennessee average. This is not a dealership that has performed very well, and it's not like that they've gone in all of a sudden and said, we want to terminate you for bad sales performance. And there are others, not just limited to sales. It has to do with service as well. The dealer's performance in 2012 in regard to service satisfaction was next to last among Kia dealers in the state of Tennessee, second from the bottom. So this is not a stellar performing dealer that that they've seen fit to write this letter to give them notice of termination, 90 days. I hope that I have answered your question. That's the reason why that they gave in their termination letter, and it's done with deliberation after having borne with this dealership for over 7 years, wanting him to improve and trying to help him to improve. I'm sure Mr. Cameron will have some things to say in response, but I didn't want to get into all the merits of that in my argument. But you asked, and I've given you the best answer that I'm able to give you. Okay.
If I might make a comment on this, if we get into the facts of the case very deeply, and we are making a determination on this petition, those are two different animals to me. If we're going to get into the facts of the termination, then my opinion is we'll need an ALJ to sort these things out, which is our normal procedure. Now, keep in mind that the petition today is for either a contested case hearing or a hearing to determine whether or not a contested case hearing should be granted at a later time. And I would like to say maybe councils each agree on one thing. It's not in dispute that a manufacturer has the right to cancel a franchise. What is in dispute is whether or not the dealer has a right to a hearing before he is actually canceled. Am I both councils? I don't want to put you in sideways with your clients, either of you, but I want to get us.
You have, Mr. Roberts, you've summed it up, and our position is that there is no right to a hearing statute under the dealer termination provisions, unlike the situation where you have a dealer addition, the example of Capital Chevrolet. And there have been other dealer addition cases that this commission has adjudicated and has passed on. But the statute, if you look at it, is quite different than it is in C-20 than it is in C-3 and C-21. It is absolutely clear under subsection C-20 that the commission has the right to convene a hearing and a contested case hearing before that new dealership is established. It is also absolutely clear under the statute that the subsection C-3 and C-21 does not, it's not the same, and it does not enable the commission to require that hearing before this dealer is terminated.
My effort here is just to put things in the big end of the funnel and have them come out the small end. And
without commenting on any of the facts of the case, because I agree with Commissioner Roberts that that's for a different time. But if you will notice, this is the same argument International Trucks made against Kyle. It's the same argument that every manufacturer that appears here makes, that you're not the right forum to hear this case. Now, if you look at the legislative history here, you were created by the legislature for exactly that reason. You bring the expertise of people in the industry on the dealer side, the manufacturer side, and the consumer side to hear a case like this. If not you, who? A chancellor who has never been involved in the car business? Some other judge somewhere who knows nothing about the ins and outs and intricacies, I'm trying to say big words with cotton mouth right now, I apologize, that just don't know the business. What we're asking, and I'm asking today, because of this 60-day provision in the APA, if we come away from here today without a hearing date, that 60 days will expire. And in that case, it goes to Chancery Court. I don't want to see that happen. I want to see you be able to do your duty. We're not asking for a private cause of action for Gary Matthews. He's not asking for any personal relief. What we're saying is that you, as a constitutionally established entity, have the right and the power to interpret your own statute. And I suggest that that interpretation is that you have the power to entertain this dispute before the dealer is terminated. And that's set out in the Capital Chevrolet case. I agree it was an ad point case, but what you've got to understand is that General Motors came after the commission with all guns blazing and attacked everything about this commission. And so the Tennessee Supreme Court was well within its power to say, and I quote, as stated earlier, the previous statutes which were sustained in Pace gave the Commission authority to resolve disputes concerning the termination of franchises. And then when you look at your own rule that says that if they don't agree to keep it in place pending a hearing, that can only mean one thing. You've got the power. Thank you.
Did you want to? Thank you for the, we appreciate that, and that's what we,
Make the motion to hear it then, or?
a motion can be made at any time. Then we discuss the motion.
Could be hearing it. And I would like to make a motion that it be set and be heard. If we can, if it's legal, if that's the legal right.
I think we will have to be more specific because we're considering the petition is for either a hearing to determine whether or not we will give a contested case hearing at a later date. And that request was at our next meeting in July. Or the commission can, or your motion is the other choice on the petition, and that is to go straight to a contested hearing. And of course, we have, this is not your
Go to
motion.
the contested hearing, then we can have it in January. That gives both parties time to do that. Is that correct?
That is the request.
Yes,
I'll
sir.
give you my opinion about that, is that is up to the ALJ. If a contested case hearing is granted, that would be up to the ALJ to get with the two parties upon an agreeable date. We can't tell the ALJ, the administrative law judge, when to be here. Am I correct, counsel?
Well, yes, on the dates, there are dates that we do have generally in January. The semantics of how it works is that the Secretary of State's office provides us with the dates for the year 2014, roughly this October 2013. Scheduling anything prior to that would be, we would schedule it contingent that the Secretary of State's office could not provide an ALJ on that date, which I can't say for certain, but I would feel strongly that if we had something set, that the administrative law judge would be assigned on that date. So I really don't have any issues whether or not it could be set in January if the commission would like to hear it. We had already planned on attempting to hear a different type of formal hearing in January of 2014, but I would say that you as the commission can indicate what the priorities are. So instead of hearing a formal hearing in January, that you all could hear this this type motion. But I would advise that you do clarify exactly what do you want to hear, because you've had a request, a motion for a declaratory order to be heard, which was one thing. And then secondly, I believe Mr. Cameron has come forward and asked that there be a contested case convened regarding, tell me if I'm out of turn, but regarding whether or not the manufacturer may may terminate the franchise agreement with Gary Matthews. And so there's really a motion we've had for one thing, and then we've had a second thing come up.
And I'm not here trying to kill that motion verbatim, but I'm trying to help clarify that and craft it, because we have a petition, and we can. My understanding is that we don't have to grant the petition. We can grant parts of the petition, but there are other things involved. Now, that might go into two different motions, actually. I guess you could have a motion for one area and then have another motion. I think for clarification, we're going to have to address all the items in the petition, and not do it and state that we're not going to do it. So I hope I didn't muddy up the water.
No, I think you have valid concerns that the petition for a declaratory order, and as your attorney, I would give you legal advice as to what I believe your authority, where it stands, so that you may know my opinion. And the declaratory order request, a petition for that, the commission, in my opinion, does have the authority to hear a declaratory order. And that was what the motion was set for today, was to hear a declaratory order. There were other things in Mr. Cameron's petition that it asked for 3 or 4 things at the end, so I think it's prudent just to kind of explain exactly what you want to grant today or deny today, so that you have that set out. Now, that is completely separate from what would the commission say at a hearing for a declaratory order. That's something completely different, and they would if one was to be had, they would argue for that at that point.
Yes, we have to give an opportunity to second that motion verbatim. We're kind of doing this out of order. We're kind of discussion.
The rewording, because, I mean, my concern is Mr. Matthews, yes, he needs, the right to speak his piece, he against this, because I looked through this whole thing and I didn't see any of the letters, the previous old letters that Kia had wrote to him in any of this, and I'm sure they've got it. I'm sure, because they've been going on like 3 years, 4 years.
Well, again, those go to facts.
Right, they do go to facts. And he deserves the right for us to hear them.
That discussion, or was that motion? That's discussion?
That's discussion.
All right. Everyone clear on what we're trying to get through this funnel, so to speak. Want to have a hearing to determine that a formal hearing is in order, or do we want to go straight and grant a contested case hearing with an ALJ, or do we want to take no action, or do we want to declare that that we choose not to hear any of the above? Those are three options. My feelings is time and again, at least twice during my tenure here on the Motor Vehicle Commission, we have members of the commission have voted, last time unanimously, 13-0, can't remember the date exactly, but that we are the venue for manufacturer-dealer disputes. And it's not just a dealer with a dispute against a manufacturer. The manufacturer can bring a dispute against a dealer here. And whether or not these hearings are in the best effort to be fair to any party that comes before us, whether it's a small dealer losing a license. And I will say, too, that there is a licensing issue here, because if the dealer loses his franchise, he loses his license, which that steps over into our, without any question, steps over into our authority. So I do think that there's a license at jeopardy here. Now, with that license comes the investment on the other hand. But I want to say this, in my opinion, or this, and the opinion I feel very strong about, this is the venue for manufacturer-dealer disputes. And we have seen very small dealers who did not lose their license without a contested case hearing. We just had one that we settled, who was I assume that's a small dealer, not the size of what we're talking about here, and that dealer was allowed a contested case hearing. It was settled outside that, but so I think any dealer should be allowed, if their license is in jeopardy, I think they should be allowed a hearing. Any other thoughts?
With that being said, too, I know the request to inform Kia that the license needs to be still in effect, or their agreement, their dealer agreement. Is that something we need to discuss also now with that motion? Because, I mean, I guess...
We can discuss any part of... I think the only thing we don't want to discuss are the facts of the case.
Right.
That's just open for discussion.
Well, just having them, because I was just reading what they had sent us, that we have in our iPads, to keep the franchise in full force, to request that of Kia until they have a formal hearing. Another license. Mm-hmm.
Chairman, if I could, as your legal counsel, I would kind of, after hearing your discussion, want to at least give you the legal advice that I know. That prior to this coming, I personally went up to the Attorney General's office and spoke with them informally about this request that was being made. And I can say with confidence that if this commission asked for the Attorney General to enjoin any manufacturer from terminating a dealer in a situation like this, they will deny it. And they said they would deny it. They didn't believe that the commission had the authority to request that. Specifically to not terminate a dealer pending the outcome of one of these hearings. I'm just trying to give you advice as to where does your legal authority lie. I believe that under the UAPA, there's a function for a declaratory order which could be done, which the commission could hear a declaratory order as to whether or not the fact presented to you, whether or not if there was a termination of the dealership, whether or not that termination would violate C3. I think that's what the declaratory order is for. But what the commission, I don't believe that your authority would go to be able to say, based on these facts, if there is a termination that would be in violation, therefore you cannot absolutely not violate, or we will do X, Y, and Z. That the termination would actually had to have been had, and there would actually have to be my office filing a formal notice of hearing and charges against the manufacturer, and we would have a whole hearing again as to whether or not there was a termination in violation of C3. And then the remedies that the commission could have is to revoke the manufacturer's license, suspend it, or to issue civil penalties for such.
If that were the case, we'd be punishing every Kia dealer in the event of the commission determining that manufacturer were in violation, and it took its right to revoke the license of a manufacturer. You can't revoke until you have another formal hearing, I would suppose. But you'd be, in that event, that would be punishing every Kia dealer in the state.
The effect that it has is that it would invalidate every other Kia dealer in the state. Oddly, when that was written into the statute back in roughly over 30 years ago, that wasn't brought up by the Tennessee legislature, and they didn't add in any other type of language in there for what other remedy could be had. The only remedy that we see that the legal division, our interpretation is that in the case of these types of termination disputes, that a termination would actually have to happen, and then the commission can convene a contested case hearing to make that determination whether or not that was in violation, and then it can impose the penalties that are provided in there, which is the revocation, the suspension of the civil penalties could be implemented against the dealer. But what the legal division, I speak on behalf of the division, and what we read, as we read the statutes, we don't see where it says the Motor Vehicle Commission can convene a contested case and tell a manufacturer, you cannot make this termination right now, you cannot do it. Because it does not say so in the statute. The only statute that has some type of similar language is under the addition of new franchises. And the Tennessee legislature took time to write that into the statute and to indicate that this is some type of protest provision that is in there. And we do deal with those quite often on a yearly basis. And there's generally not an issue that I would say that the commission does have the authority to do that. With all that being said, this is my advice to the commission. You can make any choices that you would want to, but I also have to notify the commission. It's my duty to do so, that if you do some type of ruling outside of your authority, that it could create other legal exposures, implications to the commission, and I would just be cautious. I would have the commission be cautious about those types of things, because as I indicated, I've spoken with the Attorney General's office regarding whether or not there is some authority that is in there, and there's not a formal opinion that has been provided regarding that. But they were hesitant as to the authority that the commission would have on saying, we will hear a contested case outside of the realms of a declaratory order, and the commission indicating to a manufacturer that you cannot terminate until we hear this. They believe that the rule regarding the terminations and those issues, that rule was created prior to the UAPA back in 1974. It is a carryover rule. The statutes were substantially changed, and that rule really does not have the mechanism to allow for such decisions to be made by the commission prior to a termination. And I hope I'm not being confusing to you members. I hope I'm not being, and did I?
It is a little confusing.
And I apologize. There are multiple issues on the table. And I think if you just go through them one at a time, I know that Mr. Cameron initially sent a motion for a declaratory order to be heard in front of the commission, that there is a motion for that. And the commission can decide whether or not they want to hear the declaratory order is something that you can decide today. I would just ask that you be very clear as to what you would like to allow to happen. Either a declaratory order, or would you like also this contested case hearing to be had before the commission? Because what I was hearing was a little bit more of the contested case hearing side of things, and that wasn't specifically asked for in the motion, though it seems to have come up during that time period. So I would just ask for some clarification so I can give you.
Well, speaking of clarification, I heard something in one of our rules. Could we get this rule read back? It was 0960-01-06.
Yes.
Could we revisit that?
I have that.
I have that in my notes. I had a question. If I could hear it first, maybe I'd think of my question.
This rule, and both sides have brought up very good issues about these, these rules or whatnot. You've heard about the statutes. The commission at its inception was created for disputes between manufacturers and dealers back in the mid-50s. 1977, there was a substantial revision to that, and then the official, the purpose of the commission was changed. It was amended slightly, and there were other statutes that were brought in. So there was a substantial revision back in 1977. This rule was in place prior to that time, and it actually worked in conjunction with other rules which are now gone. This rule states here, in the event that a manufacturer, manufacturer, or distributor branch or manufacturer or distributor representative determines that the franchise of an existing motor vehicle dealer should be terminated or canceled or should not be renewed, it shall give written notice to the dealer and to the Motor Vehicle Commission at least 60 days prior to the effective date of the termination, cancellation, or non-renewal. This notice shall contain a concise statement of the reasons for the termination, cancellation, or non-renewal of the franchise. Upon application of the person canceling, terminating, or failing to renew a franchise, and with notice to the dealer affected thereby, the Commission may permit a cancellation, termination, or non-renewal of a franchise upon less than 60 days' notice, if it determines in writing that a lesser notice period is justified in light of the circumstances surrounding the cancellation, termination, or non-renewal. Under parentheses 2, it indicates that failure of a manufacturer, distributor, manufacturer or distributor branch, or manufacturer or distributor representative to give adequate notice pursuant to Rule 0960-01-.06, parentheses in 1, which I just read above, or to keep the franchise in full force and effect pending a final determination by the Commission, or to abide by the Commission's final order, may result in the Commission's refusal to issue a motor vehicle dealer's license to another dealership selling the same trade name and line make of motor vehicles as the affected dealer, or doing business in the same relevant market area as the affected dealer. This remedy is in addition to any of the other ones provided in TCA 5517-101 et sec. Now, under 2, it indicates that failure of the manufacturer, distributor to give adequate notice pursuant to Rule 061, which is a 60-day notice, or to keep the franchise in full force and effect. This Commission actually changed that rule. That rule used to say 0960-01-.05. It had been like that for over 40 years, and there was never a .05 that related to the termination. So there was an amendment of that rule to make for clarification that the Commission's final order may result in the Commission's refusal to issue a new dealer's license at another dealership goes back to the manufacturer's requirement to provide the Commission with 60 days notice of that termination or cancellation.
So there is no dispute in the manufacturer's action. Everything has been done appropriately up to this point. Now, that doesn't go into the facts of the case, but that's not in dispute. The only dispute we have here is whether or not to consider the petition or take different action from that in regard to this case. That's basically it. Other questions?
I wanted to get some clarity. The franchise has not been terminated at this point, I think, based on what you've shared with us. The agreement through Kia has not been terminated at this point. So if it had not been terminated, we can't take any action at this point until the termination is taken. I'm just trying to get some clarity.
Yes.
We have a right, and I'm just trying to get some clarity through the attorney. Do we have a right to set up a contesting case after the termination has taken place? Does this commissioner have a right to do that?
I said under the statute, this commission, if it would just generally the same way we have a complaint with consumers, whereas a consumer, something has happened adversely to them, and then we take action. So there would be a complaint. We would set up. It would come through the legal review authorization, and then we potentially would have a contested case where my office would bring them forward before the commission for violations of the statute.
In that case, though, if I may interject this, in that case, we don't have, the commission doesn't have the right to tell a manufacturer to give the license back, give the franchise back. The franchise would be gone.
Oh.
And then the only thing left to consider, if the commission wanted to consider it, it would be, did the manufacturer act appropriately? And if that were determined,
that was my...
The next option is a nuclear option. You just want to blow up the whole Kia system.
Because as of May 20th, I think that's what I heard Attorney Ross says, is that is the date, that's when the 90 days is up. So at that point, once the 90 days are up for the dealership, then I would assume the dealership will get Mr. Cameron over there to take action at that point and maybe bring it back to this venue again and ask for some consideration. I mean, I'm assuming that that's
how it would work.
So at this point, if dealership has not been terminated, what action can we do at this point? What action can this commissioner do at this point?
That's the substance of the entire question here. What is the authority of the commission prior to the act actually happening? And I'll continue.
What does the legal department advise us that we can do?
Well, yes, and that's what I'm advising. Yeah, I'm advising you on behalf of the legal department, and the legal department, not just myself, but I went up there with Michael Driver and Wayne Pugh, our Deputy General Counsel, and spoke with the Attorney General's office to get some clarification as to our legal understandings as to what this was, and we were not comfortable in saying that the commission has the authority to take adverse action towards the manufacturer prior to the termination actually happening, other than going through the Attorney General reporter and asking them for an injunction. However, informally, they indicated to me that this is not something that they would generally have an injunction against in this instance.
The only thing that addresses is whether or not to allow the manufacturer to put in another dealer during this process. That's only what that is about. Is the only adverse action. Your question about adverse action only deals with not allowing the manufacturer to add another dealer until this hearing is over.
And so could be one of them. The other one was actually to enjoin the manufacturer, the commission actually indicating you cannot right now, prior to us hearing this matter, and terminate the dealer. May 20th comes, you cannot do that, or else. And what I gather for is, what is the or else? What is the commission going to do if the manufacturer, if you tell the manufacturer you cannot terminate this dealer until we hear this matter, and they do, then what authority does this commission have to do to enforce its order?
That would be you'd find them. I'm trying not to create prejudice here, but in that case, the commission has the option to revoke the license of the manufacturer.
Or a civil penalty. correct? Could you say if you do it, there'll be a penalty of $1 million?
In order to, you can do civil, you would, for violation of an order, there would be civil penalties. There would generally be, that would have to be done through a formal hearing. We would have to file notice hearing charges, have a formal hearing, and there also potentially would be a, just as for your information, there would be a dispute probably on the validity of that original order indicating that they could not. And you know, I have some, we have some reservations as to how aggressive a manufacturer would be about attempting to go through the system. The courts to indicate that the Motor Vehicle Commission does not have this type of authority, so it just could potentially cause some type of protracted litigation on that issue.
Mr. Webb, a few minutes ago.
Mr. Webb, I know you had a question.
Well, I guess I'm a little confused. I thought you first said that we did have the right to set up a formal hearing, and you thought that was legal. Is that what you said?
It was for a declaratory order.
Okay. And then you got into this other thing about
contested case on.
Got on down to the contested case, right, which we're really not talking about now, but which could come. I guess that's what I'm.
I believe that, you know, under the provisions of the UAPA, it allows for declaratory order where both sides can come before the commission and present to you facts, and you would have a certain set of facts, and say, based on this set of facts, if the manufacturer terminated the dealer, would it be in violation of 5517.114C3? And
none of this means that the dealer couldn't be terminated. It's just whether or not we have a hearing, which I think makes the commission relevant.
Go ahead and move forward with a motion that we need to declare or set a hearing for a declaratory order. I'd like to do that.
Second it.
Okay, for discussion purposes, once again, let's discuss what the motion was, Council. Declaratory order will.
Sorry, I was writing what we were about to do, and I believe there was a question as what.
The motion was for a declaratory order.
Hearing for declaratory order.
Hearing for declaratory order. I'm sorry. Hearing for the.
I believe you do have the authority to grant Mr. Cameron's motion to for the commission to hear a declaratory order in this matter.
That is not a formal hearing. I mean, that is not a.
It would be. It would be a contested case under declaratory order. However, like as I stated earlier, it would be the dealer and the manufacturer would be the ones. Generally, it would be the dealer, and then the manufacturer would come in to provide the commission with facts, and my office would not, as Mr. Cameron said, be involved in that, because this is not a penalty type hearing. There's not going to be civil penalties assessed. There's not going to be revocation of a license or anything like that. You are going to determine the applicability of your statute.
That would be in July.
We do have we have a July date open, July 16th. Is it 16th? Currently July 16th. That's the date that I know that is open. If the commission would like to hear one in January of 2014 instead, I will do the best I can to make that happen. And I'm pretty confident that if whatever you choose, whatever you wish, that we can get that for you. But because I'm not the final sayer on that, I cannot say with certainty that it will be done.
I think that's fair for us to request January. That way it gives everybody plenty of time to get everything together.
From a timeline, clarity for myself, if we grant this order to have this hearing in January of 14, we're not saying that we're preventing the termination between now and then, correct?
That's correct.
Okay.
You would hear the issue, but as we stated, the sticking point is that is what does the commission say prior to May 20th comes and goes, and say the Kia manufacturer terminates.
Vote on this motion first and then address that, maybe. just to kind of keep it moving along, I guess.
The commission, though, even if we have that, they could cancel and it's over, right?
Correct. Yes.
No need for us to have a hearing after they've canceled. So we're powerless. It seems to me we're powerless to move.
Well, I didn't think this was going to be easy, but if there is a termination, in fact, then what Gary Matthews has already filed is what we call, generally a complaint, a little C complaint, and we could investigate that complaint generally and bring it before the legal review committee, and you all could look at that and say you terminated them in violation of our statute, and you could do, as Mr. Parr said, there's civil penalties that could be had against the dealer, or against the manufacturer, or suspend or revoke the license. And I think Mr. Cameron wasn't generally arguing. Please stop me if I'm speaking out of term. He was not asking the commission to enjoin the manufacturer from a termination prior to then. He believed that they potentially could work something out for an interim time period, but he could not. You were not asking for that, is that correct?
No, and we have never taken the position that you had the power to enjoin the manufacturer. We've not taken the position that you should penalize the manufacturer in any way. All we've asked for is exactly what this motion says. Give us a hearing in January on the declaratory order. That's all we've asked. And if a termination happens, it happens. We have to deal with it perhaps in other ways.
It just doesn't seem to me that a termination in May 20th would benefit either party. I would have to think that common sense would come forward. The manufacturer's not selling any cars. Gary Matthews has a facility there with people that are employed, and I would hope something could come to resolution there at that date.
I would tend to agree with you, but I would tend to also add that I think waiting till January of next year is overkill. It's been going on for 7 years. They clearly know what the argument is on both sides of the fence.
Been a dealer for 17 years. I see 17 years.
I'm talking about the manufacturer's issue with the dealer and the dealer's position on this termination. I don't know why they would need 9 months to prepare for that argument to show that they're in the right and they're in the wrong, or vice versa. It seems like waiting till January is far too long and unnecessary. And if we were going to allow this hearing, that July should be more than sufficient time to make those arguments.
My opinion is just, Dylan, no offense to any attorneys out here, but, they seem to take a little long to do things anyway. No offense. That's the reason why I was kind of going with January.
Got a motion, and it's been a second, so...
Yeah,
We're in discussion.
Mr. Cullum, I would ask you to consider the fact that during a period of time, especially during the Iraqi war and the Afghanistan war, there's a significant amount of population deployed from Clarksville, and it does have a significant effect on the sales from groceries to gas to automobiles, and I think there are indeed special circumstances in this case that should be reviewed and addressed when we have this hearing, and I'm sure both councils will do that. But this is a very unusual situation when you have as many as 50 or 60,000 troops all of a sudden out of the town.
Talking about the facts of the case aren't going to change much. The preparation for what the issue exists today. They're both very much prepared to make those arguments. I imagine they could do it today, in sufficient arguments that we could make a determination. I'm just saying waiting till July to do that isn't necessary. I think that the July 16th date of this year would be sufficient. That's just my...
What was the date
That's
part of the
assuming
motion?
that it passes to begin with.
What was the date part of the motion?
Well, did I make it part? I don't remember if I made it part of the motion.
I don't believe that the date was part of the... Was the date part of the motion? Maybe Mr. Cameron...
I followed it up with January.
It was, okay. So, yes,
Yeah.
it was part of their motion. Okay.
So it was part of the motion.
Not unreasonable.
the franchise could be terminated in the interim.
Yes, I believe so. I believe it could be terminated in the interim before you heard it, no matter what date the commission.
Commissioners have no problem with that. They don't feel like that's a detriment to them or the community to have it terminated before this.
There was a question.
Was that the statement I understood, that there's that the petitioner has no problem with being exposed to losing?
Yes, I believe that's what Mr. Cameron may be able to express it better himself, but I believe that was his argument.
Cameron,
I don't think the commission can enjoin Kia, and we've never asked that. If they do terminate, then we have a different situation on our hands. What I suspect we would do is, if Kia does not agree, then we will go to Chancery Court and get an injunction in Montgomery County to stay the termination until this commission has the hearing in January 14th. But we don't want to be terminated. That's why we're here.
Could be terminated before the declaratory order is heard.
Yes, sir. And in that case, this declaratory order petition would likely become a complaint. As Mr. Glandorf was talking, then you're faced with different issues. But we're asking for a declaratory order for the commission to say, under the facts of this case, it's either just for Kia to terminate this dealer, or that such termination would be unprovoked, inequitable, and wrong.
Well, if concerning the motion itself, if the motion is for declaratory order with no statement about franchise disposition between now and when the declaratory order is held, if there's no concern with the petitioner, maybe the commission shouldn't be concerned either, and we have a straight up motion order in January of 14. So that's the motion that we'll have to vote on.
I ask a question, please.
Certainly. Yes, sir.
When we're talking termination, and you get an injunction to stop the termination, are they going to continue to operate under the injunction, or you got termination and shutting down? Is that correct? You don't want to be shut down. You don't want to cease operations.
Mr. Ross, do you want to play your hand here? Yes, sir.
Commission decides that a petition for declaratory order should proceed, we would ask, it says, and Mr. Cameron has already quoted this, it says any affected person may petition an agency like the commission for a declaratory order as to the validity or the applicability of a statute, rule, or order within the primary jurisdiction of the agency. Now, I didn't step up here just to read you this. I would like for you all to clarify what specific statute you're going to determine the validity of and the applicability of, which specific statute. And the only two that are mentioned in Mr. Cameron's papers are TCA 55-17-114 C3 and C21. I don't think that as to those there's any question as to the validity of that of those statutes. We're not saying that they're invalid. And as to the applicability of the statute, what are they applying to? They say basically that if the manufacturer violates those statutes, that you being the commission, may take such steps as you deem necessary to
revoke the license or suspend the license of Kia Motors of America. So if you all are going to proceed in that direction, we respectfully ask the commission to specifically state which statutes are you going to determine the validity of and the applicability of. Okay? We understand your request. Where we are is a motion that's already been stated and seconded. The only way I know that we might do that is, depending on how this vote goes, our legal counsel could interpret that and maybe give you a response to that. But I don't. With the motion that we have now, unless we amend it as such, I don't. Requesting that the commission, in its authority, be specific about what you're intending to do. Part of that certainly is going to be determined by what Mr. Cameron and his client have requested the commission to do. But there are only two statutes applicable to. They're applicable to an effort to determine by the commission if they're going to keep Motors of America stay in business. All right. Any more discussion of the motion? Hearing none, we'd like to restate the motion and have a roll call vote. Read the motion.
I made a motion to have a hearing for a declaratory order in January of 2014.
Second, all right. We're ready for a roll call vote. Director Stribling? Voting for the motion or against the motion? Yes is for. No is against.
I'd clarify, Mr. Ross does have a point as to exactly what is to be determined, and I hate to interject here while you're about to vote, but the statute for declaratory orders requires me, upon filing it, of any declaratory order, to specifically set out which statutes are going to be determined here. I have to give basically if I file any declaratory order, I have to tell the ALJs and the Secretary of State's office.
Can we do this with a second motion? I mean, if it's irrelevant if this declaratory order.
I understand, and it would be helpful. It would definitely be helpful. I think maybe Mr. Cameron can come.
My suggestion would be, if this motion carries it, then we look at which statute we want to use, because I can't change the motion.
Yes.
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 Yes. Yes.
Yes.
Yes.
Yes. No.
Yes.
Yes. Would our legal counsel read what statutes or rules that we think are applicable, possibly applicable, and of course the commission could add or subtract to this?
It would be appropriate for that to really come from Mr. Cameron, who is the one it is his motion as to what the commission, the declaratory order. It would be appropriate for him to make his request as to what statutes. Searching his I'm reading his motion here. Could be either or both, and maybe some clarification could help Mr. Cameron.
517, 114, C3, and C21.
Have those read back. Could we have those statutes read back to us?
Ask a question, please. Which statute did the Capital Chevrolet case, what was it based on?
Two things, same act, but in a relocation case or an add point case, you've also got 5517-114C20, which is the one that talks about protest and giving 30 days notice and all of that kind of stuff. This one has to do, C3 discusses manufacturer unfairly or without due regard to the equities or without just provocation canceled or failed to renew the franchise or selling agreement of a motor vehicle dealer. That's C3. C21 says committed any other act prejudicial to the dealer by threatening to cancel the franchise or any contractual agreement existing between the dealer and the manufacturer branch, distributor, or distributor branch. Written notice in good faith to any dealer of the dealer's violations of any term or provisions of the franchise or contractual agreement shall not constitute a violation of subsection C. So those are the two. One is, well, they're both fairly broad, but they both deal with termination situation. Is that, Tony, what you needed?
Was that the Capital Chevrolet case or the one we're dealing with?
The Capital Chevrolet case, Commissioner Roberts, was 5517-114C20, and we're talking about C3 and C21.
I want to make sure that Commissioner Murray's question was answered. Now, I think it'd only be right that Mr. Ross, since you were part of that case, do you agree with that was the statute concerning the Capital Chevrolet case? I'm sorry. The question was, what was the statute involved in the Capital Chevrolet case?
Exactly about
Okay.
that.
I just want to make sure because you were there.
Yeah.
Okay, sir.
Yeah, I was there. He told you the truth.
Oh, I don't question the truth. I'm just looking for accuracy or agreement.
I was there too, Commissioner Roberts.
Okay.
He was.
All right. I think that was the question that Commissioner Murray had.
Okay.
All right. And then the two that are, okay, and we just read the two that we're concerned with today, or that, and they, could we have that statute number back again?
Tennessee Code annotated 5517-114C, parentheses 3. Oh, could you not hear me?
No.
I'm sorry. 5517-114C3 and 5517-114C21.
Does the commission want to add or subtract to this, or not do this?
I have a question.
Sure.
As I understood, these two statutes apply to adding an additional dealer. True or not true?
I don't believe these statutes apply to adding an additional dealer. The statute that was commented on earlier, 5517-114C20, talks about the additional dealer statute. However, the facts in this case does not involve the granting of an additional franchise to any person. Therefore, it's not applicable in this matter, and it hasn't been requested for the commission to make a determination regarding that matter.
Want to clarify the statutes which is formed this motion on? You could do.
I don't think you do that. I don't think you have to be specific on it, do you? You agreed to have a hearing on it, on what he's presented.
That's correct.
So,
You don't have to. It was requested, and it was stated. I think both sides in this had an ample opportunity to express what they think the statutes are and one of them stated, but that's correct, we don't have to. We don't have to make a motion, we don't have to, it was a recommendation by our legal, but we don't have to. Okay. Motions, so is that correct? Anybody want to make a motion either way?
To the attorney, would it be proper for us to do the motion?
I have to. I'm required under the rules,
Okay.
under the Uniform Administrative Procedure Act rules to list the statutes involved in this, and whether or not the commission makes a motion for it. I've heard the commission. I am your legal counsel. I'll file it appropriately as I have heard it. But it just has to be filed for something. It's not just for our benefit. It's for the administrative law judge who has to read all of these documents also as to what is to be determined here.
That is the two, C3 and 21, right? So didn't we just approve that?
We approved an action. We didn't. What we didn't state were the statutes that we arrived. What we think what we think that action is about.
There has not yet been a motion.
Commissioner Jackson, I make the motion that the rule that need to be applied to the previous motion of authorizing a hearing in January will be rule statute number 55-17-114-3-C in parentheses 3 and 55-17-114 in parentheses C in parentheses 21.
Second.
Those are the same ones that. Not that I have any doubts, but is that right, Councilor Jackson?
That's right.
Okay. All right. Any discussion now of that motion? Hearing none, let's, yes.
I did.
Oh, I'm sorry. Commissioner Jackson and
I did.
Commissioner Hatcher seconded. Now let's have a roll call vote, please.
Commissioner Jackson, you want to restate your
Oh,
motion?
my God. Commissioner Jackson makes a motion in regarding the previous motion that was made about the what is that? Declaratory hearing for January 2014, that the statute that applied to that hearing will be statute 55-17 in parentheses 114-C 3 parentheses, and then 55-17-114 in parentheses C in parentheses 21.
Yes.
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 Yes. Abstain.
Yes.
Yes. With that matter, Counsel? All right. Fill in the legal report.
I believe that would conclude my legal report.
I think we're ready for old business. My laptop just went dead on me. But is old business the next thing on the agenda? Don't have any old business. New business is placed for comments by commission members. Anyone feel like, I'm sorry? Yeah. There are two committee meetings at 1:30. Do the chairs of those committees, you want to keep that time? You lunch?
The head shaking no over there. Are you hungry?
Move them back a half hour, can't we?
I'm sure. At least.
Separate committees, you
15
can do it.
minutes.
Oh, you're on the same committee. Okay.
Yeah.
You want to move yours?
Move it a little bit so we can get some lunch. You want 30 minutes or 50 minutes? 15 minutes.
2 o'clock, give you an hour.
15 minutes to walk in.
Yeah, let's do 2. That sounds good.
At Rules Committee?
Yeah.
Rules Committee, 2 o'clock. Audit Committee, what do you want to do? Where's the chair? Lynn?
Go forward, 1:30.
At 1:30. Audit at 1:30, rules at 2 o'clock. All right, what's next on that agenda, Director Scrivener?
Mr. Chairman, I believe that you've had a full day.
All right. A motion to adjourn. Is there one? A second?
Second.
And a vote for yes?
Yes,
For to
yes.
adjourn?
Yes.
I'll vote for everybody.
I don't hear any no's. Thank you. That's work.
There's a button on the side.
I'm hungry. Get out of my way. I was moving all the chairs around, sorry.
What do we do with dead objects?
I know, it threw me off. I almost stopped for a second. I was like, oh, that's me. It's really taken me a while trying to sign the checks at the dealership. Luckily for me, my signature's so crazy, it's hard to tell what I signed anyway.
I'm so proud that Donnie Hatch.
We waiting on anybody else? Are we good to go?
Missing.
I think everybody else. I think this is everybody.
Okay.
Yeah. Well, this is the start of the Rules Committee meeting, and Commissioner Murray, Cullum, Vaughn, and Trickett are here. So if you want to go ahead and, well, and yes, we also have the addition of Roberts, Commissioner Roberts, for now.
Good afternoon. Thank you all for coming back so soon. I'd like to start off. I'd like to start off with Representative Goins is here today. I believe with one of his constituents, and he would like to approach the Rules Committee regarding potentially a rule that you currently have and potentially an amendment to that rule. So I would ask that Representative from here to the podium.
Thank you. And this is something that was brought to my attention by email from one of my constituents probably a couple of months ago. And as you know, there's a landline rule for used car dealerships, which in this day and age, it's the rule, while I understand why it's been put in place, is starting to seem a little bit antiquated. With modern technology and the price to hold a landline, it's become where this rule is really counterintuitive to small business and what small businesses are trying to do, certainly in my part of the state, and I'm sure in other parts of the states as well. And if it would please the committee, I would like to have Mr. Glenn, my constituent from Morristown and owner of Frontier Motors, come up and address the situation as he sees it and how it affects his business on a daily basis.
Thank you. My name is Hugh Thomas Glenn. I'm a licensed motor vehicle dealer. My license number is 9225. How many of the committee, if I can ask a question, how many of the committee members here use a smartphone? Smartphone, iPhone? So you get to use technology that I'm forced not to use. I'm a small dealer. I'm closed today. I can't, I pay $126 a month for phone and internet at my shop, and I can get the same thing through sale.
Microphone?
Yes, ma'am.
Thanks.
I can get cell phone service with internet for about $35 or $40 a month, saving me roughly $90 a month that I can seriously use. When I called and asked the commission about it first, they said it was because it needed to be listed in the phone book. 90% or more of the people that contact me either do it through an ad that I run or they found me on the internet. I don't know hardly that many people that use a phone book anymore to look up a number or find someone. It's usually a Google. It's more Google than Yellow Page. I'm looking at it as a cost savings and allowing me more freedom. Like if I want to go to an auction, I have to wait and get my messages when I get back or whatever. I just think, like Representative Goins said, it's something that we should have available to us and not be an additional cost, but let us replace our landlines with a cell phone. And even I can keep the same number and list it in the book. That's not a problem for me as well. Thank you.
Certainly appreciate your time, most definitely, and thank you very much.
I believe if he would be allowed to address that he may too. Sorry.
Thank you. Bob Weaver, Tennessee Automotive Association. Representative Goins had mentioned this to me earlier when he met with Director Stribling and some other folks on behalf of Mr. Lynn. And going back, I get one of the benefits of having been here quite a while is I remember when a lot of these rules were put into place and the purpose for which those rules were promulgated. And in this case, I think there was a couple of issues the Commission was attempting to address. One is addressing what I might term out of art fictitious dealers, those that were dealers in name only but merely wanted access to the auction sale or whatever to buy vehicles without paying sales tax, to be quite frank. There was also a problem with dealers who were never seemed to be open, where the people they had sold cars to could never find them to try to seek redress for their concerns. And then thirdly, the Motor Vehicle Commission needed to be able to find their licensees in order to inspect business records or temporary tag logs or what have you. Certainly, I think we can all agree that technology has certainly progressed, and I might suggest for the committee's consideration, if you were so inclined to recommend to the full commission to allow folks to use their cell or mobile smartphones, if there were merely a requirement that the licensee list with the commission their primary phone number, so that the commission would have a way to contact the dealer if a consumer complaint or a regulatory complaint were filed, and a continuing obligation, if you will, if I were to change my phone number, I would have to come back and notify the commission that number had been changed. And I just offer that as a possible way to address a situation that would be fair to small business, and at the same time have the commission continue to have that regulatory oversight. In 2005, Mr. Markle and I were talking when he was serving as the attorney for the commission, is when we addressed the fictitious dealer situation by requiring dealers to post their hours of operation so that a consumer would know when they could come back and find the dealer if there was a problem with their purchase or when they were available to sell them a car. And I think with that piece in place, then having the dealer file his primary phone number with the commission, with the understanding he would notify the commission, allow the commission to have comfort that they could find this individual if the case need be, and address the constituent that brought for you today. I'll be glad to try to answer questions if the committee.
Changing with everybody having cell phones. I mean, it's definitely a good point.
From an enforcement standpoint, I don't know if we just enforce the rule that's listed, whatever the rule be. I generally don't deal with motor vehicle dealers and them not having phone numbers that are available. That generally has to do with the administration. I know that they constantly have frustrations with dealers who have a phone number listed with them, and the phone number is out of order. It doesn't work. Any number that they give them, I don't know what whether it be a cell phone or a regular phone or whatever. That just is an issue that comes up from time to time. So all I know on the historical standpoint of this rule is that this rule was contemplated and passed, I believe, in 2008. It specifically listed that the primary phone number of the dealership posted, it must be posted, and that mobile and or cellular phones were not acceptable. That was back in 2008. And as part of the flexibility, as part of the flexible analysis of the rule, the Commission at that time adopted the statement that the costs associated with the installation of a required landline are minimal. However, the type of service voluntarily chosen by the business will dictate the expense to the business. The facility requirements have been suggested, yada yada yada, but that which doesn't matter. But it seems that the Commission had some kind of understanding of the costs associated with it back then. But I think you all identified that was 2008. We're at 2013. So whatever the will of the commissioners are, I don't think that it would have a problem on the enforcement side one way or the other.
Landline can be out of order, out of service, so either way.
The only issue that we ever have with motor vehicle dealers and cell phones is a dealer who happens to be in a car and they want to sell that car, and somebody calls them and he says, I can come to you right now, and he does an off-site sale. That's the issue that we have, that every motor vehicle sale has to be done on a licensed location. That's the only issue we ever have with that.
Of course, at the same time, you can also transfer the calls from the dealership, so it'd still be the same type deal. So, just in my opinion.
Would it help enforcement if it were a verifiable number, if we call it a verifiable number?
Yes, they do verify every number. When a dealer has a biannual inspection, that number that is listed on their license for the license is actually called. The investigator actually comes into the building and calls that number and makes sure that it rings where it's supposed to be. But verifiable, they would verify that number if it was given to them, yes.
I can make one more comment. I think the rule should be updated to allow some fashion. I realize we're in a new era, and in some ways you can give better service by the accessibility of a cell phone than you could if you were out of the office and no one answered the landline. That could happen after hours, something like that. But with a cell phone, depending on how a person uses it, most people don't cut them off until they go to bed or something, so might make better accessibility.
Correct. I would. This may impact another rule that we have just off the top of my head, is that we have a requirement that minimum business hours have to be kept at a dealership at any given time, and we've always interpreted that. That means that the door is open and someone is there for the minimum business hours. That be some kind of action so that we don't have dealerships that have their doors closed except for one day a week, but they're answering their cell phone. That generally when we verify that they're in business, we would actually go to the location whether or not they're answering their phone. Since the issue of you can transfer a landline to a cell phone now, you can forward that anyways. But I think we could make it work.
And we could also put something there about dedicated service, or dedicated. The cell phone has to be dedicated to the business, or and be in the name of the business, or whatever the case. Not an individual's name. Certainly, that seems to be where technology has gone. There's lots of individuals that don't have home landlines anymore. Although, from a cost standpoint, I'm not quite sure. I don't think, from a cost standpoint, the landline anymore today is actually. I see the bill of my cell phone, and I don't have a lot of service to it, and it's extremely expensive. But nevertheless, from the essence of running the business and being connected and being able to be serviceable to your customers, certainly there's a lot of advantages to having that connectability.
We have a fine in place for failure to have a good telephone number that
There is. It'd be there's, and I do not have that in front of me, but we do. As part of the biennial inspection, I want to say that off the top of my head, I think it's a $250 civil penalty if you do not have that land in place. But it may be $500. I cannot be for certain, but there is.
Is that to not having a good number on file with the commission, a working number. Someone might forget to change it, but that might help to remind them the next time if they change the number. But if the commission, if the enforcement can't call a dealer and get them on a good telephone number, there's a lot of expense involved to the commission to try to track this individual down. I think some kind of fine would be in order. It might not be. That would be part of the rules. I think.
Would be. Yes, I believe. If
$200 or $300 fine or something would be in order.
How do we need to move forward with this, Tony?
I think I can't remember the last time we did a rules committee. I just cannot remember in all the years that I've done this at one of these committees. But generally how we do it is that we would make these, would come up with these agendas here, a motion at one point in time for legal counsel to move forward to present you with something regarding this issue, and we can do that.
Back to the Rules Committee or to the whole, total board? Okay.
Cellular service, I think, is probably what.
If you trust the way that I would draft it, then you can go ahead and make a motion that we send it back straight up to the full committee.
Okay. I'd like to make a motion that we pursue this. Let you go ahead and pursue presenting this to the full committee. All service.
Second.
Seconded by Mr. Trickett.
Aye.
As opposed? All four. Yeah.
Thank you all very much.
Thank you very much.
We have, I have provided you all with a memorandum of suggested rules. Do you all have that? Because we have extra copies if you all need that. Okay. I think that's the meat of our discussion of what it needs to be. There was one other thing prior to that that's not in there, which came up in the other meeting, which is the fact that we have a rule that if you work for a certain dealership entity and it's on your salesperson's license, that you can actually work at any other entity that's owned by that dealership. So if you have, dealership A, and your license is in dealership A's name, and then dealership A owns 4 other dealerships, you can work for them. But the way the rule is written is that if, say, you have dealership A, just say Jones Automotive LLC, and then you have Jones Automotive 2 LLC, Jones Automotive 3 LLC, that really doesn't comply with our rule. It does not, because not all of those dealerships are owned by one parent entity. So you could have one person who owns all 3 of them, or a person and their partner own, all 3 of these dealerships. But you would kind of assume that the rule would have let that salesperson at one of those dealerships operate at the other 2. But the way that the rule is written is that it's not. So I was actually approached with this issue by Patrick Merkel, who is representing one of his clients, one of his dealerships, and they were trying to go through a name change. They were trying to go through an entity/name change, and we ran into this issue of, oh no, those salespeople are not going to be able to work at these 8 different dealerships because they're not owned by the same entity. The issue that he had is he had one individual who was the majority owner of all of these dealerships, one individual, and it all had that individual's name. Was that correct? There's different corporate names, but there was one person who was the majority owner of all of them. So since he made all the decisions, the business decisions, they wanted to be able to let their salespersons move back and forth for that. So I wanted to propose that to you all, that if your understanding of the rule is that that if someone is a majority owner of a dealership, that if he majority owns any other dealerships, that salesperson should be able to work for those other dealerships if that's the rule.
I've got a question for you. Are you talking about like they could sell, say I've got 6 different franchise stores. So this one salesperson that's licensed could sell at any of them at any point or one at a time?
You know, the way we look at it right now is that any of them. So he could work on one, Monday, the second one on Tuesday. He gets switched around. Really, management makes the call or whatnot. And
he'd be licensed for the whole automotive group.
Yes, it would generally be that. Now we'd have to, as part of the administration's function, is to figure out how we keep track of all of that. That's one thing. We had in the past. What we have is this one parent corporation, and then this one corporation actually owns these other probably LLCs, corporations, and since this one is the one listed on the salesperson's license, he can work for any of these other 5. Well, that takes a lot of documentation. It takes a lot of work, and I constantly get questioned about this from dealerships who are trying to reorganize themselves, where they are, in order to let their salesperson work at these different dealerships, they have to incorporate a certain way to meet our rule requirements. Whereas I think the majority, the commonality between these schemes is that there's one person who's the majority owner for these types of dealerships. They're just different LLCs. So either one person or one LLC owns the majority of them. So generally that's what we see as LLCs. So if you are in agreement with that, we could move forward, with an amendment on that rule. And I'm not trying to give an opinion one way or the other about it. This was just brought up.
Licensed salesman at one entity within a dealer group. And a felony conviction was caught that wasn't caught for whatever reason in the previous application process. So, if an employee's working for a group and commits a felony of some sort and they don't know anything about it, there's no way for this commission or the state. We would lose a checks and balances, or we lose a piece of control over being able to monitor the current base, right?
Well, in a way, there is a statute out there that indicates that if a licensee is convicted of crime of moral turpitude, if they plead guilty of a crime of moral turpitude, then by statute their license is automatically revoked. So in that situation prior to, if somebody actually had committed a felony, pled guilty to it, and it was a crime involving moral turpitude, their license should have been revoked. And for purposes of the statute, the dealership should have had a duty to notify the commission of that. We don't have a specific statute on that, but we have one regarding false claims applications, things of that nature.
Responsibility on the dealer, whether they do it or not. There's no way whether they did it or not.
There's many things similar to that where it's really voluntary. Yes, it's not a. It's actually allowed. There's not other programs within our department have similar type statutes that they have to tell you or whatnot. Ours doesn't indicate that. It really just allows for the revocation when there's a guilty.
Also, I believe one last thing. I believe from a new manufacturer standpoint, they're going to have a significant issue with salespeople being able to work at Toyota One. Building in a little bit of flexibility for a name change for a particular dealer, I don't see that being a big. Every franchise and it's done, especially if you're working for a public or whatever, and just to be able to jump from dealer to dealer to dealer, I don't know that would make the best sense. You out of control, and I think it could become very loose very quick. But
for like if you've got a Nissan store and you've got a Honda store, transferred over and not have a.
So you have to go through the reapplication process, maybe,
or at least some sort of transfer.
Transfer it, but you still have to. I don't know. I just think that's what have.
I see what.
A lot of multi-dealership owners, small.
Well, it's one of those where this rule was done in 2008, and it's one where I unfortunately was sort of behind the drafting of it, and what I understood at the time was not necessarily correct. And I think Tony explained it at the time, and I'll use Commissioner Roberts now that he's left. At the time, he owned not just his Toyota store in Columbia, but he also owned Chevy Buick in Lewisburg. And my thought was, and it wasn't necessarily Commissioner Roberts who drove this, but occasionally a dealership would have staffing issues, and I was talking to somebody 2 weeks ago who had a flu issue, and a couple times they had a sales force of 10 and only 3 were in because everybody was sick. The ability to shift somebody over, it's more for a temporary thing than for a sort of a permanent jumping around like you raised, Commissioner Collin. The thought was that if it's common ownership, or not common ownership, but as a common entity, it was my understanding that most of the dealerships set their corporate entities up as one corporate entity, and then
separate LLCs.
No, not even the separate LLCs. Though each all the dealerships owned by that one entity, just operating under a doing business as. And I was wrong.
I wouldn't think that's the way it is.
And it was,
they're very siloed, and they keep it that way specifically for insurance purposes.
Exactly, and liability issues as well. Insurance and the legal liability, and it's a misunderstanding that maybe a bad assumption on my part that was not caught during the process. And at the time there were multiple people. There were a number of people on the rules committee that had multiple dealerships, and I thought afterwards they would have kept me off from going down the wrong path. But I did go down the wrong path, and I think you're right, Commissioner, is that they're all very siloed. There's one here in town that I know that is not, and it's a fairly new entity. It's the downtown Nashville Nissan and Hyundai. That's owned by one. Those 2 stores are owned by one corporate entity.
Downtown Nissan?
Not Nissan. Downtown Hyundai and Subaru are owned by one entity, Martin Management, and those are just the Downtown Hyundai is a DBA and the Downtown Subaru is a DBA. But you're right, there are a lot more are siloed. The issue came up with a name change, but it also came up with a larger entity that was trying to put in a fleet sale component and trying to minimize overhead of fleet sales. And under the law, I said, because each of these are siloed, we told them you couldn't do that. I think you're right that you lose some of the oversight when they change. It's something that you guys. I asked Tony if we could bring it up just so that you could think about it. Mostly, my thought is that the attempt that was made 5 years ago was not what I think was trying to be done wasn't implemented. Whether it's good policy or not, you guys can decide. It's there, and it does have sort of that catch where it's got to be the common legal entity owning those dealerships.
And 2 things that I believe are valid and probably have some merit that we could try to draft into some flexibility. 2 things. One being crossover franchises simply because of the customer base you're dealing with. That makes some sense. We could build in. The second would be for if we had some flexibility for staffing for specific periods of time, let's say, allow the license to transfer over to a common ownership for a maximum. Adding a little flexibility there seems to make sense. I think any kind of permanent move, though, is where I would think we would want.
And just like if, for example, like the flu deal. I mean, how often is that really going to happen? And honestly, for
temporary staffing.
yeah.
You know, you gotta,
I wonder.
You know, this license is good at a common ownership dealership for, you know.
And this is, you know, the previous issue you discussed is a pretty clear-cut, easy one. This is one that, you know, I think you've got some valid points, and it's a lot more complex. And to find the right language is going to take just a little bit of work. But
Manufacturer's not going to be okay with you bouncing around from Nissan to Honda. I mean, that's an interesting idea. I didn't think about that too.
But I know that Tony, you know, in opening it, Tony's got some issues, and the commission would have some issues about how do you track that. That right now the name on the license is, well, on the name, you go to the name change that happened here with Carnival to Universal. If the name change is, you know, Carnival Kia of Rivergate, well, this one was a situation where it's siloed, so they weren't able to jump anyway. In talking to Tony, it's just when the licenses come back up, they'll fix the name. They won't have to reapply with the change in the name for them. But trying to keep track of who has that common ownership. You know, it's right now it has to be disclosed. But if it changes, you know, the manufacturers know, but then the dealership or the commission doesn't necessarily know if. You know, as part of estate planning purposes, the dealer transfers a certain percentage to children to begin that process of moving it. The manufacturers obviously signed off, but they may not pass that information on to the commission. So you need to be able to know. Obviously, some checks that are going to be important for the commission as well.
Commissioner Cullum raised the point earlier about, you know, if bad acts occur from point A to point B. I knew it was in here somewhere, and it took me a while to find it. But under 5517-114B2, there's a provision that says, in B, as I usually talk about 114 being the prohibited acts section. A is kind of all licensees. B is dealer and salesperson's licenses. B2 says whenever any licensee pleads guilty or is convicted of the offense of odometer tampering or any other criminal offense involving moral turpitude, the licensee must, within 60 days, so notify the commission and must provide the commission with certified copies of the conviction. The licensee's license shall automatically be revoked 60 days after the guilty plea or conviction unless, during the 60-day period, the licensee makes a written request to the commission for a hearing. Following the hearing, the commission, in its discretion, may impose upon the licensee any sanction permitted by this part. So there is an affirmative duty in the law today if someone either tampers with an odometer or commits any other criminal offense involving moral turpitude, there's an affirmative duty to notify the commission with an automatic termination of that license.
Has happened from time to time. From time to time, we have had that happen. We've had that sent to us, and they did not tell us, and the license was revoked. And whatever issues they would have with the tracking it or the databases involved in salespersons and dealers, I mean, not expectation management. We don't control the database itself. We make requests upon it, and it's old. It's very old, and I don't, and I'm not in charge of it. So, but I know that they do work with. They do the best that they can, And if there was any type of temporary movement of license or what, I'm sure there'd be a form that could be created for that, and we could track it somehow. That's not an issue.
Come back to you and say,
Well, I
here's-
would say that, from my perspective at least, that building a little bit of flexibility in there to address current rule and building in some flexibility for
I could draft something and bring it back to you. I think that would be helpful because I really need to talk with people in the administration to determine exactly how the function of that language would be. What is it actually? How does it function? So that I can bring it back. I'm afraid that that I'm trying to create a rule or get the language in there that suffices a database more than your intent. So I want to make sure that I get both in there. If I could bring it back,
I'll make it more difficult. But
if I could bring it back to you all in July, that would be.
That sounds great.
That would give me time. Okay.
Yeah, the only thing I would add, I think majority owner is probably the best place to focus. I know that the percentage of ownership changes. All be different. So focusing on a majority ownership for like control, it's going to be hard pressed to put it on a parent organization with subsidiaries because most of them don't. Time requirement that would require a permanent license change versus a temporary.
Yes. Okay.
And I like you picked up on my fleet issue. If I could ask that he take a stab at the fleet issue as well, because that's a little different, and like you say, because it is a sort of a back end deal.
Luxury of having multiple franchises that actually helps.
That also be temporary in nature or permanent in nature?
I would it would be permanent for
Okay.
fleet. I mean, having a multi-franchise license for fleet support. Again, an administrative management checks and balance on that is something to become.
I just want you to make aware. We do something similar already with exceptions to motor vehicle dealer licensing, motor vehicle show permits, things like that. I mean, think that's actually an exception to unlicensed activity, and we just track it with something.
Could actually make it a separate license specifically for commercial fleet, and then they could have because you're going to have salespeople. Well, I also sell both on the floor as well as fleet. You can have maybe.
But the commission, what the commission's not allowed to do is by statute, the legislature indicates that you cannot create any more licenses than the commission gave you. But what we could do is we have like motor vehicle show permits, things like that. We could have like a temporary ability to sell somewhere else or whatnot. It's basically getting the permission from the commission prior to doing it. But it would and we could probably track it that way. Okay. I'll bring it back to you. And I'll bring it back to you in July.
I second that motion. All in favor? Yeah, there. There's our motion. It's unanimous.
The next item that we had, I'd like to get to the meat of the rule proposals that I provided to you all. And if I could, I could go into explanation of it. Over the years, we've had an enforcement issue. We've had an issue with generally consumers, the complaints that I see in front of me that are probably the most difficult to be familiar with and to decide on are those acts that would be under our statute considered to be deceptive acts. And that's under Tennessee Code Annotated 5517.114B1F. Indicates basically that any motor vehicle dealer or salesperson who commits any act in the opinion of the commission is false, fraudulent, or deceptive, you can revoke their license, suspend it, issue civil penalties. But it just stops there. I mean, it stops there. So any type of deceptive act, fraudulent act, things like that, we have to go through the entire legal analysis as to looking at these things. Now, over the years, what a deceptive act is changes over time because there's new gimmicks and new schemes that come out. Similar to our statute here is under Tennessee Consumer Protection Act, they indicated that deceptive trade practices were illegal and they allowed for private right of action. But over the years, they added specific things like odometer tampering. They added that specifically. And that's what I was trying to do here is that the Motor Vehicle Commission has the ability to revoke licenses, suspend it, or issue civil penalties when they find that a motor vehicle dealer has committed a deceptive act. What this would do is by rule say, over the years we can agree that these are deceptive acts, point blank period. So if we see these things, then the commission has already weighed in that they're deceptive. And what that helps is that helps us in the legal department, that when we want to actually write a consent order to somebody, instead of spelling out 15 things and then all these facts that I think are relevant, I give them 20 or 30 facts, and I say that was a deceptive act, that we can say in there, we can point specifically, this is what you did not do. And it would be very beneficial because going down the road, Patrick Merkel is gone from this position. Tony Glandorf at some point in time in the future, no plans right now, would be gone, but so that we don't lose the knowledge in the legal division as to what the commission has said would be deceptive acts in the future. And what I attempted to do was just list out things that I commonly see that I think would be deceptive in there. And I didn't do this just in a vacuum either. I went and looked at a lot of the jurisdictions that surround Tennessee. I looked through Kentucky and North Carolina. I looked through Georgia and Alabama, and I tried to look at their rules and statutes to see if they kind of have done something similar, so that I wasn't kind of recreating the wheel when doing so. I found that many a times their motor vehicle commissions are already still a part of their departments of revenues and motor vehicles, so that they're kind of interjoined and they all have the same kind of statutes and rules. But we do run across where there are rules under the Department of Revenue that you all would say, of course a dealer has to do that. A dealer has to do that. If you're going to sell a salvaged vehicle, you need to disclose that it was salvaged. You need to disclose that it was salvaged. Would you all agree to that? Okay. I see the head nod. I want to make sure I got the up. Well, there is not a statute. There is not generally a statute on that in the Department of Revenue. It talks about a salvaged vehicle that is there. Mr. Weaver could probably we could go back and forth. I would agree that you have to do it, but I have not seen the statute that says if you sell a salvaged vehicle, you have to report it. It's there for flood vehicle, but it's not there for salvaged vehicle, because I've looked. And I wanted to let the commission say, you know what, we're going to say that is a deceptive act. If you don't have it disclosed in writing, that would be a deceptive act, and that would help us out so that we would.
Mr. Weaver, agree up to the point where it's a knowing standard, because part of the fight in 1996 and 7 that we fought on salvage title branding was that there are folks who spend a lifetime washing titles to where a legitimate dealer doesn't know the vehicle's been wrecked. So, and then you have the advent of Carfax and these other organizations who are adding information after the fact, sometimes up to a year or more in arrears. And so I think without a knowing standard, I would have to strenuously object to saying just on its face that it's either got to be a rebuttable presumption or it's got to be a knowing standard, and I'd argue for a knowing standard. You still have the state of Mississippi, Commissioner Vaughn, that has no title branding law, which is the very reason the Tennessee law, it was a unique feature when we passed it, why on a title you'll see all the two-letter state abbreviations on the title. And that was the only way we knew to forecast to read Trickett that car's been through Mississippi, you better look again, because that's where they were taking the path of least resistance, because the value of that car is exponentially increased with a clean title versus a salvage title. So yes, I think if a dealer knows it, a dealer should disclose, and I would strongly support that effort. But I think you have to understand there's still folks out there who spend their life trying to figure out how to wash these titles, because it's in the billions of dollars, not the millions of dollars, how much is at risk out there.
Absolutely.
I would
I
agree
agree
if
with
I
that
didn't put
totally.
that in there. Thank you for catching that, because generally that is something that I generally would have to show every time, is that he knew it was a salvage title and salvage vehicle, and that usually came to him by ways of the title. It was
Almost a
indicated on
Mars
that.
versus Max used car standard, where the guy sold the truck to the customer. He never knew it was a salvage title until he paid it off 3 years later and got the title back from the loan company. Behind the as-is disclaimer, that clearly, and the court clearly held that was a deceptive act and should have been treated as such.
And what I generally get from time to time is this complaint, it happens a lot, is that the dealer says, somebody buys a car, a certain amount of time passes, they find out it's salvaged, and they said the dealer never disclosed that it was salvaged to me. Yeah, I disclosed it. I told you. And that's what the dealer says. I told you, remember, we sat down, we talked about it, we disclosed it. Well, then I get into an issue is who are we going to believe on this issue? The majority of the time that vehicle was repossessed for non-payment. Well, then you have the consumer who's had an issue, and you have the dealer who has an issue. Sometimes the consumer comes back and says, well, I didn't pay it for anymore because it was a salvage vehicle and I told you I wanted my money back. Well, if we could make it so that when the dealer knows, and I agree, that when the dealer knows that vehicle previously had a salvage title, that it be disclosed to the consumer in writing. Because I have a lot of times where the consumer says, you never told me it was salvaged, and we get a copy of the deal file, and sure enough, it's stamped on there. The title that you will receive is going to be a branded title, possibly rebuilt title from a previously salvaged vehicle. And I would get back that's back on the consumer to be aware of what they're signing when they're being disclosed such in writing.
And I would actually just like to echo the knowing part, and sometimes it's not just 3 months down the line or a year down the line. I'm dealing with an issue where Carfax reported a total loss 3.5 years after the total loss, and the titles came out of New York, not branded, marked no damage, and I'm dealing with the repercussions of a year after 6 months after they sold the car, Carfax is now showing a total loss on an accident that wasn't on Carfax before, still not in AutoCheck.
Believe me, I can say lots of things about Carfax, but not on the record.
Yeah. I'll follow up with a few comments of my own.
Daryl Noble from the Tennessee Independent Auto Dealer Association. This is one of the biggest complaints that we get in our office from a consumer. Consumers must think that they get to call our office with this, but we try to help them, and you're right, it doesn't show up on Carfax. The dealer a lot of times doesn't know about it. They are out-of-state titles. They are washed. But most everybody, and I'm sure the franchise dealers have it in their DMS system, and most of the used car dealers do, that there is a salvage paperwork that tells you that you're purchasing a salvage vehicle. And a lot of dealers don't have it, but we strongly believe that's important for every consumer to know that that's what they're buying. But not only the consumer, it happens from dealer to dealer on a wholesale basis. And if it's not on that title, and then that dealer takes that car 6-8 months later to the auction, and Carfax or AutoCheck has decided to put it on the title, then the auction kicks it back, and the dealer's got nowhere to go because he has no repercussions with the dealer that he bought it from. Some of the states, actually, I think North Carolina's got one that you've got to actually tell them that if it's been in a major accident, whether it's on the Carfax or not. Cars in the Carolinas.
Question is, how do you implement something into specific items with the knowingly? I mean, what do you use?
I would put the language in there for any vehicle that was. I would have to amend the language so that it basically applies to any motor vehicle that the dealer sells where he had knowledge that it was previously salvaged, and just having the knowledge, just inputting that in there would work fine because there's many ways that you could prove somebody's knowledge of something. Specifically, the way we do it, through the auction documents that we received or the titles that the dealer had received. Generally, how we would.
Do you need some sort of motion to?
No, we'll go
Okay,
through
good.
all of these. We'll make that, and we can do it at the end because I mean
Fabulous.
we're on B, and I don't even think I started on A.
Yeah, I'm not sure.
But I would like to go through it now. Okay, so we've got that one now. A. Here, this is where a dealer is required to post a buyer's guide under the federal rules and for the FTC regulations. That's where buyer's guides were created, and every dealer generally knows they have to post a buyer's guide on the side of the window. Our investigators like to go out there and try to write them an agreed citation for that. You can put a buyer's guide on the window. Not in the Motor Vehicle Commission rules or statutes. Not in there. We'd love it for it to be in there. And I think that that it's such a standard nowadays that the commission could say that failing to do so is a deceptive act. Because what that's really doing is trying to educate that consumer. You all know. Educate that consumer on what kind of warranties would be coming with this vehicle. And without that in there, you'd be surprised about the contracts I see. As is no warranty. And then underneath it says 90-day warranty. Well, so what is it? The buyer's guide really needs to be the one that indicates exactly what it is on there. So if that was out there, then every time this occurred, I could easily just go and say, here is our authority to issue out a civil penalty, just like we generally would do for buyer's guides, that you didn't have them posted in your windows of your vehicles.
I might point out it's the Federal Trade Commission's used car rule. It's where the buyer's guide is defined. It says need definition. And it does prescribe the form, the ink color, the size, what can be on there, what can't be on there. Can't be personalized with your dealership logo and all that sort of thing. And literally, they prescribe everything about it, also to where it's displayed. And so it can't just be conspicuously in the window. It's got to be in compliance. If you're going to go down that path, you have to follow the used car rule, which specifies all that.
Right, and I think I put I have a parentheses in parenthetical here for a need definition, and that would go back to specifically I would state the FTC rules for the buyer's guide, that they would have to comply with that.
Tony, can I add something to that? It needs to be in there if that vehicle is. A lot of dealerships will have them behind their building. They're at recon. They're in the shop. They're not ready for sale yet. So.
And I have it here for any motor vehicle offered for sale. That's being offered for sale. That's my understanding.
But if it's a demo?
Available for sale is the
available
term
for sale.
of art.
Okay.
Yeah.
Available for sale.
I am.
I
Just
see.
thought I'd share
Yes.
that. Making no more demos. I always drive a used car.
Okay. And C talks about frame damage. And we could have lots of discussion about frame damage. Mr. Merkel over here could probably talk to you from his side of it. I'm sure Mr. Weaver knows about it from that side. What I have an issue, what I generally end up getting an issue with is that you have vehicles that are just disclosed as having frame damage at auction. Just frame damage. We're not even talking about unit body damage. Frame damage. It's listed at auction. The person gets the vehicle. They drive it. Something happens. They find out through a Carfax auto check. There it was. Frame damaged vehicle. You bought a frame damaged vehicle. Here's your depreciation of the value according to Carfax. Whoever they turn around and try to sell it, every dealer who they try to sell it to or any other consumer pulls that and says, "Oh no, you got a frame damaged vehicle." And the dealer goes back and says, "I disclosed to you that it was frame damage, but it's not in the contract anywhere or anything like that. So we have a problem with consumers who are buying vehicles who are indicating that the dealer had knowledge that it was frame damaged, and they were not told that it was frame damaged. That would be separate from any type of unibody damage, and that's why I would indicate that if any vehicle that's why you have language in there where if the auction disclosed that it's actually a frame damaged vehicle, then it should be deemed to have frame damage by the commission, and it would just have to be disclosed to the buyer. That would be helpful on the enforcement side, because other than that, I really don't have a way of prosecuting any type of dealer where, it says frame damage on the actual documents, because I have a complainant who thinks that they've been wronged by a dealer, and in order for them to prove frame damage, that dealer themselves, the consumer, they have to go and get some kind of a mechanic, some kind of expert. They have to hire somebody to tell them that it's frame damage and send that to me. Or the state of Tennessee, if we try to prosecute a dealer, we would have to go and get our own expert witness, some mechanic, to go and view the vehicle and see that it's frame damage. So without a real rule on here, we don't have a lot of authority to actually enforce selling frame damaged vehicles without a disclosure.
The challenge with that is going to be is that you can't get two people to agree in some cases. This is such a hot topic in the auction world within AAA standards and different to agree specifically on what is and what isn't frame damage. Unibody kind of rolls into that same argument. That there is a clear, defined definition of what is and what isn't frame damage. You're going to constantly have the Carfax reporting one thing, the auction reporting something else, and we're a ways off from getting that resolved, I believe.
But when it comes to this, my thought is it needs to be knowingly, same as B. Because, if somebody knowingly sells a car that has frame damage, regardless of, what that definition is.
Right, and I was trying to go a step further, because to actually show that frame damage, there has to be proof put on. And that would be my office would have to show that vehicle is frame damage. We have to have the vehicle, somebody inspect it, certify that this thing is frame damage in their opinion. There
are companies that will do that?
There are. In the state of Tennessee, I guarantee.
There are, but
yes.
Again, it's which source is reporting it. Because I can tell you, Carfax will report frame damage, and I've got 3 inspections that says there wasn't any.
Absolutely.
Carfax will report whatever's sent to them. They don't verify anything.
Yes, my understanding
But
is.
the consumers believe that is the gospel because of great marketing from that particular company. So.
Errol, go ahead.
Yeah, coming from the auction world, and Commissioner Cullum, you're there too. There are companies out there, fleet companies, lease companies, that sell every single car with frame unibody. It's on every car. Doesn't mean that car has it. They're just covering themselves. They don't want the checks back. They want the car to be gone, and it's done and it's over. I'll take a car, and I've done it, bought it at Manheim, took it to Odessa, sent it on a post-sale inspection, and it passes with flying colors. Bring it back to Manheim 30 days later, sell it again, put it through a post-sale inspection. Manheim says it passes. There's no frame damage, but yet I bought it 30, 45 days ago with frame damage, but there's no frame damage on it. If we're going to do that, the dealers are going to be in trouble, because there's probably 300 or 400 cars, maybe 500 cars in this market alone being sold every week with that title, with that being branded on there.
And I guess what we have is we don't have that this commission can't enforce a vehicle that's been sold that's frame damaged then. I don't see how you would do it. That vehicle could be bent in half, and our department does not have the first dollar that they're going to spend to get an expert to come before the commission and give that type of testimony. It's not going to happen. We've asked for it. No. And that's just one of those things where part of my job is having to explain to that complainant why we had their complaint closed when they showed me a picture of a vehicle that has got a bent frame on it, and in my opinion it looks to be bent, and it was actually announced at auction with frame damage, and then the dealer can say, well, I didn't know, or maybe I did disclose it and you didn't find out. That we will not be able to prosecute that person because of the fact that the burden is on us to do that. And I hate to bring up budgetary issues or whatnot, but we do have issues that we are not going to have anybody else step forward and do that.
sell it and they don't disclose frame damage, well, they never had an inspection. You can literally, I mean, the way the jacks are made now, you put them on you have that little groove and you jack up the car. Changing a tire will give you quote unquote frame damage. Now, does it affect the safetiness of the car? Absolutely not. But according to NAAA guidelines, it could be classified as frame damage. So harping on it, but without if we want to, as far as disclosure, knowing disclosure, I'm not opposed to that. I mean, if the auction announces this car has frame damage, and dealer A buys it and then sells it and doesn't disclose it, okay, fine. That's probably something we can control. But knowingly it's hard, especially if the car is moving from dealership to dealership. It's I don't know how you'd patrol that, and it puts so much burden on the dealers. I don't know how they could control it.
Keep going through there where they put that legend on every vehicle, whether it's got it or not, to cover themselves.
I understand where the standpoint is that with so many vehicles nowadays that they do put on their frame/unibody damage, and there's nothing wrong with it. Now, if the dealer has that and he sees that there's like a nick on the side door, he fixes that for costs him nothing, or maybe there's nothing wrong with it, and he discloses it to the buyer. You're going to disclose, well, this thing was announced at auction as the frame or unibody damage. And then they say, well, let's talk about the price then. It's going to say,
okay. You better buy it right. It's the only thing that you can say.
Can I say something?
I stand to be corrected, but if you go back to 55.2, under the rebuilt, when we went through the salvage title branding, I think frame damage is one of the things that requires the surrender of the title for a rebuilt certificate. Put up here in B that if it's got a salvage or rebuilt certificate and you have to make that disclosure, we may sort of get to where you want to get, Tony, because if that triggers it and we have to make that disclosure, that's something a dealer can get knowledge of, and if he knowingly sells a vehicle that's had a rebuilt certificate or a salvage title, then that could be your violation.
Yes, I think we had the discussion earlier about the salvaged or rebuilt certificate of title, and I think that would cover any vehicle that received frame damage and receive a certificate or rebuilt due to the frame damage. Yes.
Yeah.
What I'm trying to, I guess the issue that I'm running into, in all honesty, is where you have vehicles that are announced at auction, frame damage / unibody damage, and the person is purchasing that vehicle. In many cases, the dealer hands them the Carfax. That announcement isn't on that Carfax yet. We had one of those this morning, and they purchased that vehicle and they didn't disclose that to the buyer. Maybe there's nothing wrong with it, but maybe there is. And I just needed really guidance as to how should we prosecute those things. It was announced at the auction and printed out the Carfax, because if you sell it within 30 days of it being at auction, the announcement hasn't made it on Carfax yet. So they say, show me the Carfax, here it is, it's on there, it's not on there, and then a year later it shows up. And I had somebody who showed me the Carfax that the dealer printed out a year ago. No frame damage, no unibody damage. The auction ticket shows announcement, frame damage, unibody damage. They turn around and try to sell it at CarMax. CarMax told them that it had frame damage and showed them the Carfax, and from that auction the dealer bought it out. It now indicates that there is frame or unibody damage. So, and it's not anywhere on the documents. I look at the bill of sales and everything. There's no disclosure on here. I don't know what's wrong with the vehicle. I have no idea.
That just shows that Carfax isn't a reliable source for that.
Other than I did have the auction ticket that had the disclosure from the auction that it was frame / unibody damage. I know that Carfax is not it has to all be verified. That's usually why I get the complaint, is because of Carfax. I verify that through the auctions.
Those particular situations, when I deal with those, because I have to deal with them all the time as well, and what I do is I go back to the starting point and the timeline. And the vehicle was sold at auction and announced to the dealer who bought it that it had frame damage, and that dealer sold it and didn't disclose it, then it would fall back on the dealer, in my opinion. He clearly was told, and whether it had it or not, it was disclosed, and he should have either disclosed that it was announced, but shown that it didn't have it, or something of that nature, show some kind of a waiver or what have you. That particular situation, that seems pretty cut and dry. The issues that you run into is when there's nothing announced at the auction, and the dealer sells it, and a year.
Yeah, and
those are the ones that seem to be the.
And I don't have a problem with those.
Is still.
Yeah, I don't have a problem with those because I think that goes back. That dealer had no idea. The dealer had no idea. I mean, if the dealer doesn't know, if he didn't have the ability to know, then I wouldn't impute that knowledge on him whatsoever. It's where they actually have sold that vehicle and it was announced as unibody frame damage, and then they go out and look at it and it says like it's on a certain rocker panel, and they look and sees that there's a rock hit it, and now it's like this unibody type damage thing, and he fixes it for Patrick had a client who did the same thing. They fixed it, and it wasn't disclosed to the consumer, and then the consumer time period goes by, says, "Hey, look, not only did it was actually announced at auction, but you fixed it, and you didn't even tell me about it." Well, did it materially affect the value of the vehicle? Probably not. No, maybe not. I mean,
once you fix the vehicle and start painting on it, it changes the value of the vehicle drastically.
The question is materially affected the value of the vehicle. If you have a small dent in the side door, rock thrown on it. I mean, I don't know. I'm not the expert on this whatsoever.
Once you start doing, PDR on it and you put paintwork on there.
Mm-hmm.
I mean, I bought a car a couple of weeks ago and it got here and it had paintwork on the back from Texas. I called them up. I said, $800 and I keep it or you pick it up, because I bought a no paintwork car. It changes the cost of that vehicle drastically. But back, if we start asking for frame damage, and I believe that there's cars that need to have it on there, Tony, I do. But if there's 300 or 400 cars in this market, or just in this state alone, going across the block every week with frame unibody, okay, and we were going to make all the dealers start telling everybody about it, even though there's none on there, that's going to change the value of that car, and the cost of that car at the auction is going to go tremendously down, and the manufacturer or the fleet lease company is going to it's either going to have to change the way they sell their cars, or they're going to take a bath on their money.
It would have gone down anyway if they announced it.
Yeah, but I stand in those lanes like some of them, Commissioner Collum, and like you stand over in the city lane there, and those guys just bid and bid and bid.
Oh, they still get purchased.
They're still buying the car. I mean, they're not taking a 10 or 15% hit on that car.
They're not taking a 10 to 15% hit as long as it's not reported in Carfax.
Right.
But
see, these guys are standing there with their scanners, and they're going, "It's not on Carfax because I can do it right now."
But that is, I think, exactly the scenario that we're trying to protect, right? Which is the deal that was announced with frame unibody. The dealer knows the consumer is only looking at Carfax in that particular scenario. It doesn't say, "Hey, I can buy this car at theoretically under market value because of the price of it, and then sell it retail before it goes to Carfax." Something along.
That's what I'm. Right? That is exactly what I'm trying to get at.
Yeah.
I only want to. I would only be interested. It would only be helpful for a rule where the dealer was there when it was announced as that condition. And I don't look at Carfax to determine where the announcement was. I literally go back to the auction and say, we would like to see the paperwork on that deal, and when it had the announcement on there that it says unibody / frame damage, and the consumer indicates it. They weren't told, and it's not on the deal file whatsoever on any of the documentation that should be a violation. That the dealer should disclose that, and they can put any kind of disclosure. Hey, it says that, but I disagree completely.
Yeah,
whatnot.
you can put that all
I mean, is that too much? Is that gone too far?
No, I mean,
from everybody's standpoint.
I'm just trying to keep a flood of things coming here, and dealers not able to sell some of the cars they buy, but yet still protect the consumer at the end. And I do agree that if a car's got really damage, frame damage, it was in an accident, and once it has frame damage from an insurance company, it becomes a salvage vehicle, because there's a lot of stuff out there that doesn't have frame damage that's announced frame damage. It's a fine line.
I would like to think there's something between Mississippi that has no law and Minnesota, Wisconsin that have very strict laws. I'd like to think there's at least some common definition that Commissioner Cullum were searching for earlier, and I'd like to suggest that we just, let's all put our thinking hat on this one and see what we can come up with. We know what the intent is. The intent is to protect that innocent consumer or innocent dealer from getting a dealer trade without knowledge and selling one and then find himself in violation.
Modify the requirements to make them more specific to addressing safety versus just I jacked up a tire and I dented the frame. Designers, anyone that's selling cars at auction, know that if the vehicle truly has any kind of damage like that and you announce it, not in a strong market like we just had, but a normal market, yeah, it's going to affect your value. Carfax will definitely affect your value, whether it's relevant or not. But so the argument about what's considered frame and unibody and what has material effect on the vehicle, the car, that's what I think when they come to that conclusion, then all the auctions will pretty much have to abide by that particular ruling. Auction, then making the dealers disclose it, I don't think is such a bad thing. But until that happens, you got so much variability there. I don't know how you.
Should we? Maybe what I could do is that we could do a study on it. I could keep records of all of the complaints that I get in where it has a unibody frame damage issue and give you a synopsis of the facts involved in that, okay?
Excellent.
And then I think what I could provide you, maybe more of what I should look towards now, is where the complainant has actually provided me with actually evidence documentation of a safety issue frame damage. How's that?
Sounds good.
Because, I mean, that would probably kind of really the heart of the matter here. Sure. So we'll do that then. I will set that up and report back to you all.
So we go through this process. There is a legislative referral that we've been made that we'll not get to before
Yes.
we adjourn today.
We will. I will. And we don't have to go through all of this today. We'll try to get as much as we've done. I'm sure, but there was one other thing that wasn't a part of this packet that did come in late this past week. Was that we had a legislator who was contacted the Motor Vehicle Commission through our representative liaison. Senator Jim Tracy sent an email to our liaison Charles Schneider and Denise Lawrence, and he basically indicated that the organized unlicensed sale of motor vehicles, curb stoning, is a huge concern that he has. He says that basically it puts consumers at risk, lost sales tax revenue is created, and legitimate dealers are forced to compete against these unlicensed, unregulated persons. And he asked the Motor Vehicle Commission through this committee to develop a proposal on the issue of curb stoning and recommendations to his office no later than December 1, 2013. I'm assuming this is in order to pass a state legislation that would affect the issue. And can I give you guys copies of his? I'll give you guys copies of his.
While he's passing it out, Senator Tracy is chairman of the Senate Transportation Committee, and so he has purview over motor vehicles and things of that nature. And he's been particularly sensitive to the issue. And there were several drafts attempted by staff this year, everything from a $50 civil penalty, almost an ordinance-based fine for selling illegally on public spaces, to, quite frankly, an approach I threw out, which is if you're serious about the unlicensed sale, make it subject to the abandoned vehicle statute and incentivize local governments to go pick these cars up. And if someone couldn't prove ownership, let the local government sell them and keep the money, because they've got the tow trucks, they've got the auction access. Some people thought that was a little draconian, and can't imagine why. But I mean, you've got several logistical problems. One is somebody's got to police it, and somebody's got to do something with the cars when you find them. And so there are several approaches, but first and foremost, Senator Tracy wanted me to speak to the committee to say, under no circumstance is he interested in preventing an individual and inhibiting their right to sell their car. He's not interested in that. And there's a Sixth Circuit Court of Appeals case on this. Tony, I don't know if you got it. Okay, it's it's Pagan versus the Village of Glendale, Ohio, and they point out that there's got to be a valid state interest to overcome the challenge that you're infringing on commercial free speech. And in this case, it was a local ordinance that prohibited the sale of cars on public rights-of-way. You know, it's an 8-7 decision. They overturned the federal court. Justice Gibbons, or Judge Gibbons from Memphis, was actually the trial court in this case, which upheld that. There's 200 ordinances that this decision, this 8-7 decision, and there's a very strong dissent that I think the dissent can guide us in what we might want to look at in terms of coming up with a plan. But I would just encourage all of us as we go through this process, recognize up front and to, quite frankly, sell it to the legislature. They need to be assured we're not trying to inhibit Patrick Merkel's right to sell his car. We also need, I think, to make the case that many times it's this organized activity. I mean, there's all kind of new investigative I-team stories that show them bringing in these cars on these rollbacks that are flood cars, that are salvage cars, that are damaged vehicles, being parked in everything from a shopping center parking lot to a city park with somebody's called Bob and Bob's cell phone. And so someone's thinking they're buying this from an individual. And in fact, it's an organized activity that are selling damaged vehicles to consumers, and the consumer's never going to be able to track the seller down. And so there's a consumer protection aspect. There's also the realization that I sell you this car, and you go to the courthouse to get your own tags, and you report that you bought it for a much lower amount in the bill of sale. There's sales tax loss there. And admittedly, at the end of the day, there's legitimate dealers, new and used, who are having to compete with unlicensed, unregulated, unscrupulous individuals and entities. And so I think that's a valid issue, and I would hope working together on a pretty short time frame we could report something back that we think is balanced, makes sense, and will protect the public.
Bob and I worked on this together, and it's a big problem in our area, but you can go to stopcurbstoning.com. It's a nationwide thing. It's ran by the Auction Access, owns that site. They're the people that own Auction Insurance, that insure all the auctions. They said based on the amount of people that live in Tennessee, it's probably a $25 to $30 million tax revenue problem for a state this size. That's a lot of money. You know, when I drive up and down the road and I see, you know, a place that's got 5 or 6 cars out there and 4 of them got the same phone number, I know that guy's in the car business. He's not trying to sell his own car, you know. So, let alone the liability for the shopping plaza if somebody falls and gets hurt. So,
to do, I mean, we obviously have clear rules within our statute as to what asking that we recommend some kind of it currently is the civil law against curb stoning. Is there one? I mean, we have our, we manage licensed activity, right? I mean, this is clearly unlicensed activity. Is there currently a law on the books now that if you're caught doing this, you have some kind of penalty?
We do have rules, existing rules, talking about the unlicensed sale of motor vehicles. And there's also a provision over in the Consumer Protection Act that addresses advertising. Someone who advertises in the Tennessee in violation of our advertising. That, quite frankly, dates back to was addressed to folks in the state of Georgia and Alabama who, after Tennessee adopted advertising rules in 1988, took great advantage in running all kinds of ads in the Tennessee media. That, quite frankly, was a little unfair to someone trying to abide by Tennessee rules, and it speaks to folks who seek to entice buyers in the state of Tennessee that are not licensed in Tennessee. So there are those kinds of things we can pull together. I think I know what Senator Tracy ideally wants to do, have happen, is for this group, based on your experience as dealers, for the manufacturer and others, consumer input, and then the overall input of the commission, what's something that's workable? What makes sense? Because, in his words, this body is certainly the more preferable audience or participatory group rather than a legislative study committee, many of whom maybe all they've done is bought several cars themselves. So this is the group he thinks would have the expertise to give him some guidance, for him to get some kind of proposal in December, and then for him to decide whether or not that makes sense, and for him to have a bill drafted, for him to pursue legislation based on your recommendation.
Currently, the commission is the only one who actually has the authority to enforce any type of curb stoning. I mean, that's it. No one's going to be pulled over from the by the police department, sheriff's department, get arrested for selling more than 5 vehicles a year. I mean, it's just not going to happen. Yeah, is it a Class C misdemeanor? Yes. They've told us many times, 5517-109 is not in their database, and they're not going to charge somebody with it. We've been told that straightforward. It's very difficult. Now, we do have investigators who have done excellent jobs and have really good relationships with local law enforcement to assist them when they can show that law enforcement officer, look, 6 vehicles, there's the guy. Can you help us out to help clarify this issue? They'll work it, but we, the complaints that we receive in are complaints that come from generally consumers out there. Or the investigators will see something and they are forced to, they have to also file a complaint with us, give us something we can set up a complaint with. There is not the Motor Vehicle Commission here. You do not have roving investigators who are the eyes and ears of the commission going out to do that. That used to be the case. All of your investigators now are under the investigation division. They're under Mr. Key. He controls them. We basically have to ask them for an investigation to be done and whatnot. That's how it's done. So it's very difficult to be proactive the way that we operate right now. That there's challenges to it. Now, when we do get complaints for curb stoning for unlicensed activity, we aggressively go through those with our investigators. Hit or miss. Hit or miss. I mean, it's just there or it's not there, or whatever. I mean, like Mr. Weaver said, if they're organized people, it's hard. We've got to. We track them down. We run with them. We work the best we can. And generally, the best that we can generally sometimes do is we can see and prove the allegation. And who knows if that's the actual real person's name? Who knows if that's their driver's license? And they're gone. Poof. So a lot of times, I actually end up bringing these back to the commission, saying we can't find this person. We don't know if it's even if that's who they are.
Which is why I thought, if you put it under 5516, which is the abandoned vehicle statute, you basically show the money to local governments and say, if they can't prove who they are and what they are, and those vehicles are forfeited to governments, then they get to sell the cars and keep the money.
Yeah, I've spoke with Terry Ash. He's the director of the Tennessee Sheriff's Association. He also in Lebanon, Tennessee, and he said this is a big complaint that they get in all the sheriff's departments across the state. It's people parking cars wherever and selling them on people's property without even asking for them. I know the city of Maryville over in East Tennessee's got a ordinance against that, and I know their local government polices it pretty well. So that might be something we want to take a hard look at. But I know the Sheriff's Association would probably act on on policing it, if they were given the authority and the proper training on how to do it. Of course, they don't want to pick up anybody's car that they shouldn't be picking up. But he said these cars are everywhere. He said he gets complaints from McDonald's, banks, shopping centers, you know, because the managers there, they don't know who to call about these unlicensed vehicles sitting out there.
Quite an issue in Memphis as well.
Yeah, Memphis, I
It's
get a lot of
all
calls.
over.
Yeah, but it's not. It's just everywhere. It's just everywhere.
I guess, would it be enough time to get something put together before our next meeting and then address this definitely so that we can have something back to them before their meeting in December? Is that possible?
You consider it being presumptuous if Mr. Noble and I
That would be
if I can talk him into it,
lovely.
That'd be perfect.
try to come up with something,
Excellent
let you
plan.
look at it.
Definitely.
That'd be all right.
That's excellent.
Okay.
I like your idea.
Back to where we were discussing these deceptive acts. I told you it would take an hour, and it's past that time. So I just don't. I do not know how much longer it would take. I'm not pushing you to move forward any faster than we. Want me to go through what I would think are more priority things to look at right now? I can do that. Okay. I know this could take us much longer than what it has been.
Do we have a set plan to meet the next time as well?
I will. I would put it on
Okay.
if we could. I'd like to
That'd be
place
great.
it on the agenda. So because I didn't intend to go through a rulemaking hearing next time. I can't. These have to be looked at through my boss, through the legal division. They have to go up to the assistant commissioner. The commissioner has to look at them before I can even ask the commission to have a rulemaking hearing on. Back and then we present them to our bosses to let them look at it. So. Anything that we don't
Tony,
cover
in
here.
the interim, would it be appropriate if ever watching this live streaming video, if they're still with us, if they had comments on what's here, would may we
Yes.
copy the subcommittee, or rather just send them to you?
If you, whatever is sent to me, I will give them in writing all of the, all of the notes and all of that, because I think that would be absolutely relevant and good for you all to look at, so that if we have any comments about what we've looked at, then I can show you those comments going forward.
Okay.
That'll keep things moving along.
Mm-hmm.
Okay, so I would like to, let me circle things that I would like to talk to that would be more relevant. F. Okay, so talk about D, issuing of temp tags with a salvage certificate of title. Okay, so we have dealers out there who think that, one, it's nothing wrong not to sell a vehicle that had previously been salvaged and is rebuilt. Dealers sell consumers a vehicle that has a salvaged title, has not even been rebuilt. Many times the consumer wants to rebuild this vehicle themselves. They're intending to buy a salvaged vehicle. Memphis, I see a lot of it, where somebody wants to buy a salvaged vehicle. I generally don't have an issue with that because the consumer says that's what they wanted a lot of times. What happens is that dealer sells them a salvaged vehicle that actually does run, and this thing is, by its definition, not legally can be operated on the road. And then they give them a temporary tag, 2 temporary tags, 3 temporary tags. And they're driving a salvaged vehicle, salvage certificate of title, all over the city of Memphis. And usually or in other places, but Memphis comes to mind. And what ends up happening is that the person then later complains that they couldn't get a title on that vehicle. Well, they can't get a title because, one, they can't get registration is generally their issue because it doesn't have a rebuilt title. Department of Revenue will not issue a title on a vehicle that was sold by a dealer to a consumer and not and when it was rebuilt by the dealer and the consumer hasn't been the one rebuilding, where the consumer is applying for it. That's part of their rules. They won't do it, and they generally don't have a lot of sympathy for that consumer out there who says, well, this guy defrauded me. I didn't realize that he was the one applying for the title. So one of the issues that I had, one of the bigger issues that enables them to do this is where they're giving them temporary tags. Salvage vehicle, drive it off lot, here's your temporary tag. We don't have a rule on it. It's come up in the last year and a half, and we've had discussions in the enforcement side amongst us attorneys as to whether or not issuing a temporary tag to a salvage vehicle is wrong. I believe that is wrong because I know that vehicle by definition is not legally operable on the road. I don't have an issue with it. There's other attorneys out there who haven't read all of the motor vehicle dealer statutes and statutes regarding the duties of motor vehicle dealers, so they don't understand where I'm coming from because it's not in our rules or statutes. If it was in there, then it would help me address some of these complaints that we have in there, where you have, the consumer, maybe I can't really see the bill of sale out there or whatnot. Maybe I'm having proof issues or whatnot. But if I can show that, yes, you had that vehicle and you issued a temporary tag to that vehicle, then that'll be good enough for those deceptive acts.
The title being
Pretty clear, cut and dry.
Salvage title is on the vehicle, not a rebuilt title, salvaged.
I think once the title's been, if I remember the statute correctly, and it's 553201, vehicle is subject to total loss and the title is surrendered, and then certificate entitles them to rebuild the vehicle. And at that time, they go back to the state, and if they can show that the cost of repair was less than 75% of the pre-accident condition, exceeds that, then they are required to get a salvage title, and that was based on the Federal Task Force report back in 2000. Came up, but on a rebuilt certificate or a rebuilding certificate, I don't believe that car is capable or authorized to drive on the streets of Tennessee.
This is where the definition of a salvage title indicates ownership of the passenger. It indicates as part of it means passenger motor vehicle ownership document issued by the state for the owner of a salvage vehicle. Ownership of the passenger motor vehicle may be transferred on a salvage title. However, a passenger motor vehicle for which a salvage title has been issued shall not be registered for use on the roads or highways unless it has been issued a rebuilt title. And I go through there and I say there's no way that Revenue ever intended a temporary tag to be put on a salvage vehicle.
Okay.
And then okay.
Any other discussion? No. We're good. Keep moving.
Okay, the next one is a little bit more contentious. Number E, failed to provide a certificate of title or registration to any consumer within 60 days from the date of sale. I just threw it out there. I'm not really sure if you all would be agreeable to that, but there is issues with dates.
Mr. Weaver?
60 days from, make sure the title has to be issued or that has to be applied for.
Title or registration.
I remember back, and some of you in this room remember, when it took the state almost 6 months to issue a title. It was a horrendous problem, and part of the solution was going to be the trust system, which has now been abandoned. So we're back to the same Odyssey system that's been operating since I was in the Department of Revenue in the late 70s. And so I'm just saying that perhaps you might make it a rebuttable presumption that it might be deceptive, because there are some areas of the state where I understand, Tony, it's a real problem that they never get around to applying for registration. They're waiting to repo the car before, so they don't remit the documents. If that's what we're after, I'd really rather go in that direction, because I've seen where legitimate people, maybe there's a problem getting the title from Plano, Texas, where it's been held in a vault, and, you know, you'd think in 60 days you could, I know on the conditional deliveries or the spot delivery statute, we put 30 days past receipt of funding under the contract to kind of start the clock running. I think maybe that's something we could think about, but a flat 60 days, stuff happens. And I'd hate to make that a deceptive act.
We're talking about issuing the new title for the new purchaser, right?
Yes,
That's what
either
we're
that
talking
or,
about. A
yes.
vehicle sold to customer A, and it's the dealer's responsibility to make sure he gets that title within 60 days of purchase. That's what we're talking
Title or registration, depending how it's going to be.
Going to your Texas example, correct me if I'm wrong, but the dealer can't sell the car unless he's got the title in hand.
That's not true,
Or have it.
Tennessee is a state, unlike Pennsylvania, where you must have title present to sell the car. That's why under the Federal Truth and Mileage Act, the secure power of attorney can be used to execute that document pending receipt of the title document from the prior satisfied lienor. So Tennessee, you can continue to sell a car without the title present. That's why a flat 60 days is hard to make work, because it's been, not in my lifetime at TAA, it's been 6 months at one point in time to get a title from the state. Once you send it to the county court clerk's office. So it can happen. We're not there right now, but I've seen it happen, and I'd hate to set this up as a deceptive act the dealer's guilty of without at least making it a rebuttable presumption of here's why I couldn't do it in 60 days.
When is there a scenario where it makes more sense to be able to sell a car as a dealer? I'm just trying to understand why we do it that way in Tennessee.
Do it that way so you don't freeze inventory. Sitting on the back lot and you're unable to sell it.
Took a trade in today and you paid it off, and then you're waiting for the lien holder. You would go ahead and sell it.
Yeah.
I'm just trying to understand the cash flow. Yeah.
We just had one that came out of Florida. It took 72 days for Manheim, Florida to produce title for us. Now, we could have sent the truck back, but we'd already spent money on it because it's out of the norm at 72 days. Now, if I'd have sold that thing, I would have been we did sell it in the middle of it, but it was 45 days out. We sold it that, well, they're going to get the title. They kept saying title's coming. So now it's sold. So now we sit here and hold our breath. Okay. It doesn't happen every day, but it does happen. And for the franchise dealers, they're taking cars in on trade. They don't want them stacking up behind the dealership. They know they're paying them off. They want them to go to auction, get their money. So when when the titles come back, they cash in their checks. Yeah.
Yeah, and that's the scenario. Yes, that is a scenario that I understand, and we do have a lot of them come out of USA over there in Texas that they have problems getting. We had one this morning, and I generally, when we see those, we end up closing those out. The issue that I run into that gets frustrating for us is we have dealerships that basically they feel more inclined to be a bank than they do a dealership, where they have buy here, pay here, and they are not. They don't title register anything. They don't. They have themselves as the lien holder. They keep them all.
Abuses there then cause problems for people who are trying to do it the right way.
And I can't without something.
We do have a statute now that requires them to make that payoff, and we do have one under the conditional delivery or spot delivery law that says when it has to be applied for. But we do have that one segment that I think Tony and I think all of us would like to address, which is the ones who intentionally never apply for registration, knowing more likely than not they're going to repo the card and they never submit the registration.
That's what I get is I get someone who they haven't registered the vehicle. The consumer is trying to make their payments, weekly payments, bi-weekly payments, however they're doing them, and they're a lot of times they can't make the pay. I get it more than once. I can't even get a hold of them to make the payment. Payment is late. Repossess the vehicle. I come back. I've got no documentation the vehicle was ever sold to this person whatsoever. The papers were in the vehicle, then they repossessed it. That's worst case scenario. That is really hard to indicate, to show anything on that. But we're trying to make it so that we can have something solid, so that everybody, we can catch it. We can make it a little bit easier to catch what that act is, because it's not always temp tags. Sometimes a lot of the issues that we'll find in this is temp tags. We'll have a temp tag issue or whatnot, and we can enforce that. But, issuing more temp tags than allowed is not as egregious as intentionally not registering vehicles, so that, one, they don't even have the title in their name. Two, you don't have to, whatever they paid you, say, $1,500 so far, you take that back, repossess a vehicle, and you've never seen anything remitted to the Department of Revenue, which, for us to get that information from Revenue, we found we have to go through just as many hoops as a regular consumer citizen out there. They do not share that information with us freely. So we're trying to find it, and I do agree. I don't want to be overburdensome on anyone out there. That's why I put this out there, just to see where we can move and what direction is a better way to move for that, and frankly to get your all's opinion on this type of behavior. And
one thing I might suggest, there are two pieces of legislation this year. One has a direct impact on this, I think. Department of Revenue passed a title and registration rewrite, and I will get you a copy. It just passed. I'll get you the final form. In it, it restricts the number of temporary tags a dealer can purchase, and so it will have some break on the number of temporary tags flowing around out there. Still recognize that in a pinch, a dealer can get some from another dealer as long as you keep up with the log and things of that nature. The other is a bill that hopefully we worked in conjunction with you all on, which talks about if a dealer were to drop their surety bond. I noticed that was on your list.
Yes.
Let a surety bond lapse or fail to notify you on relocation. This onto the governor would give you the authority. Well, it says that it would be beneficial to have a specific statutory language to make clear these are continuing obligations of the dealer, i.e. on the entire time they're in business. Also to notify the commission if they relocate, and it would give the Motor Vehicle Commission the ability to exercise.
Currently, right now, a big issue that we have are dealers whose surety bond is terminated by the surety. By rule, they have to cease and desist, which has nothing to do with their license. You have to cease and desist. If we want to take their license away, I've got to bring them in front of you all, and you all say, here's the issue. But one of the remedies that you don't have for surety bond lapsing is to revoke their dealer's license. It's not there. It's not in the statute. So I think what Mr. Weaver and the legislators were assisting with to make that one of those, make that a reason that a license can be revoked based upon, because the dealers that were doing similar to what I just indicated, those dealers who were doing these things of not titling vehicles and repossessing them all, are the same types of dealers who allow their surety bonds to lapse, or their surety bond has been terminated because of all the claims for inability to get a title. So I think that will be helpful going forward in the future for that.
I have a question, please. Can you give me an example of where the surety bond is used, where a payout is issued on the surety bond? What?
Yes, you don't see them, but I get calls from the Attorney General's office from time to time where they go into court on behalf of the Motor Vehicle Commission. 5, 6, 7 times a year, the Attorney General's office. Mary Ellen Knack is the person who represents us up there. She'll get called because there is someone who is being sued on the surety bond, and the Motor Vehicle Commission is actually the beneficiary on the surety bond for $50,000, and somebody wants Motor Vehicle to come in and commission come in with the money. We generally end up interpleading that money into the court system. So an example would be somebody buys a car for $5,000 and they cannot get the title to the vehicle. The example down in Plano, Texas, maybe they can never get the title. It could be an honest mistake. They never receive the title. Well, what ends up happening is that surety bond is for those people who cannot receive the title, and they can we basically interplead this money in the courts, and they can determine who would get certain sum of money for that vehicle because they couldn't get title or registration for it. There's many times when you'll see a dealer go out of business. We'll have 20 of those, and people will get cents on the dollar of what they paid that dealer, because the $50,000 surety bond, in today's money, that's one car sometimes, and you may have 50 of those. So, but that's one example.
The other thing it's good for, Commissioner Murray, is failure to remit taxes to a governmental entity. I upped it from 25, Commissioner.
From 25 to 50, it was a significant jump. I remember when we went and talked to the legislator about it, and they were very concerned over the jump from 25 to 50. I'd have to pull data to tell you, but I've seen circumstances where it was a $90,000 car on one car. For most dealers, it's not an issue. It's somebody who sets up a shell corporation for a dealership, and then their total intention to sell these vehicles and not provide anyone any titles for them. I can stop there. I would like to skip. We can take up the rest next in July, starting at F. And I did have some that I would like to get your opinion on today, if I could, which were regarding inspection of business records. I believe on page 3, what you'll see is inspection of business records, temporary tag logs. I would like to get your all's opinion on this, because we do have an issue with temporary tag logs. And I think most dealers, there's frustration between the dealers and the investigators. The dealers want to do the right thing, but they don't have clear guidance as to what they need to do. The investigators know to inspect these temporary tag logs, and they do it very vigorously. And they do not mind writing notice of violations and agreed citations, but they also need to know exactly how this temporary tag log needs to be. And they like to have it with much specificity. Exactly how does it need to be? And the only thing I can come up with is that our statute indicates that you have to maintain accountability of these temporary tags that are issued. You can't issue more than those by law. But the Department of Revenue has specific rules about this. And it just makes sense to me that if the Motor Vehicle Commission would just copy their rules, then we could all be enforcing the same thing. But as of right now, because of the way our statute is written on the maintaining accountability for these tags that are issued, it doesn't go into specificity as to what that means. Some dealers, they say, Department of Revenue gives out this temporary tag log that you can write them down, but nobody says we have to use that. So I use my computer. I use, paper like this. And the investigators they call me, they have confusion or whatnot. So if we could have clarification, so basically, I've indicated here that anybody who, I basically have copied most of the Department of Revenue rules regarding these things under 4 for temporary tag laws.
Let's make sure it didn't change under this bill I'll send you.
What about, and also what about voided tags?
Yes, that's not addressed here.
I think it needs to be addressed because we have a company policy. If there's a voided tag, the voided tag has to have voided written on it and has to be back in that book. So if anybody comes in and checks our log, they've got to see that voided tag. I want everything accounted for. I don't want to have to go, yeah, that sounds like a great...
We can add, if we could, starting with the revenue rules or whatnot, that what everybody knows generally to be the rule, and then adding that to that, I think that can... we generally do see, yes, voided tags are noted in the log, and that would help for clarification.
Making you think.
But specifically, what they would be writing down is that the name, the address of the license, name, address of the licensee, a description of the vehicle's make, year, model, identification number. That shouldn't be a licensee. That should be the person who they issued it to.
Most of your DMS providers have that in their software. A log system, ours does. And I think that's how we keep up with
Printed out, yes. We have,
a uniform too, though, the motor vehicle or,
Well, it doesn't say that it has to be
Probably
printed.
the DMS vendor, if I had to guess.
pardon?
Probably to the DMS vendor, if I
Yeah.
had to guess.
So I guess we need to make sure that it's covered, that if somebody has it, like a record in the computer or even something printed out, because I have it to where the guys have to sign it just so I know where everything is. But, I mean, it does have it in the system where you can keep track of it in the computer system, like Reynolds and Reynolds or ADP has a
Oh, yes.
listing of it. So
and our rules right now indicate that you can have it in an electronic format. It does not have to
good.
be written out, so long as this contains this type of information, and the information that it started with is just what Department of Revenue actually does require.
This would have, you'd have to have all of this information.
Which is the
I mean,
name,
maybe
name,
you need to
address.
make sure that your DMS system, if this rule were adopted, had all this information.
Yeah, because what the investigators like to see, when they come to me is, Tony, if this guy has been issued 400 temporary tags, and I want to check them, if they're in sequential order, that really helps. But nothing says they're supposed to be in sequential order. So we've got Jason downstairs, Jason Gillum, when they sent it in, and he does a great job. He goes through that thing and tries to find the tags that he can't find. And really, the reason why we do this, and he's so aggressive, because if dealers know that we're not checking, and they can just kind of have this mess in front of us that we'll just throw it to the side and not do it, then that's their out from having to actually write these things down, and they can make mistakes or just intentionally go around the system. So, but yes, we can check it. I can look to see if that complies with the DMS. And
with that, let us know.
yes, and I may have to ask one of you all for some
That's fine.
information about what is in a DMS and whatnot.
I'll be happy to help if you just email me.
okay.
I'll be happy to help with that.
But I think it would be really helpful for investigators, so when they go out there, they can do that. We can kind of put this one to the side, because I think they deserve it for that. The next one is certificates of title, and I think that would probably be the last one I'd like to. That would be priority for today.
Okay.
Unless you all want to go on, go further, I'm definitely willing to do that. But certificates of title. So currently our statute indicates that the type of business records you're supposed to have are all your deal acquisition files, and you're supposed to have proof of ownership of a vehicle, of every vehicle on your lot. Proof of ownership. It doesn't say you have to have a certificate of title. It's just proof of ownership. And when we amended that rule a couple years ago, the reason we had more aggressive language in there, but what came up was you have vehicles that are floor planned, and you don't have the certificate of title of that vehicle. It's sitting at the floor plan, and you have a list. Well, that list was sufficient to show that you had ownership of that vehicle. We also have something in there on consignment sales, so that you have proof of consignment. That also covers you. So we indicated proof of ownership. Well, what's come up with certificate of titles is, and I don't have much of an opinion one way or the other. I'm bringing it up because it becomes an issue with our investigators. Is that you will have one dealership, like I said, we talked earlier about you have multiple dealerships under different entity names. Say you have Jones Autos 1, Jones Autos 2, Jones Autos 3, Jones Autos 4. Every one of them have a different dealership number. One of them has one owner, one person, individual is actually the majority owner. Well, they'll take a trade-in at Jones Auto 1, and they'll put it on Jones Auto 3 lot, and they have the certificate of title. What they haven't done on the back of the certificate of title is they didn't have the person who traded in sign the back of it, nor did the dealership take ownership. They've got an affidavit. They have a power of attorney to allow them to go ahead and reassign it at any point in time. I don't fear that this dealer is going to sell it on an open title. I really don't fear that that's going to happen on this type of dealer out here. But what he's doing is he's getting it at one car lot, and then he's selling it on a separate one. It comes in at Jones Auto 1, gets sold on Jones Auto 3. And what ends up happening is when they finally sell it, it goes from the previous owner to Jones Auto 3 down to the person who just purchased it. Well, the acquisition file is actually over at Jones Auto 1, because that's the dealership that actually had it. And Jones Auto 1, in all legal reality, has nothing to do with Jones Auto 3, other than it has one common owner. But because they all say Jones Auto on the dealership, the only thing they put on the back of the title is Jones Auto. And we've had investigators who have the hardest time trying to verify this vehicle that's on your lot is actually owned by this dealer, because where's your acquisition file? Where did you buy this vehicle from? Well, we got it in a trade-in on that lot over there, and we keep all our records at that lot. Well, it's really about trying to make sure that, well, and here's the other issue we come up with, is that the person over here, say they have an issue with registration or something about that. If they file in on the surety bond of Jones Auto 3, because that's the one who sold them the vehicle actually came in under Jones Auto 1. So sometimes they have issues with the surety bond company is going back and having difficulty determining who's the actually buying entity, who is the selling entity here. Whereas in what we think should happen is that Jones Auto 1 should endorse the certificate of title in their name. And if they want to put it on Jones Auto 3, then just transfer it over to Jones Auto 3 and sell it at a Jones Auto 3. Because what we have is a lot of dealerships who are just keeping the certificate of title and no one signed the back of it whatsoever until they sell it. Did I confuse you?
We're going to be going to Mr. Murray's store.
Can I say something, Tony? I understand what you're saying. But being a dealer, if I'm at Jones Auto 1 and I put it on my Jones Auto 3 lot and he doesn't sell it, he now has ownership of it. He's had to write me a check. We got to buy it back from him. If it's a Jones Auto 1, it came in at Jones Auto 1, I want to put it on Jones Auto 3's lot, I just do a consignment affidavit saying that I'm purchasing this from them. I haven't paid for it yet, but it's just no different if I do a consignment from an individual or another dealer. At least you have a traceability. But I could see with franchise dealers that have multiple lots maybe close to each other wanting to move their inventory around, they're not going to want to write checks and do a wholesale deal. And in the real world, where you're coming from, that looks like that's how it should happen because it's a paper trail, and you want that paper trail to exist.
We do want
but I
a
think
paper
with
trail.
the consignment form from dealer to dealer, your paper trail would still be there. You agree, Bob?
Well, I do agree. Of course, there's nothing in the statute that mentions other than you can receive consignments. There's nothing that says you have a consignment form.
Right.
Now,
We don't have
the best practice is you do have one,
We have them in our DMS.
but maybe that's an alternative we can look at and discuss with you, Tony.
Okay. Because right now there's just absolutely nothing. I mean, there's a dealership who, Jones Auto 3 has got this car. Their certificate of title is in the name of the previous owner. They haven't even had the previous owner sign it and release it to them and put their own name in that, into that dealership yet. And then they don't have the acquisition file because it's sitting at another dealership. So he's got a car on his lot, and he doesn't have a power of attorney on it. He's got the title, but it's not even signed by the previous owner. He has no proof of ownership of this vehicle, though he has the certificate of title. And they think that that's not an issue. You can just go over to that other lot. That means our investigator has to go all the way back over to the other lot and get that documentation when we thought it should have been retained at this dealership right here. I mean, how difficult would it have been for them to sign the back of the certificate of title?
Remembering another aspect of the discussion back when we did last rules revision, and that was he had 15 or more dealerships in Middle Tennessee and sold them to another entity. I'll just leave it at that. Under all the new federal privacy laws, the USA Patriot Act, and all that sort of thing, he wanted to keep control of this non-public personal information that's contained titles and other things. And so they made a strong push to be able to hold all their customer-sensitive data in a central location under the controls that they had put in their organization, and then wanted to be able to parse them out as the transactions were completed at one of their multiple franchise locations. And so I'm not sure whether that is still a valid then we want that document there. I mean, I just think that's a discussion that ought to take place.
I mean, that was really what came up with the investigators. They said, hey, they called me. Hey, they've got a car on the lot. They got a certificate of title. It hasn't been endorsed by anybody. It hasn't been signed by the owner, so it's not an open title. Where you just have the person on the title sign it. It's not an open title. They literally have a title that they can't show how they got the title, how they got the vehicle.
It can, just not at that store, right?
Well, they say you have to go to that store,
Well, because
or
that
you
is
have to
something
get
we
the
discussed last
documentation.
time was common ownership, because I'll use my uncle as an example. They have a Nissan and Honda store, they're next to each other. They have a central office that handles deals, money, and, customer sensitive, their information, so they have it all behind, locked doors. But they don't have two separate ones, they have it all together. So I don't know if that's something that comes into play here or not. Because technically, I guess, I don't know for a fact, but he could have information for the two separate stores. But devil's advocate on that deal.
Yeah, and I agree. Our current rule, the way it is, it allows for all of those business records to be stored at one central location. It can be done. That was specifically for that reason, is that you can have them all so that you can have it in one location or whatnot. But that's separate from the proof of ownership, is that even though you can have all your business records at one location, you have to have proof of ownership of every vehicle that you have. This is one of those issues that comes up that
If the lots are attached. The lots are attached. I'm not saying, go 6 miles down the road and,
Immortal words of Roberto Duran, no mas.
yeah. Well, if that's it, I guess I can conclude with that.
What?
I can conclude with that, and then if you have any more questions.
You want to keep talking?
Thank you.
Thank you all very much. So is there anything that we need to do, make a motion to do anything or adjourn? I make a motion that we adjourn. Yay. All in favor? Aye. Great. All those opposed can leave.